responsive. We have given notice, my lord. It is on a private land, my lord, and we are going to use speakers, my lord. If it could be taken up today, my lord, it could. But your lordship's orders are also there. My lord, if your lordship can take it up today.
Take it up at 1 o'clock. The other matter is also fixed today, my lord, at 1, my lord. We'll serve notice, my lord. Kindly grant us leave, my lord, and take it up at 1.
You granted tomorrow at 1.
Tomorrow at 1 p.m. Tomorrow today at 1.
You grant not tomorrow. Come
Tomorrow.
Happy to mention, my lord,
this is tomorrow as urgent motion.
my lord, may I permit to mention the petitioner belongs to the EWS category.
Yes.
My lord, may I permit?
I'm sorry. I'm sorry.
My lord, may I permit to mention the petitioner belongs to the EWS category, but wrongfully treated as a general. There is an extreme urgency, my lord, because the selection process comes to the end only this month only, and if the process complete, the petitioner comes to difficulty.
When you applied for? When you applied for?
My lord, it's a matter of upgradation, my lord.
No. When you applied for the EWS category?
My lord, 2023, my lord.
23. When the recruitment, admission process is started or recruitment process was started?
My lord, 2023, my lord.
Then you have waited till last date.
No, my lord.
Sure.
My lord, it's a matter of new motion, my lord.
Huh?
Kindly take it, my lord.
What is the urgency?
My lord, my lord,
What is the urgency? Because only 2 days remain here. If all men will be taken as urgent matter, it will be difficult.
my lord, the selection process will be in on the December only, my lord.
Correct, I am telling when the selection process was started and when you applied for. When you applied, you have applied under the EWS or general?
My
When you applied, in which category you applied for?
my lord, the EWS category, my lord.
EWS, you had a certificate of the EWS?
Yes, my
So
lord.
now what is the problem?
My lord, the respondent authority,
Get ready, come.
পরে কালকে মেনশন ভালো করে পয়েন্টগুলো পরে কালকে মেনশন
May I be permitted to mention one matter, my lord? My lord, this matter was relating to that minor son who was treated. This matter is related to that minor son, which has been tremendously tortured by his mother. My lord, your lordship in the last occasion was pleased to direct that you direct the district judge to take up the matter or to transfer the matter.
I pass an order. You are given a liberty to make appropriate application before the additional.
yes, my lord, but
Correct.
that has not been reflected in the order, my lord. That has not been reflected in the
Can you see
order.
the last line? The petition is liberty to file appropriate application before the district additional district judge fast track court. It is not there.
My lord,
I am having the total
my lord,
what I have dictated and
photographic memory.
can you see the last?
My lord, here it is written, however, the dismissal of the writ petition will not prevent the petitioner from taking appropriate steps in the guardianship case pending before the learned additional district judge.
Then what further remains? If filed, if the district judge is not taking, then you come, we'll see to that.
All right, my lord. Madam,
May I have your lordship's kind leave, my lord? My lord, this is directed against the Election Commission of India. The urgency has arisen, my lord, yesterday upon publication of the draft my lord, electoral roll for 2026. And the petitioner, exercising his right of adult suffrage, had made a representation. This is pertaining to the SIR, my lord, the Special Intensive Revision. The Honorable Division Bench of the High Court at Calcutta, they had, my lord, struck down the classification in respect of OBCs, my lord, from 2011 till 2024, my lord. It was directed ultra vires, my lord, the provisions of the state legislation, and that apart, my lord, the certificates were struck down. My lord, we had made a representation to the ECI stating that the SIR should not take into consideration these certificates, the OBC certificates, in terms of, my lord, the order passed by the Honorable Division Bench. The order has not been stayed, my lord, even, my lord, by the Honorable Apex Court, my lord. Now we find, my lord, yesterday upon publication of the draft electoral roll, my lord, there is no rider or nothing to that extent, my lord, stating that no, these OBC certificates will not be taken into consideration. As a consequence, my lord, now the final list will be published, because now is the time for, my lord, giving objections, my lord. My lord, this gives rise to the urgency, my lord. My lord, I am fine.
What you want? What is the urgency?
My lord, direction upon the ECI to comply and not take into consideration the, my lord, the documents, the OBC certificates, which has already been struck down. Because one of the certificates, one of the documents, my lord, has an option, but persons whose names are not there, So the ECI says that you can submit also OBC certificates. We say that OBC certificates, please take, but do not take the certificates which have been struck down. This OBC A and OBC B, because a particular chunk from the Mohammedan community in West Bengal, now they were granted OBC status since 2011. Now that has been struck down. There is no existence of those certificates even, my lord. But the ECI, if it takes into consideration the very concept of free and fair election, my lord, that will be completely whittled down. Well, this is the urgency, my lord. It will not take more than, my lord, 5 minutes for my lord to adjudicate. If my lord kindly, my lord, take it up on, my lord, Monday, we'll file and serve it, my lord. The office is here, my lord, in Strand Road, the office of the ECI. Will effect physical service also, my lord.
Hello.
My lord, with your lord,
Hello. List on Monday.
my lord, with your lordship's
As
kind
urgent
leave.
motion.
My lord, with your lordship's kind leave. Yesterday, my lord, junior my lord had come to mention a matter. My lord, I'm seeking leave, my lord. The petitioner is a Bangladeshi national. My lord, he has served out his sentence under the Foreigners Act. My lord, after that, my lord, he has made a representation that now he is suffering a detention without any authority of law. Your lordship, my lord, had inquired what is the SOP, rather what has to be done. My lord, the Supreme Court has answered that. There's a Ministry of, my lord, Government of India's notification. If your lordship sees from paragraph number 16 to 19, well, the Supreme Court in the 6th of February 2025 has relied upon this ministry's circular, which says that it should be done within a span of 30 days. If your lordship will see the same issue. Now my 30-day period will expire on the 30th of December. Till now, no steps have been taken, my lord. I'm only beseeching a direction upon the government of India, my lord, that they act in terms of this circular which the Supreme Court has taken cognizance of. Lordship will kindly see from paragraph number 16 onwards. The entire issue is with regard to Bangladesh nationals who are suffering detention without after serving out the sentence. The competent authority within a span of 30 days has to ensure that they are deported or pushed back.
Okay, see. No, there is a time. You come, you file. I am giving. Let's
Leave.
see on the on 2nd January or 3rd.
My lord, only my lord, my 30th December, I have to go. The statute says that 30th December, 30 days I have to go back. My lord, if it can be, my lord, taken, I'm only beseeching your lordship. It will only, my lord, one direction upon the union to, my lord, act in terms of this judgment as well as the circular which they have issued.
Who are the party in your
My lord, FRRO, my lord, Union of India, as well as the jail superintendent. 3 persons are the parties, my lord. Yes, my lord, I have shown it. My lord, they are respondents number 2, 4, 5, and 6.
Government of West Bengal is not a party?
Yes, Government of West Bengal is party number 1.
Okay, hello. 23rd.
Deeply.
Huh? Come after me.
May I be permitted to mention? May I be permitted to mention one matter, Your Lordship? I'm praying for leave, Your Lordship. I'm for 2 badminton players, Your Lordship. I represent state of West Bengal and national level and state level. A suspension order was issued against me, Your Lordship. Thereafter, I approached this Honorable High Court. Your Lordship has passed an order that disciplinary proceedings has to be conducted. Thereafter, they have reopened the suspension order, Your Lordship, without conducting the disciplinary
No,
proceedings.
there was a direction that they will conduct the inquiry within certain period, and there is a kindly see my order. There is a direction.
Yes, yes.
They have undertaken.
They have not, Your Lordship. Now, Your Lordship, the urgency is that from 24th, Your Lordship, there is a national. Your Lordship would see the urgency, Your Lordship. Because of which I'm praying for leave, Your Lordship. Your
No,
Lordship.
this court has already passed an order. You can participate subject to outcome.
Yes,
of the-
we have no personal hearing was granted to us, Your
So
Lordship.
what has happened? What final order is passed?
Yes, Your
What
Lordship.
order is passed?
Suspended, Your Lordship, without giving us a formal opportunity to
You have
present us, Your
not
Lordship.
submitted your reply to the so-called notice.
We couldn't, Your Lordship. They have not given us an opportunity, Your Lordship.
I don't know. If I find wrong, then you will be trouble. You will be in trouble.
Very.
I remember what order I have passed.
Yes, Your Lordship. Yes, Your Lordship.
If this court will find that after the opportunity you have been suspended, then you will be put in
No
cost.
opportunity
You are
was granted, Your
mentioning
Lordship.
the urgent measure.
Yes, Your Lordship.
My lord, may I be kindly permitted
Wait.
to,
Allow करके 23 को रखो.
my lord, may I be kindly permitted to mention the matter? My lord, this is a very urgent matter. I have participated in 4 tenders, that is about 4 crores involvement. My tenders arbitrarily, illogically, violation the government rules have been technically rejected. And even I have complied all the parameters for all the 4 tenders as per the checklist. But others, the same, they have
When the tender was open.
tender is open last week.
Ah.
Now they have for technical bid cancelled. They have opened the financial bid and enter into reverse action now in the process of awarding the tender. If it is not immediate state, my lord, I will be suffered irreparable loss. My lord, this is raise the matter for early hearing immediately. Otherwise, they will award the contract to all.
List on 23rd.
Your Lordship, may I permit to mention one matter, Your Lordship, for inclusion in the list. Your Lordship, the same was appeared before the coordinate bridge on 19th 10 2025 and the
My lord,
WBCL were direct
it's urgently required before.
23rd, third one.
and
If
WBCL is
you want
direct
more urgent, then I will go to the 8th of January.
Sir. My lord.
and Your Lordship, the WBCL is directed to submit a report and the matter was supposed to listed 4 weeks after that. Your Lordship, the same was not
Okay,
appeared.
come after vacation. Come after vacation. I will take.
Your Lordship, the petitioner is 78 years
Okay,
old.
no problem. You mention in the reopening day, I will take it.
Challenging a notice for removal of alleged encroachment issued in may I only say 23rd December.
Call the list, call the list.
May I only say this notice has not been issued.
Nothing. Yes, call.
My lord, may kindly hear me, my lord. Online.
Madam, may I be permitted to mention, my lord, one matter?
No, sir.
My lord,
Okay, you
My lord, may kindly hear me, my lord. My lord,
The read is going to be come on today.
no problem. Come when the list.
may I only
Yes,
my lord,
call the.
this is not even in the list, my lord.
Call the matter.
may I be permitted to mention one matter, my lord? My lord, I just pray before your lord.
Who is appearing for
There's
the
a mentioning.
For state.
The impugn order is set aside. However, it is made clear that the respondents intend to take action against the petitioner. This order will not prevent the respondents for taking appropriate action against the petitioner in accordance with.
And may I now pray for a formal stay of the Millard
Record an order. Later,
under the other.
the learned counsel for the respondent prays for stay of the operation of the order. Learned counsel for the petitioner objected for the same. Accordingly, stay is refused. Next. Item number 2.
May it please your lordship, my lord, this is for correction, my lord, some inadvertent typographical errors of prepared.
Yes.
My lord,
The correction.
my lord, in paragraph number 2, my lord,
Huh?
in paragraph number 2, my lord,
Ah.
it would be the second line, my lord. The petitioner received an email, my lord. Email message in his registered email address. Instead of WhatsApp and mobile number, it should be substituted as email and registered email address.
You have submitted the mail.
No, my lord, page number 28, my lord. It
Page
was an
number?
email. 28, paragraph, page number 28, P3 annexure. It's email only, my lord.
28.
Yes, my lord.
Yes.
And my lord, the next one in page number 4, my lord. Paragraph number 13, 1. My lord, the penultimate line. My lord, it would be a week from the date of this order, as your lordship had pronounced. Not.
Which number?
My lord, 4. Paragraph number 13, 1. My lord, the penultimate line. Karnataka within a week from date of receipt of this order. Instead of receipt, it would be date of this order, as your lordship had pronounced in.
Receipt, because the authority is not there. That's why I pass an order.
And my lord, another one is 6. It would be 6,700. The next page, my lord. Instead of 67,000.
67,000.
My lord, that will be 6,700.
The matrix list is to be mentioned for correction in the order dated 2/12/2025. Counsel for the petition submit that in the order dated 2nd December 2025 at paragraph 2, line number 2, the word WhatsApp message is to be deleted and is to be read as email.
Yes, my lord.
Is to be read as email.
And the registered email address, the next line, my lord.
Email line.
Instead of mobile number.
No. In paragraph 2, line number 2 and 3, the word was WhatsApp message in the registered mobile is to be deleted and it is to be read as email in the registered
Email address, my lord.
email address. Okay? Email address. We further submit that 6,700, that one.
My lord.
Three.
Page number 5.
We further submit that in page number 5. In page number 5, Roman 3, the last line, the amount is to be read as 6,700 instead of 67,000. Ek zero बढ़ा दिया. In view of the submission made by the counsel for the petitioner in the order dated 2/12/2025, paragraph 2, line number 2 and 3, instead after the word received a inward comma email in its registered email address be read instead of WhatsApp message in its registered mobile number. Okay? And in page number 5, para Roman 3, the amount shall be read as 6,700 instead of 67.
I'm extremely
This
grateful.
order may be treated as part of the order dated 2/12/2025. Yes, next.
I appear for the petition. This matter is under
I am
non-prosecution.
for the mallet responding number.
There is a error in the cause title. There is a error in the cause title, typographical error. Respondent number 4. It would be Dattapukur Police Station. It has mistakenly written as Bashat Police Station. Yes, this
Why
is
it is to be mentioned?
for non-prosecution, Your Lordship. For non-prosecution.
Non-prosecution. You want to withdraw?
Yes, Your Lordship, because there is a error in the cause title.
Ah.
The respondent number 4 would be Dattapukur Police Station.
Ah.
It has typically it has written as Bashat Police Station. Kindly bring liberty to fresh a file on the same cause of
You
action.
correct that.
Then
No, my lord, the petitioner's address also will mention this. Two address mentioned. Petitioner's address also.
Petitioner's address.
Yes, my lord.
My lord, give liberty. I can
The
correct.
first title, he has stated Barasat in the my lord, paragraph number 2, Dattapukur. So, my lord, it's required to be so many correction.
My lord,
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. The counsel for the petitioner submitted that after going through the writ application, it is found that there are some technical defects which cannot be rectified by way of an amendment. Accordingly, he prays for withdrawal of the writ application with the liberty to file a fresh. In view of the submission made by the counsel for the petitioner, WPA 26308 of 2025 is dismissed as withdrawn with the liberty to file a fresh. Next.
My lord, I appear for the petitioner. My lord,
I'm for the DVC, my lord.
there is this is a restoration application along with an application for a my lord, condonation of delay.
Yes.
My lord, if your lordship takes up the restoration application,
Can 3. Can number?
can 3. The order is at can 4, na?
Can 4, 6 and 5.
Na, restoration double.
Can 3.
The order is at page 20, 20.
20 of the can 3.
Can 3. Can 4 is the condonation of delay.
Can 3, page 20.
20. This was dismissed on August 14, 2024.
21. Page 21.
Oh, I'm extremely sorry, my lord. In my petition, page is page 20.
P3 action.
Okay.
Yes, but it was in the warning list. In 2008,
Yes. My lord, I have
24, it was dismissed. They
My lord, I-
filed an application.
my lord, I have sought to explain that in my, if your lordship kindly goes through, my lord. In fact, it was in the warning list because, my lord, the affidavits were already exchanged. Then, my lord, kindly sees paragraphs 4 to 6, 4 to 7
Of the GA3.
of GA3, my lord, at page 13. Paragraphs 4 to 7, my lord, have sought to explain the reason for the non-appearance.
Yeah. So it was dismissed on August 2024.
Lordship.
And when you filed the application?
My lord, I filed this application, my lord, on 19th February.
19th
So
February.
there is a delay of 100 days.
Hmm.
My lord, that is CAN 4, my lord, I filed this application for condonation.
Where is your CAN 5? What is the reason shown? Nothing,
CAN 4.
no reason. Yes, can you come pay paragraph 2? Recently you came to know. Then
But I've seen that. I've seen that. I've seen that, my lord. My lord, it is not happily worded. But lordship will kindly consider, if your lordship takes the order in the main writ petition.
What is the matter?
Yes, that is what I kindly takes, my lord, page 18 of CAN 4, CAN 3. That is why, my lord, I am placing it. This kindly takes the main order that was passed. Page 18 of CAN 3. My lord, may I place it? And may I place it to your lordship?
Yes, no.
Very well.
So then what has happened now? Is after this order? This is of 2008 order. Then
Yes.
what has happened?
But after that, my lord, I don't think it has been heard. That is why, my lord, we have stated in CAN 3 that we, my lord, applied for assignment. If your lordship kindly sees paragraph 6 at page 13 of the same CAN.
2008.
Yes, my lord, kindly sees now paragraph 6. But I am a land loser. This is the position. My lord, hears it out, my lord. Kindly hears it out. Whatever happens, happens.
Is there anything remains in that
Yes.
application?
My learned friend is appearing on the other side. My lord, there is.
My lord, there are, my lord, substantial questions, sir.
Yes.
Well, only one thing I must indicate, my lord, with due respect to my senior friend, my lord, there is delay is more than 100 days. Because it has been dismissed on 14th of August.
He also did not appear.
The petitioner has filed the present application being CAN 3 of 2025, praying for recalling of the order dated 14th August 2024, wherein this court has dismissed the writ application along with the connected application for default on the ground that despite the matter was listed in the warning list, the petitioner failed to appear before the court. The petitioner has filed another application being CAN 4 of 2025 for condoning the delay of 100 days for preferring the instant CAN number 3 of 2025. Counsel for the petitioner submit that this is the matter of 2008 and this court has passed an order for exchange of affidavit. Affidavits have been exchanged, but in the meantime, several occasions due to change of determination, either the matter was listed in the either the matter was listed at the dawn in the cause list or Sometimes it has been not listed. Sometimes the matter has been assigned to some other. But in spite of effort taken by the petitioner, the matter could not be taken off hearing. All of a sudden, the matter was listed in the warning list, but the clerk of the petitioner could not be noted the same, and accordingly, the matter was placed in the main list. The learned advocate appearing for the petition could not appear before the court. Thus, the matter was dismissed. He submitted dismissal of the writ application also not known to the petitioner. And immediately when the petitioner came to know that the writ petition was dismissed, immediately the petitioner has filed the present application along with an application for February. Learned counsel for the respondent raised objection and submitted that the petitioner has not shown any cause why the petitioner has not filed, has not shown why the petitioner has not appeared before this court when the matter was called, and also petitioner failed to show any reason for not filing the present application within the prescribed period of time. Heard the learned counsel for the respective parties. This court find that the matter was filed in the year 2008 and substantial question of law is involved which is to be decided in the present application. The parties have already exchanged their affidavits. Thus, this court is of the view the matter is to be heard on merit. Accordingly, delay for filing of the application is condoned. Full list of order dated 20%. This court also find that the petitioner has shown sufficient cause for non-appearance of the petitioner when the matter was called. Accordingly, order dated 14th August 2024 is recalled. WPA number 22343 of 2008 is restored in its original file. This the matter as a specially fixed matter. Give the date in the month of January, specially fixed matter. जनवरी कौन सा 2 बजे कोई डेट है देखो. This is the writ petition for hearing as a specially fixed matter on 16 जनवरी. खाली है अपना डायरी देखो ना. खाली तो 2 बजे 16 January at 2 p.m. as a specially fixed matter.
My lord, may I make one submission? My lord, when your lordship was dictating the order, my lord, since I have appeared in this matter today for the first time, I was going through. My lord, I find that possibly the averment is not correct. It will be more than 100 days. Lordship has not. The lordship's order has gone down as 100 days.
More than 100 days कर दो ना, जामिया है ना.
My lord, one more thing, my lord, kindly record that we have, though formally opposed the prayer.
Yes, opposed.
Formally.
Of course, I already recorded.
Grateful.
But if I had not pointed this out, my lord, it would have been a mistake on my
I
part.
have recorded.
Grateful. Grateful.
I am deeply obliged to your lordship.
This court know with the difficulty of the persons who are appearing for the authorities.
I
I don't know why you have that side.
Absolutely.
For quite long time, your lordship knows also that fact.
Yes, next.
Deeply obliged.
Item number 552, appear for the respondent bank.
No, I am for the petition, my lord. This is an application for restoration.
Pertains to SARFAESI Act, my lord.
Matter application for restoration.
But you have challenged the SARFAESI proceeding. Without wasting the time of the court, my lord, I indicate before your lordship, my lord.
On the 1st of December 2022, the matter was dismissed for default.
So it is a matter SARFAESI. I am releasing it, mentioned before the appropriate court.
My lord.
This SARFAESI Act matter.
Yes.
So I am releasing it from the list of this court. You mentioned before the appropriate court.
No.
The petitioner has filed affidavit of service. Let the same copy the record. This court find that the matter is connected with the SARFAESI Act. Accordingly, this court is not having.
May I just indicate one thing? They have made party the United Bank of India as a point of now. It is amalgamated to the Punjab National Bank.
Accordingly, this court is not having the determination. Full stop. WPA number 2489 of 2016 along with connected applications. released from the list of this court with the liberty to the parties to mention before the having examination. Ungrateful, my lord. Next.
My lord, may I take back the affidavit of service filed before your lordship?
I recorded, filed and recorded. I already recorded, filed, kept in the record.
Okay, notice is what you have. Affidavit service.
Yes. The pairing. Item number 5. 6.
6 minute I beg to appeal.
Yes.
This is restoration of an application for addition of party. On that particular day, this is within time, that particular day, I was unwell, so I couldn't come. This is can 2.
Can 1 was dismissed for default.
Yes.
Yes. Why you are not appeared on that day?
My lord, I have stated in paragraph 3, my lord, I was unwell.
The petitioner has filed the present application, praying for recalling of the order dated 25/11/2025.
My lord, Mr. Devjit Mukherjee is on his legs before another court, praying for not today.
Has dismissed the can number 1 of 2025 of default on the ground that the learned counsel appearing for the neither the petitioner nor the learned counsel appearing for the petitioner have moved the matter. This court find that immediately after the dismissal of the application for default on 25/11/2025, immediately the petitioner has filed the present application on 27/11/2025. Right? And it is stated that due to illness of the learned advocate, the petitioner advocate on record, the advocate could not appear before this court when the matter is called. Considering the above, this court find that the petitioner has shown the sufficient cause for non-appearance of the petition before this court. Accordingly, order dated 25/11/2025 is recalled. Can number 1 of 2025 is restored in its original file. Next.
Your lordship, kindly to give a date so that
Can
I
2
can-
is disposed of.
My lord, may I make one other My lord, may I come back with the serving the copy of the can?
Huh?
Your lordship, kindly place the can 1 any day could be.
Come after vacation, I will take. Before
After vacation.
let the can along with the W and WP writ petition be placed under the heading urgent motion on 8th of January 20.
But after WBSC sale, man.
Yes.
Service to.
Lordship has adjourned it after vacation.
8th January. Which matter?
This matter only, I have no issues.
Yes, next.
Item number 7, I beg to appear on behalf.
The virus of the act, so it will take some time. So let them first complete all the substitution and addition.
My lord, I beg to appear on behalf of the petitioner. My lord, I seek leave of the honorable.
is appearing virtually for the
My lord,
petition.
I am seeking leave to appear virtually today due to some personal emergency. I could not be physically present, my lord. So I am seeking leave of the honorable court to appear virtually today.
Yes.
My lord, can 1 is an application for addition of party. My lord, here we have also filed a supplementary affidavit annexing the authorization in favor of the applicant, my lord. My lord, the authorization at page 4 will showcase that the petitioner or the applicant who has filed this application is authorized to maintain this application. My lord, can 1 has been filed on behalf of the West Bengal Legal Metrology Licensee Welfare Association. He is the General Secretary based in Hooghly. My lord, who are the similar sufferer who have the common cause of action as that of the writ petitioners, my lord.
Where is the can 1?
My lord, that we
How many can you have filed?
My lord,
Can
3
two,
can.
sir? Can
My lord,
3, sir?
my lord, can 1 is by the General Secretary of West Bengal Legal Metrology Licensee Welfare Association. My lord, can 2 is on behalf of the.
No, but can 1, where is the can 1? Can 1 is not in the file.
But the cause list shows that today can 1 is listed, my lord.
Dada, where is can 1? Can 1 na? Can 1 नहीं है? हाँ? नहीं आया. Can 1 is not on record, sir.
My lord, if my lord permits, can my colleague hand over a copy of Can 1 if my lord permits?
Yes, what is the Can 1?
My lord, Can 1 is on behalf of the
Addition of party.
Addition of party. My lord, kindly take note of paragraph 5. For the purpose of filing this Can 1 for addition of party is that this gentleman is the General Secretary of West Bengal Legal Metrology Licensee Welfare Association based in Hooghly, my lord. They are the licensees under the Legal Metrology Act. My lord, they have the common cause of action. So in order to avoid multiplicity of proceedings, my lord, this Can 1 has been filed on behalf of this association by the General Secretary, my lord, seeking addition of party.
Who is the applicant here?
My lord, the applicant is the General Secretary, my lord, of the association, as well as he also happens to be a licensee under the Legal Metrology Act, my lord.
Applicant is Samar Datta.
Samar Datta, my lord.
Secretary. Yes, who is appearing? You are appearing, Mr. Trivedi?
Yeah, Lordship, I am appearing for Union of India.
Yes.
And my lord, I may represent also respondent number 3 and 4.
Have you
So
gone
this
through?
has been challenged. They are challenging the virus.
Yeah, that is challenge, but Can 1.
As far as how if it is a common, because this needs to be decided in a common manner.
Absolutely.
I don't want to procrastinate it. They are wanting with the same grievances. Because my lord, what they are saying is that this particular gentleman is also having the same grievance. My lord, as far as that is the only paragraph which says that he has the same grievances. That is the only reason. My lord, kindly takes up paragraph 5.
Yes.
And 4-5. This is
6 also.
Now, other verification whether he is the
Who are the petitioners? They are the association.
My lord, the petitioners are the members of the office holders of the Legal Metrology Licensee Welfare Association based in Kolkata, my lord. My lord, can see from the cost title, my lord, they are the office holders of the Eastern Regional Legal Metrology Licensee Welfare Association.
Correct. And the applicant
he is based in Hooghly, and this association name is West Bengal Legal Metrology Licensee Welfare Association.
So is the another welfare association?
Another welfare association, my lord. They are also all the members of these associations, including the petitioner and this applicant, are the licensee under the Legal Metrology Act. My lord, they are the
Okay, but what about the Can 2?
My lord, Can 2 is an application where we are seeking. My lord.
Yes, what is the Can 2?
My lord, Can 2 is an application. My lord, Can 2 was heard lastly on 3rd December when my lord passed the direction upon our leave that to bring on record that the two individuals, my lord, substitution and addition of 2 individuals. The petitioner number 1 has resigned, my lord. In the main writ petition, the petitioner number 1 has resigned and the petitioner number 3 has expired. Under such circumstances, my lord was kind enough to grant us that leave to bring on record necessary documents with regard to the accept of addition of these 2 individuals who have come through Can 2 as a party.
Yes.
My
What is the Can 3 now?
Can 3, we have, my lord, our new legislation, our new rule has come forward, my lord. We have challenged that new rules, but that is subject to, my lord, the main, if the ultimate which we have challenged Legal Metrology Rules 2013, if after consideration of everything that is set aside, everything as a consequence, my lord, will go. So, my lord, today we are praying for Can 1 and 2. My lord, can keep this matter in January. We will be and subject to.
Have you filed a supplementary affidavit?
Yes.
Where
Yes,
is that?
absolutely. My lord, my colleague is there, my lord. She is going to. We have also served. My lord, kindly first take note of page 6 is the order of my lord.
Now, where is the resolution supplementary
My
affidavit?
page 7, my lord, kindly take note of page 7. My lord, I apologize. This is in the vernacular language. My lord, the date is 20th April 2025. Page 7 is the AGM 2025. My lord has got that?
Yes.
My lord, now I will directly take note. I will directly draw my lord's attention to page 10. My lord, at the bottom, may I just read my lord? At the bottom, page 10.
Yes.
সভাপতি প্রস্তাব দেন পুরনো কমিটি ভেঙে নতুন কমিটি গঠন করার প্রস্তাব দিলেন সিদ্ধান্ত সকল উপস্থিত সদস্যদের মতামতের ভিত্তিতে এবং সর্বসম্মতি ক্রমে নতুন কমিটি তৈরি হলো এই কমিটির বিবরণ হলো নিম্নলিখিত প্রেসিডেন্ট সুপ্রিয় ঘোষ ভাইস প্রেসিডেন্ট উৎপল রায় মাই লর্ড কাইন্ডলি মার্ক দি উৎপল রায় because he is the applicant number 1 my lord thereafter kindly
I cannot mark anything in this resolution.
No, my lord. That is for my lord, because these are to the applicants. That's
File
why.
the supplementary, you could have filed the translated copy.
My lord, we tried, but the time was very short. My lord, I am too.
At the time, the order was passed when the order was
3rd
passed.
December. Thereafter, my lord.
3rd December. Now today we are on 17 December.
17 December, my lord.
14 days you cannot you're not able to translate the one page of the resolution and file the supplementary affidavit. Yes, anything.
Well, my lord, as far as that resolution is concerned, my lord, 1 and 2 is concerned, my lord, one a person who is wanting to join, my lord, I don't want to stand in the way because if it is the same subject matter, I don't want that multiplicity of proceeding. Another writ petition will come before my lord only, and that will unnecessarily. And my lord, as far as the addition of parties concerned, it's a formal, my lord, I will not stand in the way.
But the other association who wanted to add as per the can 2, so you have to pay the court fee.
My lord, we will. My lord, yes. No, no issues, no issue. My lord, we have already, my lord, that is absolutely not an issue. As directed by my lord, we will comply with the same.
The petitioner has filed an application being can 1 of...
May I take my lord's leave?
Yes.
I'm very sorry.
1 of 2025, praying for allowing the applicant to be as writ petitioner number 5 in WPA 6796 of 2022. The counsel for the applicant submit that the applicant is the member of association based in Hooghly, and the present writ petitioners have a common grievances and the cause of action that is to be declared that the legal metrology within bracket government approved test center bracket close 2013 the guidelines dated 8th October 2013 the legal metrology within bracket government approved test center amendment rules 2016 and the legal metrology within bracket general amendment rule 2021 are ultra virus to the provisions of the legal metrology act 2009 and as such the applicant is also having the same grievances wanted to join as a writ petitioner in the present writ application. Consider the submission made by the counsel for the petitioner perused the application. This court find that the applicant is having the common grievance to that of the original writ petitioners, and if the petitioner has been added as writ petition number 5, none of the party will be prejudiced. Accordingly, can number 1 of 2025 is allowed by impleading the applicant, namely Samar Datta, General Secretary of West Bengal Legal Metrology Licenses Welfare Association Hooghly as petition number 5. As the applicant has been added as the respondent writ petition number 5 and is having the common grievances, thus the added writ petitioner is required to file the further court fee. Accordingly, the petition is directed to take appropriate step by adding And accordingly, petition is directed to take appropriate step for adding the applicant as the risk petitioner number 5 within a period of 1 week.
My lord.
Within a
Lord.
period of 1 week. And after the adding the applicant as the writ petitioner, comma, the amended writ petition be served to all the respondents and also to file the further court fee in the present within 2 weeks thereafter.
My lord, may I seek one indulgence?
Yes.
My lord, can I serve upon the learned advocate representing the parties the copy of the writ?
I don't know sir, whether all the respondents are appearing representing.
My lord, I will serve.
10 number Swences disposed of. Okay. The petitioner also filed an application being Can 2 of 2025, praying for deletion of the name of the writ petition number 1, Deepak H. Writ petition, deletion of the name of Mr. Supriyo Ghosh being the writ petition number 1 and Mr. Deepak H. being the writ petition number 3 on the ground that they have resigned.
My lord, Supriyo Ghosh has resigned. My lord, will find that at page 13 of the application.
On the ground that the Supriyo Ghosh has been resigned from the post of president of the Eastern Regional Legal Meteorological Licensed Welfare Association.
And my lord, petitioner number 3, Deepak H, has unfortunately expired on August 18, 2000.
Number 2, petition number 3, Deepak H, being the secretary of the said association, died on 18th of August 2025.
My lord, joint secretary.
Joint secretary?
Joint secretary. One of the joint secretaries.
Here it, one of the joint secretary. Joint secretary died on 18th August 2025. The petitioner has also filed a supplementary affidavit showing that the association has taken a resolution for appointing. Who will add? For
My lord, the
Utpal Roy.
Utpal Roy, who is the vice president,
as vice president of the association, and
Shorit Kumar Saha, who is one of the joint secretary.
And Mr.
Shorit Kumar Saha.
Sarit Kumar Saha, being the joint secretary of the said association. Concerning a submission made by the council for the parties, peruse the materials on report and the supplementary affidavit, this could find that the petition number 1 has already resigned, which has also been approved by the association, and the petition number 3 has passed away. Accordingly, their name is deleted from the cause title of the writ petition number 6796 of 2022, and the name of Utpal Roy being the vice president and Mr. Sarit Kumar Saha being the joint secretary has been added as petition number 1 and petition number 3 in place of Supriyo Ghosh and Deepak H. The petition is directed to correct the cause title within a period of 1 week and to serve the amended copy of the writ application to the respondents within a week thereafter.
I'm grateful, man. I'm grateful. My lord, the writ petition date be, if my lord's diary permits, a date can be fixed.
First you serve the notice. Let what affidavit completed?
No, my lord. It's absolutely a new motion.
Let the writ petition along with Can 3 be placed before this court on 9th of January 2020.
I'm extremely grateful, man. I'm extremely grateful.
Motion kori. Next.
Item number 8, I am for the petitioner, my lord. This is an restoration application. The
where is the order?
Order is annexed in
July.
number 6.
July 20.
1st July.
Huh?
1st July.
1st July 25.
Yes, my lord.
Yes. Why you are not appeared?
My lord, I am engaged in some other court, my lord.
You are engaged in some other court. So why you have filed the application before this court? This writ petition could be taken to the other court.
No, my lord, I filed within time, my lord.
Correct.
Yes,
No
then
time.
after
But
the
if you are not able to appear before the court, why you are filing the cases? One person, one day, one matter, one in one court. Make that policy so that the matter cannot be dismissed. One person, one writ petition, one day in one court. Because one person cannot appear in other courts. So one person, one writ petition, one day, one court. Take note of it and do this. So in future you will not be with the order of the dismissal of the writ petition. And you cannot take this ground. What is the writ petition for?
For I have filed an RTI application. Thereafter, I have filed also appeal, my lord. But they did not reply the same, my lord. For
Who is
this,
for the respondents? I will serve the notice.
Yes, my lord. For
When you
stay,
file the this RTI application?
my lord.
17th October 2023.
Yes, my lord.
So then what has happened? They are not considered.
No, my lord.
You filed the appeal also. Appeal is also not considered.
No,
So that's why you filed the writ application.
my lord.
Who is for the respondent?
State will be the respondent, my lord.
Record and order. The petitioner has filed the present writ application being Can 1 of 2025, praying for recalling of the order dated 1st July 2025, wherein this court has dismissed the writ application for default on the ground of non-appearance of the parties, non-appearance of the petitioner when the matter was called. Okay. Full stop. Counsel for the petitioner submit that the petitioner was arguing the matter in other court, due to which the petitioner could not appear before this court on call. According, the writ petition was dismissed. Immediately when the petitioner came to know the writ petition is dismissed on 1st of July 2025, on 10th of July 2025, the petitioner has filed the present application for recalling of the order. At the land counsel for the petitioner, this court finds that the petitioner has shown the sufficient cause for non-appearance of the petitioner when the matter is called. According, the order dated 1st of July 2025 is recalled. WPA 20678 of 2024 restored in its original position. Can number so and so disposed of. Okay. The writ petition is also taken off hearing. The grievance of the petitioner before this in the writ petition that on 17th of October 2023, the petitioner has made an application under Right to Information Act to the State Public Information Officer seeking some information. Full stop. In spite of receipt of the said application, the State Public Information Officer has not neither supplied the information to the petitioner nor has rejected the same. Accordingly, the petitioner has made an appeal before the appellate authority on 9th of April 2024, but even the appellate authority has not considered the appeal filed by the petitioner. Accordingly, the petitioner has filed the present writ application. Considering the above, this court find that no purpose should be served by keeping the writ petition pending. Accordingly, writ petition is disposed of by directing the respondent number 4, that is State Public Information Officer from a Public Service Commission from a West Bengal.
Respondent number 2.
4.
How
the
the
2?
State Public Information Officer.
4.
Yes, and department is 2, my lord. The secretary.
4.
4 is yes, my lord.
To dispose of, to consider the application filed by the petitioner on 17th October 2023 and to dispose of the same within a period of 4 weeks from the date of receipt of this order.
My lord had directed to communicate the order.
WP is disposed of.
Great. Then after that.
Next.
12, my lord, I appear for the petition. I appear on behalf of the CAC in this matter. Private respondent. Lord, I am the occupier / tenant in respect of this premises. My lord, I believe all are represented, my lord. But my connection got disconnected on 10th of this month, my lord. Lord, thereafter, I made a representation on the very next day.
Disconnected.
Lord, that is for the CSC to answer, my lord, because
You paid
Lord,
the electrical and
paid
charge?
bills till November, my lord. That is here, my lord, before the read court, my lord. Kindly takes, my lord, page 19 onwards, 19 to 28, your lordship will find.
Success payment.
Yes, my lord, till November. December due date was on 12th. Prior to that, my lord, my connection was disconnected. Lord, there is no allegation of theft or pilferage.
No.
So, my lord, it is for the authorities to, my lord, answer. But there is, my lord, an existing landlord-tenant dispute.
Manor, on 9th of December 25, Manor, we received a letter from the private respondent being the consumer for voluntary disconnection of the meter. In view of the manner, we disconnected the meter on 10/12/2025. Subsequently, on 11th, my lord, the petitioner herein wrote to us that there is an illegal disconnection. And on 15th, my lord, they applied for new meter submission.
15 they applied.
Yes.
Where is the new application?
Well, that has been applied online, my lord. Because, my lord, this is
My
not
lord,
a matter.
subsequent to that, my lord, we have
The
inspected and we
76
have found that from an amount of rupees 20,369 is due on behalf of the earlier consumer. But if they pay, my lord, we are ready.
Consumer.
Yes.
This meter connection which has been disconnected.
Yes, meter was disconnected on voluntary. My lord,
He has paid.
no, he has not paid.
Two things have been
He has not
suppressed.
paid.
I'll just indicate. Lord, because it's an equitable jurisdiction, I'll just indicate that. Lord, bills that have been disclosed at page 28 is the last bill. He has paid till September. October, November, now December also, before disconnection, he does not pay. He does not pay because he writes, and these are the green bills which got issued. He does not pay and he suppresses why he doesn't pay. I have those documents. You know. He writes to me saying, I am relocating. I'm giving up the flat. I will finally hand over possession in February. I don't want to be here. And thereafter, I have those emails. Thereafter, he stops paying. So because he's not paying and he's not there, so I naturally go and send it.
You are appearing for?
For the private respondent. Those emails also is suppressed here. The fact that he hasn't paid the electricity bills, that also is suppressed.
That is a different aspect altogether.
Kindly come.
Preston, I am dismissing here in note.
Kindly come to 13.
There's no question of suppression, my lord.
Manor, kindly come.
It's a landlord-tenant dispute, my lord.
I will come to you.
Manor, kindly come to clause 13.9 of regulation 46. And why we are asking for the payment, Manor? Now it has come up, Manor. There we have issued the green bills, Manor. They have not paid. Regulation 46, clause 13.9.
Which regulation?
Manor, this is
regulation.
31st May 2010. Regulation 46. Manor, may I hand over my copy, Manor? It will be easier for your lordship. Only thing it is a big mark. 13.9 take to the
Yes.
The last clause 13.9.
Accept supply of the license intending on shall be required to pay. Yes. Does the license is service and
This is the reason we are asking for the payment. And if
you do one thing, you file a short report. Come up after month.
Let it be also reconnected because for 6 days, my lord, without connection, my lord, 76-year-old man, he's about to die. But I'll tell your lordship, if that is the case, well, I'll fight it out. Without prejudice, well, I'll put in the 20,000. Without prejudice, it will be kept.
Point, my lord, he suppresses all this.
No, there's no question of sub. Lord, if there is any bill which is unpaid, I'm ready to pay. I'm saying this. Lord, it's an electricity connection. Lord, my instructions are it is paid till November.
correct, sir. But if your client has not given a proper instructions to you.
But the question of relocation, my lord, there is a landlord-tenant dispute.
Correct.
So, my lord,
No,
there
no,
can.
no, that is different thing.
That's
That
right.
is different thing. Once you have made a representation to the landlord that there is a due and you will vacate the premises, then
No, not
that's
due, my
what
lord.
let the report come.
No.
If it is
I'll file a very short affidavit
let
on
the
that.
report come.
But in the meantime, let it be connected, my lord,
If
because
it is a suppression of fact, how you are?
that's no question of
the cake and eat it.
my lord, there is no question of suppression of fact, my lord.
Why you not disclose? And tomorrow,
Not para 13 my lord have
when you
disclosed.
see, when the yesterday the court was about to rise, your junior has shown the photograph and shown the my old age, my this, that.
No, that is a correct position.
Correct. So, but you have suppressed that.
But
I
20,000 is
last
not
court.
pending according to us because 20,000 is in respect of the other my lord owner.
This court find that
Sir,
there are
may I
some
take your
disputed
lordship
facts
leave? A matter has been
which
taken up.
has been suppressed by the petitioner.
Now, kindly do not record that it has
It
been
is present
suppressed
in
because my lord,
application
no
according
affidavit has been filed, my lord, to that
of view.
effect.
That's why this court is of the view that has to be dealt with only after calling for a short affidavit from the respondents from the CSC as well as the private respondent. That the short affidavit will file within a week. Reply, if any, there to be filed within a week. Thereafter, list the matter on.
No, there will be no connection for my lord.
8th of January.
Three weeks, my lord. How can a person survive, my lord?
January 2025 under the same heading.
But how can a person survive, my lord, as an interim measure?
Take back my regulation.
Right to life, my lord, Article 21.
Yes.
Lord, kindly appreciates that, my lord, that is interim measure. My lord, I am ready to pay, my lord, kindly appreciates that, my lord.
Yes.
Three weeks, my lord, a person can survive.
Regulation and copy. Regulation.
May I please your lordship? So it is this that matter, my lord, you will recall, my lord, where my bank account, my lord, has been debit freeze. And my lord, after hearing me, my lord, you passed an order directing respondent number 3 and 6, my lord, to appear, and lordship, my lord, directed the Registrar General to send them notice, and I was also directed, my lord. Accordingly, my lord, I have served notice. I filed my affidavit of service. Lordship will find, my lord, they have received it. Now, my lord, they have been directed to, my lord, file a report before this honorable court within 2 weeks. আমি জানি না জজ সাহেবের কাছে কোর্টের কাছে জমা
Yes. You are appearing for the bank 4 and 5. Is the ऑफिस से कोई रिपोर्ट आया? ऑफिस से रिपोर्ट आती थी तो गए ही नहीं होगा आरजी को भेजे थे ऑर्डर आरजी को भेजे थे कोर्ट ऑर्डर करता आप लोग फाइल भेजेंगे या नहीं
কোনো অনুবাদ না
Yes, what is the matter?
My lord, here, my lord, my bank account, my lord, has been debit freeze by way of a notice, my lord, dated 6 January 2025. That is at page 19, under section 19, my lord, under section 94 BNS. Now, my lord, in my most respectful submission, my lord, by the Itanagar police station, that is the respondent number 3. Now, my lord, 94, under 94, my lord, the police authorities or, my lord, the other authorities, they can, my lord, summon, my lord, for documents. My lord, 94 does not give them any power, my lord, under any stretch of imagination that they can debit freeze my bank account. Now, my lord, be that as it may, they have already done it. The bank account is under debit freeze. Now, my lord, if your lordship comes to, my lord, later, now, my lord, what happened, my lord? There, my lord, if your lordship kindly takes up page 19 once, may I, my lord, narrate the actual incident, what had actually happened? My lord, I am reading, my lord, once. This is to inform you that the above mentioned case was registered on complaint of Inspector such and such, CGSC and CS Itanagar Commissioner, stating that during the course of their investigation, credible information was received indicating that a firm by the name Siddhi Vinayak Trade Merchants has obtained the said GST by submitting fake rent agreement bearing a forged seal of JMFC documents. After obtaining the said GST ID, the fictitious firm raised fake invoices. Lordship will kindly mark here. They have already stated in their FIR notice that they have raised fake invoices amounting to rupees such and such. It's a huge amount. thereby defrauding the government exchequer of rupees 99.31 crores. So, my lord, FIR was against Siddhi Vinayak for, my lord, issuing fake invoices, thereby they have been sucking money from the market. Now, my lord, if your lordship kindly comes down for the purpose of investigation, you hereby directed through this notice to provide the following within 7 days from the receipt of this summons. One, CF of the following account numbers. The second one, my lord, lordship will kindly mark 502,000,125,2010. This is my bank. I'm only concerned with this account. Others, my lord, I'm not concerned. And now, my lord, if your lordship kindly comes to the penultimate part, you are further directed to debit freeze the above mentioned account. So accordingly, my lord, on the basis of this notice, my lord, the respondent bank, they, my lord, debit freeze my bank account. Now, my lord, if your lordship kindly comes thereafter, my lord, to page 25. Now, my lord, thereafter, apart from, my lord, Itanagar police station, they had also sent me summons. My lord, the fact remains, GST commissioner issued a notice to me. It's important, my lord, page 25. Then I came to learn the real incident. In an ongoing, has your lordship got it, my lord? In an ongoing investigation of Messrs. Siddhi Vinayak trade merchants undertaken by this office, it has been noticed that the said firm has passed the input tax credit to your firm amounting rupee such and such. Now, my lordship will kindly mark page 19. They have raised fake invoices. On the basis of this, my lord, on the basis of all these fake invoices, 2 invoices was in my name, and my lord, they transferred it to my GST portal. So, my lord, accordingly, I replied to this notice immediately, my lord, thereafter. If your lordship kindly comes to page 28. 28, my lord.
Yes.
I stated, my lord, that there has not been any transaction of any nature whatsoever with them. So, my the question of the invoices, my lord, doesn't arise. Because, my lord.
So what about the 1,83,000?
My lord, may I, my lord? Now, if your lordship kindly comes, my lord, to page 31, my lord. I had reversed that. I had already reversed that. In the GST portal, it goes back to that, my lord, the person who had sent it to me. Because it's in no way connected. Page 31, my lord. That is form GST DRC-03.
Yes.
Dated 6th of February 2025. Now, my lord, if your lordship kindly takes the amount, it is the same amount, 1,83,934. And my lordship will kindly mark the reasons. Reversal of the ITC, that is input tax credit, against 2 number of invoices from Siddhi Vinayak bearing GST number such and such.
Where from you are reading?
At the bottom, my lord.
Yes, yes.
Reason, my lord, that is 0.8. Yes. So, my lord, accordingly, even, my lord, I have reversed that. Now, my lord, the situation is, even I have, my lord, annexed the bank account details of my, which will go to, so, my lord, there has been no transaction of any nature with Siddhi Vinayak. Now, my lord, my lord, bank account has been debited. My lord, again, my lord, considering this situation, my lord, lordship will kindly recall on the last occasion, judgment brief my lord, I had, my lord, placed, my lord, one judgment of, my lord, Rajasthan High Court. Perhaps it's in the file, my lord, of your lordship, where, my lord, in such a situation, court, my lord, directing the bank to keep the amount in dispute freezed till the investigation, my lord, is over, and, my lord, allowed the party, my lord, to operate the bank.
The amount which has you are reverted, that has been deducted from your account, the amount is still in
my lord,
your
may I clarify, it did not come to, it was in the GST, my lord, GST account. Now, my lord, from there, I have reversed it to again to the GST account of that, my lord, delinquent party, that is Siddhi Vinayak. So, my lord, this is, my lord, I have instructions, and, my lord, I have annexed the document also. Now, my lord, so far as this judgment is concerned, my lord, case is a step further, my lord, because here I have already reversed that.
That's why I'm asking. You have stated that has been reverted.
Yes, my lord.
Whether that amount has come in your account at any
No, my lord, not in my account, in my GST account.
It is GST account.
My lord.
So it is the amount 1,83,000. It has never come to your account.
No, it GST portal.
That's why I'm asking.
Yes, my lord, it came to my GST portal.
Correct. So it is come to your GST portal.
Yes, my lord, and I have reversed that.
Reverse that, whether the reversal has been accepted or it
my
is
lord,
still in your portal.
My lord, that is, my lord, I've been told, my lord, that is what, if your lordship kindly comes to page 8, because this is the form, my lord, by which, my lord,
Fine, but
it's
subsequently whether that has been deleted from your portal or it is still.
my lord, it gets, my lord, automatically
Where-
once
where
I,
show?
my lord, that document paras I have, but this page 31 goes to show, my lord, that I have reversed it because it's a government document, my lord, from
Correct, you have
GST
lied.
DS.
It is a GST, but whether he obtained in your GST document, it shows that it is already been reversed.
Otherwise, this is not generated.
My lord, may I, my lord, I have instructions, my lord. If, my lord, I have not, my lord, reversed that ITC, my lord, then, my lord, this document will not generate. My lord, this, because this ARN number which provides, this is the number by which it was reversed. Because if I do not reverse, my lord, I will not able to get this document online. This document is proof of the fact, my lord, that I have reversed the amount because it comes from the government portal, my lord.
That's all.
This, my lord, these are mine. So, my lord, I was praying, my lord, even, my lord, considering that situation, my lord, because, my lord, I am starving, I cannot do my business. Though I am a step further from the judgment which I have produced before your lordship, that was I was praying, my lord. That is so, in order to prove my bona fide, I want to keep that 1,83,000 in my account. But the rest of the account, I may be, my lord, allowed to, my lord, operate because I have to run my business.
My lord, on the last occasion, as I reiterate that there are two, my lord, kind of comes to page number 20A and 26. These are the two notice they have received under section 35 of the BNSS.
Correct.
Now, as recorded, my lord, in the last order, the report is required from the IO. We have nothing to do with the amount. It has been, we are just following the instruction of the investigating agency. There is direct instruction to freeze the account. We have done that only. Now, if they have no objection in operating the account, we will leave the freeze. Nothing lies there. But so far, these notices are concerned.
Yes.
They are actually what I have read out in the section that a police may arrest without a warrant. I don't know what steps they have taken in respect with the notices, but
No, whether you have received any order of the court under 106 or 107 of the
no,
CM.
we have received a notice.
This notice,
Yeah,
whether
that
the
is a
police have forwarded any order, the court,
No,
any
no,
of
no,
the
no.
magistrate court or any
No,
of the
nothing,
special
nothing,
court
nothing.
has passed
As
an
of
order
as
for
of
freeze.
as of now, because police has the authority to freeze the account, but maybe that technicality the section should be 106 instead of 94.
No,
But
106, but then it has to go to the, it is the power of the magistrate to pass an
Absolutely, my lord, I bow down.
order. Without the order of the magistrate,
Yes.
even in.
in the purpose of investigation, 106 says that police can
Now
act
the,
upon.
now the division bench of the Bombay High Court has passed an order.
But yes, that should be routed
That
to the
it-
magistrate.
without the 106 compliance of the 106 and 107, the police authority cannot freeze and the bank cannot act on the.
We have not received any court order.
Okay. That's all.
Yes.
The petitioner has filed the present writ application praying for an order directing the respondent number 3 directing the. What is your prayer?
My lord.
See, respondent number 3 is to be directed to defreeze. Defreeze has been done by the by.
And respond number 4, my lord, because my bank account is with respond number 4, my lord, with Maniktala. Because, my lord,
Petitioner has filed the present application praying for a direction.
my lord, I have challenged, my lord, the notice, my lord, under section 94.
For defreeze.
And B, my lord, I am praying mandamus on respond number 4.
Petitioner. Lying with the HDFC Bank Maniktala branch being current account number 5020001252017. Consent of the petitioner submitted that. How you got the page number 19? How you got this order letter?
Well, it was communicated to me by my local bank.
Bank has freezed the account of the petitioner and when the petitioner has inquired the same, the bank has forwarded the letter dated 6th of January 2025, wherein the officer in charge PS Itanagar, Pampupare, Pampupare, Arunachal Pradesh, has directed the branch manager at HDFC Bank to debit freeze the account of the petitioner. And in terms of the direction of the officer in charge of PS Itanagar, the bank has freezed the account of the police. Counsel for the petitioner further submitted that on 13th of January 2025, the petitioner has received a notice, a communication from the Assistant Commissioner of GST and CX Itanagar, wherein it is stated that during the investigation of Mr. Siddhi Vinayak Trade Merchants, the office of the Assistant Commissioner noticed that the said firm has passed the input tax credit within bracket ITC in the account of the petitioner amounting to rupees 1,83,934.80. Counsel for the petition police staff. On receipt of the said application and said communication, the petitioner has immediately sent a reply to the Assistant Commissioner CGST, informing that the petitioner is no way connected with the Siddhi Vinayak trade merchant, and he has no transaction with the said firm. After sending the said reply to the CG and to the Assistant Commissioner, the petitioner has also reversed the amount of rupees 1,83,934 in the account of the Siddhi Vinayak merchants. Then a counsel for the petitioner submitted the petitioner is no way connected with Siddhi Vinayaka merchants, but the police authority of Itanagar without any authority directed the bank to freeze the account of the petitioner, due to which the petitioner is facing difficulties to run the account, as the account freezed by the bank is of current account of the petitioner. The petitioner has relied upon the judgment in the case of Mukesh versus State of Rajasthan, unreported judgment. Reported judgment in the case of Mukesh versus State of Rajasthan and others, passed by the Rajasthan High Court Jodhpur bench, and submit that in the said case, the Honorable Court has defreezed the account of the petitioner by keeping the disputed amount aside. He further submit that if this court will pass an order by keeping the said amount of which 1,83,909, counsel for the petitioner relying upon the said judgment placed before this court to pass an order for defreezing the account of the petitioner by keeping the amount of 1,83,934 aside. Police. Then a counsel for the HDFC Bank submit that the petitioner is having the current account, but the bank has received an instruction from the officer in charge of PS Itanagar with regard to investigation of the case against one Siddhi Vinayak Trade Merchants, wherein the petitioner is directed and wherein the bank has been directed to freeze the account of the petitioner, and accordingly on the instruction of the investigating agency, the bank has freezed the account. He further submit that the bank has not received any instruction from the investigating agency for defreeze the account of the petitioner, and thus it is not possible for the bank to defreeze the account of the petitioner. This could find that the bank has freezed the account of the petitioner on the instruction of the police officer in charge of PS Itanagar. the petitioner has made the police authorities as the respondent in the present case. On the earlier occasion, on 1st of December 2025, this court has taken the matter for hearing, but this court finds that the respondent number 3 and respondent number 6 have not appeared before this court. Accordingly, the petition is directed to issue a fresh notice upon the respondent number 3 and 6. In compliance with the order passed by this court, the petitioner has served a fresh notice upon the respondent number 3 and 6, but in spite of the service of notice, none appears on behalf of the respondent number 3 and 6. The affidavit of service filed by the petitioner is kept with the This court finds that the bank has freezed the account of the petitioner on the instruction of the officer in charge of the PS Itanagar. Subsequently, full stop. The said instruction was given by the said officer to the bank on 6th of January 20. Thereafter, the investigating officer has not communicated any and has not made any communication with the bank, due to which the bank has freezed the account of the petitioner. The petitioner and this court and the petitioner has issued the notice to the respondent number 3 and 6, but in spite of the receipt of the notice, the respondent number 3 and 6 failed to appear before this court. Neither the bank nor any of the respondents have come forward, have produced any order or document before this court that the investigating officer, that is the police in charge of the PS Itanagar, has obtained any order from any of the London magistrate either under section 106 or 107 for freezing of the account of the petitioner. Freezing of the account of the petitioner. In the case of so passed by the Honorable Division Bench of the High Court, it is categorically held that on de dega. It is categorically held that ... कर दीजिए, मैं बता दूंगा. Considering the full stop. In the judgment denied by the petitioner in the case of Mukesh and others, Mukesh, Supra, the single bench of the Rajasthan High Court has disposed of the writ petition by directing the respondent bank to defreeze the account of the petitioner by keeping aside the disputed amount. But this court finds that the Honorable Division Bench of the Bombay High Court has categorically held that unless and until an order is obtained by the investigating officer for freezing the account from the competent court during the investigation, the investigating only on the request of the investigating agency, the account cannot be freezed. But in the present case, also this court finds that none of the authorities have produced any order from any court that on the basis of which the investigating agency has passed an order. An investigating officer directed the bank to freeze the account. Considering the above, this court find that the communication find that the bank and the investigating officer without any order of the court has directed the bank to freeze the account of the petitioner, which is known as in the law. Accordingly, the petitioner is directed the bank, that is the respondent number.
My bank is respondent number 4. Respondent number 4.
4 is directed to defreeze the account of the petitioner and to allow the petitioner to operate the bank account.
Lordship has directed the bank to defreeze my account.
And allowed to operate the bank account.
And so far as that money is concerned,
I am not passing any order. Nobody is appearing before this court. The court will take the risk.
I'm grateful, extremely grateful.
This is my application, for the respondents. And this is akin to, your Lordship remembers the Hemant Kanoria matters, where they were declared fraud without service of the forensic report. I was on the receiving end of the other day. Today, my client has not been given that. So, I'm a bit covered. May I just point out, the first show.
I'd like to file short affidavit.
There is, may I just show?
The order. Let me see.
May I just point out,
Order is of September.
Please. Please.
My lord, kindly see, I'll just show 5 documents. My lord, first document, page 48. My lord, this is the first, my lord, if I may say, the fraud initiation, my lord, show cause notice. But on the basis of this, my lord, kindly sees page 51. This is my letter in response to that letter, my lord, where I say, my lord, inter alia, my lord, last sentence. Meanwhile, kindly share the forensic auditor report with us immediately. Then my lord will kindly see. Oh, I'm so sorry. My lord, 50. First page 48, then 51. That's the reply, my lord, in 2020.
Yes. This attempt to completely divert
Last sentence. And meanwhile, kindly share the forensic audit report with us immediately. Because, my lord, in that show cause they spoke about the forensic report. Now, my lord, kindly comes to page 52.
5 years, nothing happens. Yes.
Page 52. My lord, in 2025, my lord, they suddenly give a my lord, letter. My lord, kindly comes to page 53, paragraph 4. You are hereby informed that in order to ingrain principle of natural justice before classification of accounts as fraud, bank has withdrawn previous fraud declaration and reporting of fraud to RBI in the subject account. So they withdraw. The withdrawal of fraud declarations without prejudice of bank's right to re-examine the account for fraud angle after giving an opportunity of hearing as per bank's guidelines. Now, my lord, after this, what they do, my lord, they again initiate another show cause notice. But very interesting, my lord, kindly see page 54. This is the now the show cause notice, my lord. The present show cause notice under which the order was passed. This is 28th of April 2025. My lord will kindly go through para 3, my lord. My lord, they have given certain my lord, observations to which I was required to reply. But my lord will kindly see, nowhere in this show cause notice have they said that we are also taking the forensic report into account. They only refer that just in the middle of para 3, thereafter forensic audit was got conducted by the bank for the period. That's it. So, my lord, I gave a reply, which is at page 58.
What they have asked for? Reply.
They asked for a reply. I gave a reply. That is at page 58. And I pointed out that your observations are without any basis. Because, my lord, they were not relying on the forensic audit report. Because initially I had asked for them, they are withdrawn. Then, my lord, kindly comes to the last order. My lord, that is at page 61.
So sent to me at page 65 on second.
Sent to me on 10th September 2025, which will be at page 60, my lord, the covering letter. My lord, kindly comes to 61. In terms of RBI guidelines, dated 15 July, read with judgment dated signed on the Supreme Court, show cause notice dated 28th of April were issued based upon the findings of the forensic audit report dated 24th January 2020, mentioning the reasons, incidents of fraud based upon which the bank has perceived the account as fraud and opportunity to make a representation given the following parties. And then, my lord, they rely on this forensic report. I don't have a copy of the forensic report. So I have come up before your lordship that the show cause notice, strictly speaking, did not rely on the forensic report. Now they are relying on the forensic in the final order. The Supreme Court judgment is there, my lord. As a matter of fact, your lordship's order is also, my lord, I've got for your lordship, my lord. If your lordship kindly considers that without copy of the report, my lord, could they proceed against me? And last but not the least, my lord, I don't know what my lord is going to say, my lord. Kindly sees the guidelines. Oh, ठीक है क्यों डाक करता है क्यों? But 67 master's direction, my lord, kindly comes to 74. I just show one clause, my lord. 4.1.4. The bank, in case of sole lending, or the individual banks, in case of multiple banking arrangement or consortium lending, shall ensure that the principles of natural justice are strictly adhered to. So basically, my lord, every consortium member has to adhere to this natural justice, which, according to me and according to the judges and placing, my lord, includes, my lord, handing over the forensic audit.
My lord, the earlier show cause notice was withdrawn below. because by the time my lord, we had withdrawn, there was a ruling from the Supreme Court that opportunity of hearing has to be provided. We had issued a fresh notice to the my lord, borrowers. This was issued in the month of April. My lord, they had replied to the same. Not even once, my lord, in their reply, will see this defense that has been taken today by my learned friend. Thereafter, this report was classified as fraud in the month of September, my lord. Thereafter, we have reported it to the RBI as well as to the CBI. It has been acted upon by the departments. And now, my lord, all of a sudden, my lord, rushing to the court and praying for the interim order at this point of juncture, my lord, doesn't, my lord, justify, my lord, the matter which is there before your lordship. I was just seeking at the inception itself, my lord, kindly grant me 2 or 3 days time, not much. I will file a short report stating what I have complied. I have made compliances in terms of the master circular of the RBI, as well as I am supposed to follow my own guidelines in terms of the RBI circular, my lord. Both circulars are not there, my lord. Only one RBI circular is there, my lord. My master circular of PNB is not there on record, my lord. Kindly give me 2 or 3 days time. I'll satisfy your lordship that we have acted in terms of the law. And the ruling, my lord, of which my learned friend is talking about, my senior friend, is talking about is that of Rajesh Agarwal, in which, my lord, it has been briefly said the opportunity of hearing has to be, my lord, provided. My lord, they were, kindly see paragraph 16 once, my lord. They were aware that the forensic audit has been, my lord, initiated in their account. They have been silent to this account, my lord, today, as on today, they do not, my lord, as per my opinion.
No, you have only to prove whether the forensic report, because you are relied upon the forensic report.
We don't have to, my lord.
Whether the forensic report was forwarded to him and gotten. That is the only question. With regard to the personal hearing,
forensic
Supreme
audit.
Supreme Court has already held other.
But I have, my lord, I will justify, my lord. Rajesh Agarwal has said, my lord, and thereafter, my lord, a matter is pending before the Supreme Court recently, my lord, where the submissions are being made by the RBI as well as from the, my lord, government departments. But that is under sub judice. I will not speak on that, my lord. But as far as Rajesh Agarwal is, my lord, concerned, that is principally on a point of opportunity of being
That
heard.
is with regard to opportunity of hearing, whether personal hearing can be
In one of the
treated as a opportunity of hearing or
But
not.
to my correct understanding, my lord, in one of the paragraph, even if excerpts of the forensic audit, my lord, whatever the, my lord, fraud that we have found, my lord, if that is highlighted to the, my lord, respondents, there are several other matters also, my lord, pending before this honorable court, my lord. If that is, my lord, intimated, this is sufficient, my lord, for them to reply. And they have, my lord, today, my lord, come up, my lord, my lord, in my lord, humble submission, where there is no case for ad interim order as on the date. Kindly grant me leave to file short report, not reply.
When you will come with the report?
My lord will grant me 2-3 days time, because everything is on paper and paper.
Well, then I'll have to file a reply because I'm saying I have not received it. I'm saying that the Supreme Court order, as well as your lordship's order, and there's other orders.
His case, my lord, my learned senior friend's case, that he has not received it. Even this, my lord, even then, this proceeding is maintainable, my lord. My proceeding, since they have been intimated of the, my lord, angles, fraud angles on regarding to the transactions, those were highlighted to them in the show cause notice, my lord. Let me take instructions and come back and file report. 7 days time.
My lord, may I just place the judgments then, my lord, if your lordship can. Your lordship is aware, my lord.
But let he come.
Well, let them not take further steps from today till the date they file their opposition. Well, let them put it on record. Well, but from today, my lord, let them not take any steps, my lord. That is what I'm on, my lord.
So when 22nd?
As
my lord, instead a bit earlier, my lord, then, my lord, we can have the matter before the vacation. Although we'll proceed, my lord.
When 22nd?
My lord is keeping on 22nd. Yes, my lord.
Well, I have no difficulty.
No, let them file it beforehand so that I can also deal with it.
I will do that. I assure my learned senior friend that I'll do it.
Bank press for accommodation to file a short affidavit.
Report, my lord. Report in form of affidavit, my lord.
Short report by way of an affidavit. Let the report be filed by 22nd of December 2025. After serving the copy to learned counsel for the petition, list the matter on 22nd under the same heading.
But 22nd is Monday, my lord.
But the only problem is, I don't know what they're going to say.
23rd, my lord, in case if it may be, my lord.
And I would
23rd, I'll get the Monday, my lord, kindly. Otherwise, on 22nd, kindly keep it at 2 o'clock, my lord, I'll come back.
And only one thing, my lord, may I just make 2 submissions. But if they can, my lord, let them serve it by Saturday, my lord. Because I'll point out, my lord, I wouldn't be in a position to.
Monday, my lord, I'll utilize first half, my lord.
Okay, you go give the copy on Monday. Tuesday, you fix it.
Yes.
Well, it keeps on 23rd, my lord.
That is why I have taken time to for 23rd, my lord. Yes. 22nd.
On 23rd, file the report by 23rd, then. But advance copy may be served But advance copy may be served to the petitioner on 21st of December 2020.
My lord, in case my report sustains, my lord, then
2nd of December 2020.
my lord, only one submission. Lord. In case if my report sustains before your lordship, Lord, then kindly, my lord, I'll take leave to file reply to the, my lord, detailed reply to the affidavit.
That's only the
My
court
lord,
want to
I
see
shall
what
come
is
back.
But I am
Deeply
only submitting, my lord. If your lordship just puts in something that till that time, my lord.
2 days, nothing will happen.
My lord, the way he started off the matter, my lord, I'm quite skeptic about that, my lord, because saying the CBI is taking steps, everyone is taking steps, my lord.
My lord, in September, the order has been passed and
So what-
communicated. This
my
is
lord,
December, 3 months, my lord. Obliged.
Item number?
In this matter, I am appearing on behalf of the petitioner. Before opening the brief, I am praying my lord's kind leave to correct the cause title, putting the age of the petitioner 105 instead of 95 at page number 1, first page. It is a typographical mistake.
Who has affirmed the affidavit?
Shan has affirmed. Page to, first page, just age is about 95 years. It has been written instead of 105 years. What? I will carry with the leave of my lord. I will.
Okay, yes, what is the case? Let
The case is the petitioner was a freedom fighter who worked with the then chief minister of national government at Tamluk under the leadership of Ajay Mukherjee, Sushil Dhara, Satish Samante, etc. He was one of the soldiers of Vidyut Bahini of that independent Sarkar, Jatiyo Sarkar, Tamralipto Jatiyo Sarkar. After commencement of the scheme of 1980, that the Swatantrata Sainik Samman Pension Scheme 1980, my client applied to the government on 13th of August 1981 with the PKC and NARC. PKC is the personal knowledge certificate and NRC is the non-ability of record certificate issued by the then district magistrate of Midnapur, and PKC by one of the impanel certifier, the panel which has been prepared by the state government with consent of the central government. There was 4 or 5 persons in the panel. One of them, Mr. Giri, he has certified. I have annexed that. After the application, by an order dated 24th of July 1986, my prayer was rejected, which has been annexed at page 52 of the brief. What was their reason? The documentary evidence, the serial number 4. The document, it has been ticked only, others are stacking down. Documentary and 52, Milord. I'm sorry, Milord.
Yes.
Supporting evidence and supporting by you along with your application does not prove your claims. Well, this was the first rejection.
Yes.
After that, Milord, I made representations. Milord, representations, and Milord, the state government recommended my case. Because at the relevant time, why they have said so, because I don't know, because the secondary evidence was prescribed to be a piece of evidence for considering the case of freedom fighters for someone pension. Milord, state government recommended at page number 52A. 52A of my lord's brief, Milord.
Yes.
Milord. After that, Milord, after recommendation, the government of India directed the state government to inquire and verify the claim of the petitioner,
Yes.
which lordship will find at page number 53 of the brief. Your lordship, 53. State government was directed to inquire and report.
Yes.
Well, accordingly, the state government verified and sent the report by their letter dated 16th of December 1990. But thereafter, nothing has been communicated to me, whether my application has been rejected or allowed or still pending disposal or not. I have made one after another representation through myself or through my advocate. Till that, no communication has been done.
Yes.
As indicating as to whether my application claim has been rejected on such and such ground or it is still to be decided.
Yes.
Under these circumstances, I have come before Lordship. Now I am 105 years old, counting the days.
So 1990 till date, what you have done?
Lord, since 1990, your Lordship representation 2003, Lord 10, 16, 23rd and 25, all time, Lord, your Lordship knows it. Poor village litigant, writing the letters and letters for their consideration.
But you are the expert in this matter. Why you have
No,
not
no,
analyzed that?
that is not to that.
You are the
my client, unless my client comes to me, unless my clients come to me, how well can I advise them? Well, in anyhow, your Lordship knows better than me. Even in this case, it is a catching of judgment of the Honorable High Court and also the Supreme Court. In these cases, there cannot have any delay. Well, if I am entitled, if not, I will go out of court.
Okay.
Lord, so what I am praying before Lordship at this stage, I cannot pray before my Lord. Your Lordship kindly allow this writ application. I like to pray before Lordship kindly direct the central government to produce the record before my Lord. After producing the same, that decision may be given by my Lord in my favor or against me, especially for the reasons without calling for the affidavit. I am praying for the submission of the record, especially for the reasons of my client says. If direction for affidavit be given, that will take long time. There will be difficulties for having the matter listed at heart. Considering my age, your Lordship kindly ask next.
Lord, my learned friend has produced page 52. This is an order rejecting his claim on 24th July 1986. Admittedly, this was not challenged. On 19th November 2025, the writ petition was filed. The inordinate delay from July 1986 to 1925 has not been explained, number one. Now, the Supreme Court has, by a constitutional bench judgment in 64, has said that ordinarily in a 226 proceeding, limitation does not apply, but the provision of the Limitation Act shall apply for entertaining an application under 226, that is 3 years. No explanation is here. This delay. Paragraph 17 of the judgment, kindly find. This is constitution. 1964 Supreme Court online, Supreme Court page 10. State of Madhya Pradesh and another.
There has been that overruled.
Constitutional judgment overruled.
আরে দাঁড়ানে বাবা উনি বলছেন কেন ডিস্টার্ব করছিস জজ সাহেব শুনছেন বড় মতো রিপ্লাই
Kindly see how many of the judgment was delivered by five honorable judges. Therefore, it is a constitutional bench judgment.
Yes.
No, recently, Supreme Court 2025 SCC online Supreme Court page 1969 of 69, the Honorable Justice Patriwala has said each day's delay has to be explained. This is not the printout here, but you can
What is the citation?
This is 2025 SCC online Supreme Court 1969.
Page.
This is 1969.
1969. Yes.
121, 126, 153, 157, 261. Therefore, the question is, that apart, this question is whether
Yes.
the second part is they are claiming freedom fighters pension on the basis of their secondary evidence, that is personal knowledge certificate. This R.N. Giri certificate is in question before the Supreme Court. That is being heard. The last hearing was in November 2025. It has been placed for further hearing in January 2026. So more than 20,000 certificates were issued in the name of R.N. Giri. Then we shall be placing
Where is
the
that
Supreme
certificate?
Perhaps my learned friend is submitting without record.
Please, please, please.
Yes, without record.
Yes.
Mr. Manna.
I will satisfy their
Please,
report.
please.
Mr. Manna, take your seat.
Please, you take
Sorry,
seat.
sorry.
Please take seat. I will hear you in reply.
Sorry, my lord, sorry.
Supreme Court.
25,000. 2,100 something.
This is Union of India and others versus Rampodo Paja.
Yes.
This is, my lord, actually. আরে বাবা নভেম্বরেরটা কোথায় নভেম্বরেরটা কোথায় আগে থেকে ভারত নভেম্বরের অর্ডারটা
2053 2019 সে ডায়রি নাম্বার সাইটেশনটা পাচ্ছে না আমাদের যে সব আছে
yes my lord, actually this is kindly first kindly find, my lord, at para 5 and 6. Number of entities, individuals authorized in the state of West Bengal to issue personal knowledge certificates, PKC. Number of certificates issued by Mr. R.N. Giri during the relevant period to consider candidates claiming to be underground sufferers absconded. Therefore, the earlier order of the Supreme Court initiating a proceeding for an inquiry was in respect of 20,000 certificates issued in the name of R.N. Giri.
So here also the R.N. Giri has issued the
Yes, same. And secondly, kindly come, my lord, to the November order set out. The Supreme Court. পরেরটা জানুয়ারিতে দিয়েছে কোনটা সেটা কোনটা Now
Yes.
the next hearing date has been fixed, my lord, is of 21st January 2026. And last hearing it was held on 11th November 2025. These inquiries were going on. In one of the matters, Sukhdev Maiti, that is being heard by the division bench. There, the then Honorable Chief Justice, speaking for the division bench, also wanted us to file a report as to how many cases the certificates were cancelled. We have filed the report regarding this R.N. Giri. There were two questions are there: inordinate delay and certificate of R.N. Giri. So therefore, there is no question of entertaining the writ petition on these two grounds.
Yes.
Unless the entire proceeding is completed by the Supreme Court on an inquiry and the delay is not explained. My learned friend was whispering that this constitutional bench judgment has been overruled. I do not know whether by whom, whether by 9 bench judgment or 11 bench judgment.
Okay.
Therefore, there is no question of entertaining this malafide application.
Okay. Yes, Mr. Manna, anything?
My learned friend has raised the first question that there is a limitation. But first of all, before referring the Supreme Court judgment, I like to refer one of the division bench judgment of this court in the case of Lichubala Ghara, wherein Lord paragraph, I will request my lord to have a look to paragraph 16. This point was taken of the limitation.
13 and 13.
The point was raised as paragraph 13. Mr. Mukherjee raised the point of delay. But it is a reported judgment. It is 2017 5 CHN Calcutta, page 464. কপি দেওয়াটাই রেফারেন্স বলে দিয়েছে, ওরা কপি দেয় না।
ছাড়ো, আমাদের একটাও দিল, ওদের দিতে হবে না। এত করে চাইলো। লিচুওয়ালা ঘোড়া ইউনিয়ন ভার্সেস ইউনিয়ন অফ ইন্ডিয়া।
সাইটেশন বললাম তো ভাই,
2017 ভলিউম 5 CHL CAL 464.
Yes.
Your Lordship has seen this honorable court. Right, in the case of Sudama Devi versus Commissioner of India, reported in 1983 two Supreme Court cases, volume 1, corresponding to year 1983 Supreme Court, page 653. It has been stated that the delay in the meritorious case, delay is to be ignored. And if it is seen that there is a meritorious case, the merit is there, if the case be delayed, it has been held in the so many cases of the Supreme Court, if the case be rejected on solely on the ground of delay, then the meritorious case will be thrown without rendering any justice. So even up to 31 years delay, the Supreme Court has condoned the delays. I am giving the reference. I could not bring all those books today because I could not guess that my learned friend will raise all those points. My learned friend has cited the case of Bhailal Bhai's case, which I have gone through personally, that has been overruled, and I also submitted that one before court number 11.
You being the experienced person knows that Mr. Chakravarti will appear,
he is
and naturally he
the
will,
first largest council miller.
he will only make short submission with regard to the what are the point involved.
Order number?
You being the senior person, you know, if ASGI is appearing, he is only making the submission with regard to the point of law involved.
Yes.
Yeah, the
64 Supreme Court, I have
That's
time
what
and, time and again referred to against him.
That's what I'm telling. He's raising
Number
the law
two,
point.
Should
Could have been prepared for
so
that.
delay cannot be taken into account. It is to be decided on merit. If there is any merit, I am entitled to get the justice for having the merit. First of all, your Lordship, my learned friend, he is saying that the first rejection order has not been challenged. So I cannot challenge now. That has been deemed to be recalled, especially for the reasons. After the rejection order, state government having recommended the case of mine for grant of pension, which cannot they ignore. They have sought for clarification and report. The report has been submitted. What step my learned friend's client has taken, that is silent. Let that document be come forward before my lord. So, my lord, if the government chooses not to dispose of the application, not to reply to the litigants for years together, for a petty, illiterate village people who has come after few days, years, claiming their legitimate claim, which is guaranteed by the scheme, cannot be ignored.
Okay.
So what I am saying, Lord, your Lordship can direct my learned friend to produce the record, and after going through the records, if your Lordship find that I don't have any case, your Lordship may reject my case with cost.
Sir. That's all.
Sir. Only one
But, sorry, Miller, one more point. I
Sorry.
My learned friend has raised the one question.
Yes.
Supreme Court order which has been raised, thrown before my lord. But after that order, even the case which is pending before the Supreme Court for consideration and which has been fixed on 21st of January 2026, in that case, my learned friend has granted pension. They are till that they are paying. In the case of In the case of Indu Bhushan Jana, they are paying a pension in spite of the case pending before the Honorable Supreme Court. In spite of that order, which my lord, which has been referred to my lord today by my learned friend. But in spite of that fate, in the case of what is Kali Krishna Bera, wherein the certifier is R.N. Giri, after the division, single bench order, division bench confirmed that order.
That all the things is okay, but after the 1990, it's okay. Leave aside the 1986, your case was rejected. But subsequently, okay, the state government has again initiated the process. But
Yes.
1990, it was served. It has been sent to the department.
Yes.
What prompted since 1990 till 2025?
No, thereafter, after recommendation by the state,
35
after recommendation by the state, the central government asked for verification report from the state government.
Correct.
But it was not within our knowledge what report has done. It has not been rejected on the basis of that report. For that, for which we have made representation after representation. It is true we have come late, but we have made representation. Kindly do that. What is the fate of my case? What after just in 98, I referring the Gokul Manjar's case, I prayed for, which was tested before the Supreme Court even. And even what is the same village, Ghoda Thakuria. I am from Ghoda Thakuria. Gokul Chandra Manja is also Ghoda Thakuria. That case went up to the Supreme Court, wherein R.N. Giri was the certifier. That case has been decided by the Honorable Supreme Court, and payment has been made. Pension has been made. Subsequently, in Sukhdev Kali Krishna Bera, wherein certifier is, your lordship decided that matter in Kali Krishna Bera, sitting in the single bench against which Lord Devolabala, Kali Krishna Bera, which was challenged before the appeal court. Appeal court confirmed my lord's order, wherein the R.N. Giri was the certifier. Then they challenged it before the Honorable Supreme Court. Honorable Supreme Court confirmed that order of the High Court, and subsequently, in spite of the Supreme Court's that order, which my landed price referred, they have paid the pension. And not only this, I can give my lord at least 1 dozen cases where R.N. Giri is a certifier. After passing of the Supreme Court order, they have done the pension. Rasmani Shah, very recently, 2-3 months ago, pension has been released. And my lord, in fact, that question is no longer before the Honorable Supreme Court. Honorable Supreme Court hearing, my lord, all the freedom fighters matter pending before the Honorable Supreme Court throughout India. Total 43 matters are pending there. That is not only the question of integrity of R.N. Giri. The question, the Honorable Supreme Court wants to formulate the point. A guideline to be followed. And where, my lord, the Honorable Supreme Court also expressed their opinion. The guideline of 14 cannot be applicable, especially for the, it was not the corrigendum or the memorandum
to the 1980 and 2009
connected to the scheme also. That was also the opinion of the court, which was expressed in the open court. And all those matters have been fixed on 21st of January.
So let this matter go after the 26th January.
21st January.
21st January.
Okay, so after 26, that's a 21st January, so I will fix after 26th January.
Then in the meantime, if your lordship so pleases.
No, you're telling us.
I paid because my age is 105. I prayed, let the document be come before your lordship. Your lordship paid. If your lordship thinks, no, I am not entitled to have any order, your lordship got the enough power to dismiss with cost. I don't mind, my lord. Let the justice be done to me, who has sacrificed his youth.
One point. He was speaking about 13 years delays condonation on merit. That is relating to a Section 5 application in respect of condonation of delay, not in connection with 226 application, where the Constitution bench has said it has to be within 3 years. And this is the Supreme Court's desire that a bench has to be constituted and all this adjudication has to be made about R.N. Giri certificates.
That has
These are the 2 points. Yes.
That has been constituted. That bench is hearing. Luckily or unluckily, I don't know.
Cases differ from
Nah,
fact to fact.
I am appearing on behalf of the freedom fighters there.
নাম আছে order নাম আছে
I don't know whether it is my good luck or bad luck.
The counsel
I
for
know the what order is going to has
press for leave to correct the age of the petitioner in the cost title as 105 instead of 95. Leave is granted to the petitioner to correct the age of the petitioner. Hearing concluded, hearing. Hearing concluded, hearing.
concluded CAB.
Pass order.
Can I refer the Supreme Court judgment about the delay?
What
Regarding the delay only. Only delay. Only 2023 cases I got a note. If your lordship so desire, I can, your lordship will ignore the marking and coloring.
Give a copy.
I will give you the reference, no problem. All these points were referred in the Devalabala's case before the division bench presided over my lord Justice Patheria and Justice Mante.
My lord, may I just only one sentence? Can this judgment override a constitutional bench judgment of 5 honorable judges? All the judgments are par incuria.
Okay, I am.
ওটা বলুন না
Next.
One more.
Okay, I will consider. Don't.
Can I? The overruled judgment before my lord so that my lord can produce in course of the day or my lord on the next day of hearing.
in course of the day in course of
In course of the day.
But judgment.
That judgment.
Then we have to argue.
Which has been overruled by my lord. Which
No,
has
if
been
it-
referred by my lord.
You want to refer some judgments?
Yes.
So I am fixing the another date then. You show the copy. Record and
I can hand it over to my lord's officer
No,
today.
but they have to give an opportunity to give the reply.
As your lord.
Monday.
That judgment was referred before court number 11. I also gave the reply and that judgment by which it has been overruled.
Monday.
Next.
I am for the petition.
Your lordship has placed it on Monday.
CAB.
CAB.
Judgment
Then copy has to be given to us if they produce.
Which one?
He wants.
I am not.
Well, then it's, if my lord places him on CAB, can I give the judgment today?
Sir, if you want to rely upon the further judgment, then I will fix another date. So
Monday.
you want to rely upon judgment?
That judgment which has been overruled.
Yes, record an order.
Sir, Monday করুন না
Though the parties to though the parties have argued the matter at length, full stop. Age का हो जाएगा बाकी का parties full stop. Learned counsel for the petitioner intend to rely further judgments and praise for time. According cases adjourned, let the matter appear on 7th January 2026 under the same heading.
ঠিক আছে তাই স্যার থাক
Yes, next.
I'm for the petition.
Yes.
Here, my lord, the petitioner might praise for consideration of his representation. Representation, my lord. The petition, the respondent number, the complaint against respondent number 4, who is practicing advocate in the Hooghly court, Chinsura court, my lord. But in the year, my lord, 1999, a partition suit was filed. My lord, it was, entrusted to an advocate. Subsequently, there are 4 plaintiffs. Out of 2 plaintiffs, my lord, 2 entrusted the matter to another advocate, who is the respondent number 4. Subsequently, in 2010, the matter was withdrawn. The suit was withdrawn by the identification of the respondent number 4, where my father, the petitioner's father, did not sign. The signature was forged and a criminal case was initiated. Subsequently, that order, which was the withdrawal order, was challenged before this Honorable High Court, and it was set aside. Subsequently, by that order, by pursuant to that order, the learned civil court, the lower court, what recalled the order of the withdrawal, and the suit is still pending. But I made complaint before the respondent number 1 here for consideration against the respondent number 4. That is pending since 2017. Subsequently, I have given the timeline, page number 7 of my writ petition. Kindly see, Your Lordship, Your Lordship may find that 29th of January 2022, subsequently on 19th February 2022, and 28th February 2022, it was adjourned. Subsequently on 23rd March 2022, written notes of argument submitted. But subsequently, no decision has been taken up. So my prayer before Your Lordship, direct the respondent number 1, my lord, to dispose of it by complaint, my lord, within a specific time.
Serve the copy to the bar
My lord,
council.
copies was notice was served, my lord, on 12th of December, my lord, which was received by the private respondent on 15th, and the authorities on 12th itself, 15th, my lord.
Who is appearing the bar council?
There is a notice, my lord. Indicating that today it will appear.
No, it is served to whom?
All the respondent. And the private respondent?
Yes. Who generally appears on behalf of the bar council here? Who generally appears?
Don't know, my lord.
You filed this writ petition 2023.
Yes, my lord. This is the affidavit of service earlier filed before this honorable court. But I have the Xerox copy, maybe in the file, my lord.
Where is your complaint?
But complaint, but I crave leave to file at the time of hearing. This is the complaint, my lord.
Where is the complaint?
The copy of the complaint.
You not disclose in the.
I have stated, but I have not enclosed, my lord. If your lordship might kindly allow me to file it by a supplementary affidavit, I could file. But at page number 16, my last representation.
When the last hearing was done?
Hearing was done, my lord, on 23rd March 2022.
Where it is?
Well, at page number 7, my lord, I have stated. Para 13. The notice I have actually page number 14. The initial notice.
That's why. Where is the last? This is the last notice, page 13.
No. And last notice is, I don't have last notice. But I have prayed for certified copy of the orders in page number 21, but that was not provided to us. Page number 21. Page number 20, 21.
The grievance of the petitioner in the present writ application that the petitioner has made a complaint to the Bar Council of West Bengal, which was registered as case number 18 of 27, West Bengal, against the private respondent, namely Bhaskar Chattopadhyay, having enrollment number WB 328 of 1993, being case number 18 of 2017. On receipt of the said, on initiation of the said case, the Bar Council of India issued notice of hearing.
Case number 18 of 2017.
Case number 18 of 2017. Issued notice of hearing. In the year 2020, And last hearing was conducted on
23rd March.
last hearing was conducted on 23rd of March 2022.
My last is 6th April 2022. I'm sorry.
6th April 2022.
Last adjournment.
The parties have also filed the written submission, written arguments. But thereafter till date, no order is passed by disposing of the complaint filed by the petitioner. Accordingly, counsel for the petitioner prays for a direction upon the respondent. Who is the respondent?
Respondent number 1 is the bar councilman.
Respondent.
4 is the private respondent.
Respondent. You are not made a secretary as a party.
Yes, secretary, my lord.
Yeah.
One is the secretary. To the secretary.
Direction upon the respondents. That is the Bar Council of West Bengal to dispose of the complaint filed by the petitioner within a specific time period. Full stop. The petitioner has served the notice to the private respondent as well as the Bar Council of West Bengal, but in spite of receipt of the notice, none appears on behalf of either of the parties. Considering the submission made by the counsel for the petitioner, peruse the materials on record. This court find that on the basis on the complaint submit on receipt of the complaint filed by the petitioner, the case was registered against the private respondent, being case number 18 of 2017, and notices of hearing was also issued, and the parties have also filed the written statement. But till date, the Bar Council of India, Bar Council of West Bengal has not disposed of the said complaint filed by the petitioner. According to this court find that the complaint filed by the petitioner is pending before the Bar Council of West Bengal since the year 2017. Accordingly, the writ petition is disposed of by directing the respondent number 1 to dispose of the complaint filed by the petitioner, being case number 18 of 2017 against the private respondent within a period of 6 weeks from the date of receipt of this order. WPL.
Next, well, may I take back the complaint one?
Petition. On the last petition is directed to serve a copy upon the FRRO and the Ministry of External Affairs. Both has been done. And also serve a copy of the amended cause title upon the respondents. That has been done as well. And my lord, this is the affidavit of service in respect to the other matter, my lord, that was not taken on records, my lord. I'm placing that as well.
Yes.
My lord, this is that Rohingya matter, my lord. Both the matters were tagged together. I'm praying for their release so that they can be reunited with their family and sent to Rohingya settlement camps, my lord.
So where you will go?
Now, my lord, will kindly see this. I have obtained instruction, my lord. The wife of Faridul Alam, my lord, I'll serve a copy upon the union and the state as well.
Yes.
So, my lord, the settlement camps are not run by the ministry or the UNHCR. It's just unofficial settlement camps, my lord, where there is a community leader and under whom there are 20-30 Rohingyas. They go every month to give hajira in the police station. My lord, will kindly see the first page. It is Delhi police. The first page. This person, Husanara, is the wife of Faridul Alam, my lord, one of the petitioners. So, my lord, will see the details are filled in. And then, my lord, will kindly see the next page.
Yes.
The family, Myanmar Rohingya refugee community, part of Hussain Ahmed. Hussain Ahmed is the community leader. Address, that is Khajuri Khas, Delhi 110094. There is families population list with families, all details. List of date of informed, room number is also given, police station is given. And this is submitted every month before the police station. My lord, will kindly see below the page, there is a stamp that is received. So they are basically giving hajira.
Yes.
So I'm praying for a similar relief, my lord. My wife is there. My daughter is also there, who I have not seen in the last 10 years, my lord. I want a similar prayer. I may be released. I will also go and give hajira. I'll give security, my lord, as far as the Maja Daruwala judgment that the Supreme Court Division Bench has passed, my lord. And with respect to the FRRO, my lord, I'll rely upon, my lord, one order of our High Court, my lord. The foreigner national, my lord. Well, this is Husanara Parveen
Yes.
versus my lord state. My lord will kindly see the first paragraph, section 14A, 14C of the Foreigners Act was there. She came to India. She's a Bangladeshi national, admitted position, overstayed. And then, my lord, she was taken into custody. A bail application was granted, my lord. We'll kindly see the second page. Second paragraph. Mr. Chakraborty, learned additional public prosecutor, produces the case diary and vehemently opposes the petitioner's prayer for bail. He submits that the petitioner is admittedly a foreign national and raises the question as to whether a foreigner, if released on bail, can be permitted to move freely within the territory of this country. In response to my query, he submits that no detention camp has been arranged by the state to keep such foreigners until disposal of trial. However, ultimately, he left the matter to the discretion of the court. My lord, this order was passed on 28th August 2025. My lord, after that, undoubtedly the petitioner is a foreigner, and although she entered within the territory of this country with valid passport and visa, but her visa subsequently expired. Despite that, she stayed back in this country.
Correct, madam. This is the pending case.
Yes, my lord. My lord will kindly see you.
In your case, you have completed the.
Yes, I have completed the sentence also.
What would be effect? How you will go and how you've been deported? How the state authority will deal with you?
Exactly, my lord. That is where the Maja Darua.
Today the court will pass an order. Okay, you've been. The jail authority will release you. So where you will go?
My lord, I will be staying in similarly. This person, my wife is staying in Delhi, my lord, settlement camp.
Who will take you to Delhi? Your movement is to be restricted.
Yes, that is why, my lord, I'm referring to this, my lord. We'll kindly see after that.
You have the Immigration Acts of 2025 and the rules.
No, my lord, I have the Foreigners Act, my lord.
Foreigners Act, that now it has been Foreigners Act has been segregated by the.
Yes, my lord. However,
25.
my lord, I have been convicted under this Foreigners Act, my lord. 14.
14. That's why you convicted. Then
Yes,
chapter is over.
Yes,
now the immigration part has come.
Yes, my lord.
There you have to put.
Yes, my lord.
As per the Immigration Act, the civil authority has to restrict your movement.
Yes.
Foreign nationals restrict your movement so that you cannot go away and you cannot done any wrong or commit any offense.
My lord will
That is
kindly.
the only problem. The state authorities has not done anything with regard to the stay of the foreign nationals.
That has been, my lord will kindly see page 3 of this.
Yes, I have gone through.
My lord, in this, it says that there is another judgment, my lord, that I'm relying upon. In that judgment, my lord will kindly see page 3. Citation time.
Yes, page 3 paragraph.
Yes. Taking note of the proposition laid down in Frank Vitrus and considering the fact that the present
reading.
My lord will kindly come to paragraph 5, my lord. After the judgment has been quoted, my lord. Page 3. No, my lord, I'm referring to the first bail one. Yes, my lord. Kindly see.
Yes.
Taking note of the proposition laid down in Frank Vitus, supra and considering the fact that the present petitioner has been in custody for a considerable period of time and the charge sheet has already been submitted, I'm inclined to accept petitioner's prayer for bail, however, subject to certain conditions. Now, my lord will kindly come to page 4. The petitioner shall provide the address where she shall reside to the investigating agency as well as the jurisdictional court and the officer in charge of the concerned police station within whose jurisdiction she shall reside. Concerned investigating officers shall communicate this order to the registration officer, who shall bring this fact of grant of bail to the notice of civil authority concerned. In the event the petitioner violates any of the conditions mentioned in the preceding paragraph without any justifiable cause, the learned trial court shall be at liberty to cancel her bail in accordance with law, without any further reference of this court. Now, my lord, the second order that I'm relying upon, my lord. Paragraph 8. My lord, you'll see internal page 4, paragraph 8.
Yes.
Therefore, we do not see any propriety in issuing a direction that either the civil authority or the registration officer should be made a party to a bail application filed by a foreigner, or a notice of the bail application be issued to the said authorities. The reason is that the authorities under the Act and the order have no locus to oppose bail application filed by a foreigner unless bail is sought where the allegation is of offense punishable under section 14 of the Act. The implementation of the civil authority or registration officer in all bail application filed by foreigners may result in unnecessary delay in deciding the bail application. All that can be done is that while releasing a foreigner on bail, the court shall direct the investigating agency or the state, as the case may be, to immediately inform the registration officer concerned appointed under Rule 3 of the rules about the grant of bail, so that the registration officer can bring the fact of the grant of bail to the notice of civil authority concerned. Paragraph 10. In addition to what we held by judgment and order dated this, we issue the following direction. While granting bail to a foreigner within the meaning of the Act, the court concerned shall issue directions to the state or prosecuting agency, as the case may be, to immediately communicate the order granting bail to the registration officer concerned appointed under Rule 3 of the rules, who in turn shall communicate the order to all authorities concerned, including the civil authorities. If such information is furnished, it will enable the authorities under the Act, the rules, and the order to take appropriate steps in accordance with the law. My lord, if a bail can be granted to a foreigner, I have completed my sentence.
You are not understanding. After the sentence is over, whether the question of bail arose.
No, my lord, I am claiming that if bail can be granted to a foreigner, I have completed my
accused now.
No, my lord,
He
I
is
have
not-
completed
he is
my
not offended
sentence.
in custody. The sentence is over.
Exactly, my lord. Then under what law is the government keeping me under
That
bail?
is to be decided.
Exactly, my lord.
That is to be decided. See, this all the things everywhere in every state. You go, the foreign national has to be released. They have to inform the civil authority. Civil authority will restrict their movement and will take vigil on the foreign national with their movement. The question now here the questions, you have been convicted, sentence has been passed, 10 years has been passed. So how now they have to be regulated?
That question has been answered by the FRRO. This is the seal cover report. That question has been answered. In both the matters.
2025.
Well, before
Yes, yes,
before
yes.
looking into this, kindly appreciate.
Yes.
Kindly appreciate that it has rightly fallen from my lord that the bail granted to Bangladeshi national, and in case where it has been categorically
CRMR 48.
recorded that he entered into India with a valid passport, it expired, and visa also expired, and then came the question that this is distinguishable on facts at all, because this particular persons had neither visa nor valid passport, and detained, and they have undergone the sentence.
Yes.
This will absolutely differ from case to case, and bail question and conviction has rightly fallen from my lord. It will not apply here. Secondly, what will be the situation after undergoing the sentence? Whether they are, yes. Number one is they submitted on the application that these are refugees. These are not refugees, they are illegal immigrants, either under the erstwhile Passport Entry into India Act or on the Foreigners Act or on the Citizenship Act. Therefore, they are illegal immigrants, not refugees. So therefore, they are not entitled to any shelter at Delhi. Number two, after the question now remains is whether after undergoing the sentence, what should be the situation? That has been explained by the FRR in the report. Kindly peruse the report, and this is also a report order has been served.
Well, a copy of the report maybe.
No, this is a confidential report.
And my lord, if we are not,
See that you don't. God will
My
give
lord, I
hearing to
just
all
wanted
of
to
you.
indicate
Don't
that
worry,
I
madam.
speak the HCR
This
CAT
court
as
will
well.
not pass any order without, yes,
This
hearing
is
any-
also an order communicated to the learned Deputy Solicitor General. This is also lawsuit kindly produce this. And then I shall place the latest law regarding the Immigration and Foreigners Act 2025.
Rule 7, section 7 and 8 of the rule. I think.
Yes. And the my lord, this is a case where your lordship will kindly find that that দেখি আমার order note করা আছে দেখি. Yes. Section 3, 13, 17 and 18. These are also very relevant.
Immigration and Foreigners Act 2022. আমার কাছে এটা আছে বার থেকে লেগেছিল এখানে 2025 আমি বার করে নিয়ে আসছি
Yes.
Now your lordship has gone through the report. Kindly come to the prayer. Whether the writ petition is at all maintainable. After undergoing the sentence, this prayer has been made at page 16. State at liberty to the petitioners who are residing at Damdam District Such Correctional Home, disclosing their destination for residence and on undertaking to report to local police station. Then P. Mandamus to issue directing the respondents and not their main agent servants to allow the prisoners to rehabilitate to the Rohingya refugee settlement camp in Delhi? Are they refugees?
My lord,
How does the writ petition lie after undergoing the sentence? What is the cause of action?
my illegal detention is the cause of action, my lord. My lord, if I'm not a refugee,
When additional solicitor general is arguing, keep mum.
Please maintain the decorum. Once the advocate is arguing, please wait. I will hear you, no problem. Yes.
Now, your lordship has seen the prayer. Prayer in the writ petition is for releasing them and transmitting them to Delhi, your refugee camp, whether they are refugees or not. A person who had neither a passport nor a visa or a document to travel, detained in India, sentenced, undergone the sentence, and then coming before the writ court without a cause of action, no petition, nothing, no representation for releasing them and submitting and then transmitting them to refugee camp. The other point which was submitted, that the United Nations affiliation, we have categorically stated, we have not entered into any agreement with this United Nations, that is para 4, you also have seen, India not a signatory to the United Nations Convention of 1951. It has no binding effect at all. Thirdly comes the moot question, what is the status of these petitioners? Now kindly come to Lord, section 3 first of the Immigration and Foreigners Act 2025. Section 3.
You are a copy?
Section 3. Yes. Now kindly come first to section definition of section 2F. 2F.
Yes.
Milord, has your lordship got it?
Yes.
2F says
Foreigner.
yes. 2F defines this is my lord, foreigner means a person who is not a citizen of India. Admittedly, is not a citizen.
Yes.
Now kindly come to section 13 of the Act. Section 13. Foreigners whose movements are restricted. Any foreigner in respect of whom there is in force an order under clause F of subsection 2 of section 7 requiring him to reside at a place set apart for the residence under supervision for a number of foreigners shall, while residing therein, be subject to such conditions as to maintenance, discipline, and punishments or offence and breaches of discipline as the central government may from time to time by order determine. No person shall knowingly assist such a foreigner to escape from custody or the place set apart for his residence, or knowingly harbor any such foreigner or give such a foreigner any assistance with intent thereby to prevent, hinder, or interference with the apprehension of such a foreigner. Now 3. Central government may by order provide for regulating access to and the conduct of persons in places in India where such a foreigner whose movements are restricted in laws and for prohibiting or regulating the dispatch or conveyance from outside such places or to for such foreigner therein of such articles as may be prescribed. This is the general provision. Now kindly come to section 17 and 18. This is obligation of carriers and like, and then 18 is liability of carrier to pay penalty. Now we have said he has undergone the imprisonment, no question of penalty. Now comes the moot question of deportation. Deportation to the original country.
Cannot be at this stage. How it can be? So, subject to correction of both parties. See, he has completed the sentence in the correctional home. And for the last more than 8 or 10 years, whatever, he is in custody. is in burden of the state.
Yes.
So only the question now, the whether have you taken the instruction whether the civil authorities have been appointed by the central government in the state of the West Bengal?
Still, no, not West Bengal. The civil authorities are residing at Delhi.
Correct,
Yes,
correct.
Kerala.
For the jurisdiction of the West Bengal, because why I am telling
That has been reported, my lord. In the report, there is fine. There is no civil authority in West Bengal.
correct. So that's why the civil authority first step is the civil authority is to be appointed by the central. It is not the state government. Civil authority is to be appointed by the central government. If the civil authority is appointed, then the civil authority will pass a restriction order. Then they will, the jail superintendent of the correction home will release and the movement will be restricted. Then the authority, that is my suggestion, because that can be done on the basis of this act. It is on now, it is only the civil authority has to restrict all the things.
Yes,
And
that's
the
true.
Supreme Court has already held the restriction is not illegal.
Yes.
Not illegal.
Yes.
So, but why the state government put the persons who already completed the sentence in the correctional home? So that's why they let the central government give the response, appoint the civil authority with respect of the state government of the West Bengal and the persons who the foreign.
That question I am answering. Kindly come once in the list to the Immigration and Foreigners Order 2025.
Yes.
Then may not kindly come to section 5. Power to grant permission to depart from India.
Foreigners orders.
Yes, the Immigration and Foreigners Orders 2025.
Yes.
Is it in your losses book?
It is not there. That's why.
Then
It is not here.
no, I am reading the provision.
Yes.
And then I'll hand over. Power to grant permission to depart from India. In addition to the grounds specified in first proviso to subsection 2 of section 3 of the Act, that is, the Act has been referred to already. A person may be refused permission to depart from India on the following grounds, namely, if his presence is required in India by any court, if he is suffering from diseases which are danger to public health, the safety is not applicable, if his exit may adversely affect relations with the foreign state, if he cannot be allowed to depart or exit from India either under specific orders of the central government or by an order issued by any law enforcement authorities, that is section 5 subsection D, says clause D. Then again kindly come to section.
What is the rule you are referred to?
This is section 5 of the Immigration and Foreigners Order 2025. Section 5. Then kindly come to section 12.
Yes.
Power to prevent, detect, impose restriction on movement and deportation of illegal migrants. This act has come into effect in September 2025, and we are now in December.
Correct.
Now, power, the immigration officer at the immigration post shall take steps, including examination of foreigners and inspection of career, to prevent foreigners attempting to enter into India without valid travel documents. This is exactly the case.
Correct.
The designated border guarding and forces of the Coast Guard shall take steps in preventing illegal migrants attempting to enter into India by sending them back after capturing their biometrics information and available demographic details on the designated portal of the central government. Then 3, the civil authority, the state government or the union territory administration or any authority specified in this behalf shall take steps to detect illegal migrants in India in accordance with the procedure specified by the central government from time to time, which may include the following, namely examination of foreigners and all that. This has already been done. They could not produce any document. They were sentenced. They have neither any visa nor any passport. Therefore, they are illegal immigrants.
Correct.
They are liable
No
now.
dispute. No dispute. So that's why
we have already given in the report that there is no designated detention center in West Bengal. This is in Delhi.
What I proposed to do, I am keeping this petition pending. I am not passing. Let the central government appoint a civil authority with regard to the state of West Bengal. within or submit the report. If the civil authority is appointed, then they will be released from the correctional home, and they will be under the civil authority, and the civil authority will
Kindly make this observation.
restrict the movement, and the civil authority will restrict the movement
Yes.
of the immigrants, the foreign nationals who have completed the sentence and who have been released from the custody. He will restrict the movement of them, and he will take care and they will keep the vigilance on the foreign nationals till they have been deported or any
Yes,
further.
but the argument that is advanced regarding bail is not applicable here.
No, bail.
Argument that they are refugees is
This-
not applicable here.
My lord, I'm not,
I am satisfying my learned this.
Yes.
I'm
on-
not-
on-
my lord, I'm not praying
if it
for
is
bail, my
by
lord.
honorable court monitors, my lord,
That's why since
but-
beginning, the
yes,
first day I
can
am
pass
telling
that order.
it is not a bail.
A designated detention center can be established in West Bengal.
He was not
Terms of
even it
That
is
is
not.
nobody's
If
case.
till it is not been established, till that is not established, they can make an arrangement, but the restriction all the because if you put, then the state government will say I have not this and all. For till the state government will not make necessary arrangement for the stay of the foreign nationals, the foreign national will reside of their own, but they will identify the place and inform the civil authority, and civil authority will keep the vigilance on that, keeping the restricted movement.
But in the meantime, the accused shall not be released on bail.
Unless and until the civil authority
Yes,
is appointed,
yes.
who will take care of it?
My
Who
lord,
will take care of
if
it?
I may, my lord, first of all, the question of refugee. My lord, if I have been granted refugee status as a UNHCR.
I am telling you, with regard to a refugee status, I am telling you, first let you come out from the correctional home, then
Yes.
you fight with regard to the status, whether you are
No, my lord, I'm
refugee,
just-
whether you are Myanmar's, whether whatever or your Arakan army, whatever it is. You fight your own. Now before the court has to guide how you cannot be keep in the custody for the long
Exactly,
time,
my lord.
unlimited. But the court has to take the balance of the state authorities' obligations. If you have been today the blanket order is passed, because with regard to the bail, your vigilance is with the investigating officer on the concerned police station. But now, after you have been convicted, you have completed the sentence, investigating officer has lost his
Yes, my lord.
jurisdiction. So who will? So as per the Foreigners Act, this Immigration Act, earlier it was the Foreigners Act, it is the civil authority. Civil authority has the authority who can keep vigilance and who will guide the foreign national and keep the vigilance on the foreign national by keeping the restricted movement.
Absolutely, my lord. I bow down to your logic. However, my lord, it is admitted that there are 40,000 Rohingyas living, and I have submitted before your lordship how they are living. So, how is the union distinguishing me from those 40,000 Rohingyas?
So yeah.
My lord, there cannot be a
you have to-
class within a
That's
class.
I'm
My lord.
telling you have to be strict either in your coming out from the case or declaring you as a Rohingya. If you wanted
No, my lord, I am a Rohingya, my lord. I have been convicted as a Rohingya itself, as a Myanmar.
That will be decided now, and before this court, now they cannot.
No, my lord. No, my lord. But I have been convicted because I entered India illegally as a Myanmaris.
Myanmaris.
Yes, my lord. So Rohingya it is not disputed, my lord. They are also not disputing that I am Rohingya. They're disputing that I'm a refugee. I am saying that I'm a refugee because I have UNHCR card. If the union does not recognize UNHCR, they should not allow them to operate in India at all, because otherwise, what is the validity of the UNHCR card, my lord? I am saying they are not disputing that I'm a Rohingya. I am saying that my wife is staying there. She is reporting to the Delhi police every month, my lord. So what is the distinction between?
If today, suppose the court, yes, you go and then how the court or the authority will say vigil you?
My lord will
how you
kindly-
will reach the Delhi? In
Yes.
the meantime, if you committed any offense, who will be responsible for
If
that?
my lord kindly takes the Majadaruwala judgment, my
Correct.
lord, the division bench. The division bench has laid down categorically all the conditions.
That has been led. That's I'm telling. That has been telling, but the court has stated the bail, grant the bail. But here the
To be released on bail, my lord.
But here the question of bail will come once the sentence is over.
No, my lord. However, my lord, it is a Supreme Court judgment, my lord, which says that to be released on bail. Maybe the use of what bail should not have been used, my lord. However, my lord, in Anna Parveen as well, my lord, the Supreme Court has granted release. Not have used the word bail, but have used the word release. after the completion of sentence.
I am totally agree with that's I'm telling you, you can
Yes.
be released. But if you are released, how you will be restricted? Your movement has been restricted. Who, which authority?
My lord, I will furnish bond, my lord. I will furnish surety.
To whom?
My lord, that my lord will direct the jurisdictional court, my lord. The court which has passed the sentencing order, my lord. If my lord directs that court to take the
But this court cannot go behind the law.
my lord,
The law.
my lord.
This is the law now, new law. Earlier it is the Foreigners Act. Foreigners Act consisting of the immigration. Now
My-
Immigration Act has been segregated now.
My
So
lord.
immigration, this is the law. As per the law, there is an authority prescribed.
Yes.
Once the authority is prescribed, unless and until the authority is not, because this law does not provide, unless the authorities have been appointed, what is the course of action? That is not provided in the law.
Yes, my lord. That is why I'm relying on precedents. There are Punjab and Haryana High Court order, my lord. Our High Court, which has directed the petitioner to be handed over to UNHCR to be sent to the settlement camp, my lord. My lord will kindly see this Shah Ghazai, my lord. The Noor Muhammad order, my lord. In both of them, my lord, they were asked to be handed over to the UNHCR. Or my lord can direct the state authorities to transfer me to the.
What is the status of the UNHCR?
My lord, that is if UNHCR is being allowed.
They have submitted the report. They are not connected.
Then why are they allowing UNHCR to operate in India, my lord?
This is a bit it kind of the NGOs.
They are
Kind
being
of
allowed, and they should not be allowed to hand over, my lord, the refugee status card as well, my lord. Admittedly, India is not signatory to the Refugee Convention. However, India is the signatory to the Universal Declaration of Human Rights, my lord. So India cannot go beyond, my lord, that. India is a signatory. And my lord,
this court is also thinking on that also.
Yes, my lord. My lord,
Your liberty cannot be curtailed.
Yes, my
But you will not. But simultaneously, we have to see the our state and our country also. How we have to be regulated. How we have to be regulated with regard to the movement of the foreign nationals.
Yes, my lord.
They have been convicted. They have been completed the sentence.
My lord, on the basis of the judgment of this order of this court, my lord, on a previous occasion, my lord, for Rohingya, they were women, my lord, they were transferred to homes, women homes, and subsequently order was passed that if they want to be reunited with their family members, application may be made to the authorities, my lord. My lord will kindly see. Subsequently, my lord, state government transferred them to women's home, my lord, and application was made by their relatives, and they were subsequently transferred and reunited with their family members. My lord will kindly see. The coordinate bench order, my lord. Fatima Begum order WPA number 1609 of 2022. My lord will kindly take the 2806/2023 order first. The 2806/2023 order. Similar prayer, my lord.
Yes.
My lord, only one thing. What is being my lord, stated in the petition and what is being argued. Kindly come to page 41 of the second petition. On the basis of the application, what is the order passed by the learned judicial magistrate?
41 of the
second petition. Item 17. Page 41. In the last occasion, I also drew your lordship's attention.
Yes, 41.
Now, the last paragraph, kindly see what is the prayer made and what is being argued now. Without challenging this order, in 482, this is being argued. So the record being number such and such was accordingly disposed of after passing the sentence of the applicant petitioner. Now it is the allegation of the learned advocate for the petitioner that the petitioner applicant has yet not repatriated his native country and he is a refugee camp holder, so he will release at once. As such, he can take shelter under the refugee camp at Delhi, which is being argued consistently. Now, at Delhi. After considering their matter, this court was of the opinion that this part of the sentence is a purely administrative matter, and this court has no authority to interfere about this matter. Moreover, this is the trial court, and the conviction was duly passed by this court to the petitioner applicant, and the record was accordingly disposed of. Now, this trial court has no authority to alternate or modify the order as is allowed from this room. So, considering all these matters, this court is of the opinion that the petition failed by the concern. Hence, the petition it is such as filed by the applicant or petitioner for discharge is rejected. This has not been challenged in 482. Now, his writ petition has been moved, no cause of action, nothing. And this is of 2018 and 2025 December. This is being filed.
My lord, if I may, my lord, I have stated that this before also. My lord, I'm not challenging this because the magistrate has rightly rejected my prayer, because once he passes the sentencing order, my lord, he's functus officio. He could not have granted this relief. So, my lord, there is no point in challenging this order because that is the correct proposition of law, my lord. So, how will I challenge something which the magistrate have rightly?
Okay, I will pass on. Mr. Yes, till the civil authority is appointed, can it be possible for your which PS case is this?
Swarup Nagar. Havda Government Railway Police Station.
But I will see there the advocate has not even a concept saying that a safe home will be not established within Joindipur Mauja for this kind of people, Rohingyas. Now, your lordship will find, your lordship can direct, the state government will coordinate with the civil authorities and they will decide the future course of action, whether the detention camp will be there or not, or the safe home will be.
My lord, I do not know this thing. I appear for the state. My lord, may I tell? My lord, the scope of the writ petition cannot be extended in this way. My lord, I do not know why he is making this submission.
Your
It is
expert channel is making.
just a minute. I do not know. I have to go.
Okay. Yes.
I have to go through. Now, my lord, all on a sudden, if a paper, my lord, come out and say all these things, my lord, then I have put an instruction. But the thing is this, my lord, the prayer, the scope of the writ petition is very limited. My lord, no one can, my lord, extend the scope of the writ petition. My lord, kindly come to the prayer of the writ petition once. My lord, they would be satisfied if your lordship kindly have a look their prayer. My lord, this is not any public interest litigation, first of all. My lord, kindly, my lord, allow me. My lord, they said, my lord, many things. I only, my lord, want to say, my lord, only 5 minutes. First of all, this is not a public interest litigation. So no question of, my lord, what they pray or not, my lord, they need framing any policy. My lord, there is no question of framing policy on the question of this individual matter, where their prayer is, my lord, lordship, kindly have a look at prayer B.
Yes, I agree.
They would be satisfied that rehabilitate to the Rohingya refugee settlement camp in Delhi, where their relatives are there according to them. This, my lord, the prayer is a very restricted prayer. And my lord knows that the apartment and everything very limited to, my lord, these individuals are concerned. Now, my lord, at this juncture, my lord, is there any scope to formation of any, my lord, direction regarding policy or other thing? Lordship, kindly consider one thing. My lord, this is not a public interest litigation. Lordship, kindly consider.
It is correct, sir.
Now,
I totally.
now, my lord, so far this prayer B is concerned, where they said that they would be satisfied for the time being. Individual prayer, individual satisfaction with regard to their, my lord, the Article 21 life, if at all Article 21 apply to them, they are not citizen. I am not on that also. But in any event, if they want to satisfy these, whether these can be done by way of any felicitation, my lord, the process,
to facilitate that, my lord, the state will, my lord, help it.
That's why, see.
But what my learned says is something totally different.
Not different.
Totally
What
different.
please you go through the act. Please you go through the act. If the foreign nationals either he have been released on bail or he has completed the sentence, he has to come out from the correctional home, there should be a restriction of movement. And as per the act, the restriction movement is to be passed by the civil authority.
Yes.
Not on this new amendment. It is already available in the old act also.
Yes.
Now due to the confusion that act has been segregated. So civil authority has to be appointed
This
by
is called detention center.
correct. So civil authority has to be appointed by the central government. That's why I'm telling if the central government is not appointed and the state government is facing difficulty for keeping all the persons in the custody who has already completed the sentence. So
No,
what should be
state
the
has not-
effect?
State has not said anything here.
Not stated, but the court has to see.
Yes.
State has no, but the court once it has been come to the knowledge of the court has some authority.
Court has some authority,
Then-
but my lord, may I tell? Now,
So
my lord,
court
the-
has to some authority, court has to see, it has to be resolved the issue. I am not against the state government, I am not against the
I am not-
petitioner, I am not against the central government.
I am-
Court has to do the work in accordance with the law. So now that's why since beginning I'm telling that whether any civil authority is appointed with respect to the state of the West Bengal, there's no civil authority. If you say that that's why last question I have put to ASGI. If suppose today I allow the petitioner to the jail superintendent to allow the petitioner to go out, who will take care of it? Who will restrict the movement? If you restrict the movement, that whether that is in accordance with this act.
my lord, may I tell? That is why I think, Lordship, kindly, my lord, because my lord, on the basis of the submissions made by them and also my lord, my learned pen on behalf of the central government, my lord, the question is now, my lord, I think that with regard to my lord, a particular class, but what I am on, that in respect of this writ petition, the scope is very limited with regard to a, my lord, not class, but a particular person or persons.
Particular, you go by the particular person.
Yes. Now,
I am going by the particular person, yes.
They say that already they suffered the entire full length of sentence.
Correct.
Now they want to come out.
Correct.
Now the difficulty is that they want to be, my lord, to join or mix with their other people relative at Delhi.
Correct.
Now, how it can be solved? So for this problem, Lordship, kindly consider, my lord, this aspect only my humble submission. So far, the present petitioners are concerned.
Thank you.
What I am telling before your Lordship, that Lordship, my lord, I am kindly, my lord.
No, I am. It is the court has the duty to hear all the person before concluding any.
My lord, what is, my lord, the case is that, my lord, my humble submission is that it is not a case made out herein. Neither we can made out a case with regard to any policy matter with regard to this. Now, whatever the, my lord, the policy matter, let it be raised. My lord, on other occasion, it would be seen if it is a public interest litigation or other thing. This is not a public interest litigation. This is totally, my lord, restricted to, my lord, 2 or 3 persons who have come before your Lordship. Now, Lordship, kindly, my lord, see that how this prayer can be, my lord,
But the problem is you are right on your way as per the writ petition. But this court is not only having one matter. This court is having lots of matter. Every day, 1 or the 2 advocates are mentioning with regard to the matter. And since when I have taken that determination, since then I am dealing with the matter. That's why the matter has to be solved once for all. Once for all. That's why I'm telling it is not that he should be keep or you will be harassed or they will be harassed. So matter has to be solved for once because the state I don't know earlier whether this questions was raised before the court or not, or
Yes, it was raised.
it was raised, but there was no further thing as in you have given whatever it is. I am not taking into consideration, you will say. So that's why now the act and all the things is before the court. So court has to pass an order in accordance with the law only. Okay, personal liberty is higher than all the things, but the personal liberty has to be seen along with the other laws. So
That is
if
but
the
only-
prayer B is allowed,
I have
only you give the suggestion to me, I will act on that. The court will pass an order that you, if the
No, I have not sought for any suggestion
no,
because of the
if
fact
the
that this
prayer
is a-
B is allowed,
is a
if,
matter.
if the court is allowed to go to Delhi, who will take responsibility from the release from the correctional home to reaching up the Delhi? Who will identify the person who will go to the Delhi of that camp?
Mother,
Who will?
the
Who will?
authority, the authority can depute.
That's why
the person.
authorities prescribe the civil authority. Civil authority is not been appointed. Can this court, keeping this act aside, whether any person can be appointed from the state as a civil authority?
Civil authority is already there in Delhi.
That Delhi, but whether he's having a jurisdiction, the court, you submit that's what I'm telling. You submit the report. If the civil authority appointed in the Delhi, having the jurisdiction over the
Kindly
state of
appreciate
Bengal,
who is to apprise the civil authority.
state government,
Yes.
By the
state
order.
government. State government has to write, yes, these are the person, they have to be released. Because what is the procedure? I am again telling. What is the procedure for release of the personnel from the correctional home who is the foreign national? Once the court passes an order, I think the West Bengal state, neither any of the correctional home is following that procedure. The procedure for release of the foreign national from the correctional home, once the court passes an order for bail, immediately this has been communicated to the civil authority, and civil authority will remain in the jail's gate, correctional home gate, and they will take the persons to the home and they will give the restriction order, then they will roaming around the state. This is the procedure. I don't know, several orders has been seen, they have been released on how they have been released, who can restrict? That is true.
These release order are pre-conviction stage.
No, that is correct.
Secondly, kindly appreciate.
No, Mr.
whether-
SJ, that is also the bail. After the bail, also the civil authority has to restrict. again.
Exactly. Kindly also consider last question, whether an accused who has undergone a sentence, not having a passport or a visa, has any right under Article 21.
That's why he's telling that this is not the public interest. So that I am not going into that whether it is a turn. Let yes. Anything for the what is your submission?
That is my submission.
Correct.
That
But you inform what can be done with regard to the civil authority, or you can give the report. Yes, you have informed to the Delhi government, the central government has not response for that.
At the present moment, my lord, I have no, my lord, the instruction or report to that
So
extent.
the civil authority visiting Delhi, whether because I don't
The
think
civil
so. The
authority is in
civil
Delhi.
authority appointed by the
The
Delhi is
let-
having the jurisdiction because all the state or union territory they are having own their civil authority appointed by the government by way of notification. I don't know why in the state government of West Bengal it is.
These civil authorities at Delhi are functioning under the supervision and guidance of the FRRO.
Correct. No, but the jurisdiction. The jurisdiction, whether
Therefore, if they are in the correctional home at state of West Bengal, the state of West Bengal can write it to the FRRO.
That's why they have not done so. That's why they are facing difficulties. The state government has not.
See where earlier stand.
My lord, earlier stand, I do not know, my lord. Lordship, kindly consider. My lord, in this way, my lord, in this way, my lord, the matter which is, my lord, can be solved in other way. The scope cannot be extended in this way.
That's why I am telling what I
Kindly
propose.
I do not know this. My lord, they have.
Correct. I am not passing any order against the state government. Make sure only I am proposing to pass an order subject to correction by all the parties who are appearing in the matter. Now the act has been amended. It is informed from the bar that no civil authority is there. As per the act, if the foreign nations is released from the correctional home, it is the duty of the civil authority to restrict the movement of the foreign nationals. And there is no home also. So that's why only I will pass a direction upon the Union of India to intimate before this court whether any civil authority is appointed with regard to the state government. If it is not appointed, to take appropriate steps for appointment of this and to submit the report. Once the civil authority appointed, all the matter would have been solved. That's all, nothing else.
Yes.
No designation.
Designation center will come, let the civil authority.
That is the reason.
That's why that's it. Once the civil authority is appointed, then he will recommend for the designated center. Then if it is done.
Judgment reserved.
Orders for hearing concluded for orders, not judgment. For orders.
আমার আশ্রমে মুসলমানরা
ও সেই আশ্রম?
হ্যাঁ
My lord is keeping it next.
I think either Friday or Monday you will get the order.
It's my lord keeping it pending until.
I am not disposing of. I will call for the report.
But the 1 p.m. matter, my lord, regarding that ashram, my lord, where that, my lord, the Mohammedan people were burying the bodies, my lord. That my lord was to appoint the special officer. The state said that they will come back with father.
My lord, I am appearing for this case. My lord, Mr. Asim Kumar Ganguly is my lord. It's not my lord. It's my leg injury. He has not come to court.
Very well, it was argued at length.
He has asked for my lord this week my lord the accommodation.
And 10 more bodies will be
down in the
buried.
heel. My lord fell down in the very first morning in the my lord home. So my lord he has my lord undergone going treatment. My lord he asked for my lord the accommodation on this matter. Only my lord not this week. Come back on my lord
This is the
Monday.
strategy, my lord. That day also, my lord, when the court was, honorable court was inclined, my lord, to pass the order.
Hey, कल 1 बजे है मैटर देखो कल 1 बजे मैटर है
1 o'clock, my lord, speaks that other matter, my lord.
11:30 बजे कितना बजे 1 बजे फिक्स है 12 बजे खाली है कम टुमारो टू this
I am always there at your
item number
item number
copy রাখছেন
item
11 item number 11
11
item number 11 दादा item number 11 tomorrow at 12 noon.
My lord, my only request is a shorter date, my lord. That's why.
I
Because it's
will
been
pass.
1 year.
Tomorrow and day after tomorrow you will get the order, but the report has to come. So 4 weeks time is to be given to the authority.
My lord, already 1 year has passed.
I appreciate, but the center has to give the report. So after vacation, I will fix the date.
Before your lordship.
I will fix the date.
Before your lordship rises
Before
up-
that, I will pass an order.
Your lordship, in the morning I had mentioned this matter, badminton matter, your lordship. Your lordship has seen this and your lordship has fixed the matter on 23rd. Your lordship would see the second paragraph, your lordship. The camp is starting from the 19th. Your lordship could keep it tomorrow, your lordship. Liberty could be granted tomorrow, your lordship. The camp is starting from the 19th, your lordship. আজকে করবো? Today, your lordship, at 2 o'clock.
मेंशन करून बोलছি मामला नয়
इसमें पहले क्या ऑर्डर किया था कुछ ऑर्डर किया था लीव दिया था
On the 23rd, your lordship.
granted.
Yes, on the 23rd. If instead of 23rd, it can be tomorrow, your lordship.
Tomorrow is the 18th. How it can be possible? How you?
Your lordship, kindly, because the camp is starting from the 19th, your lordship would see the second paragraph, your lordship. It's in Vijayawada, your lordship.
Your client has done all these things.
Your lordship has heard on the last occasion also.
Tomorrow 12 बजे तो रख दिया और कब रखेगा 1 बजे ऑलरेडी फिक्स है ठीक है टुमारो अर्जेंट मोशन में रखो
Grateful, your lordship, grateful.
टुमारो अर्जेंट मोशन
Your Lordship, may I be,
Tomorrow,
Your Lordship, may I be permitted to mention item number 39 for withdrawal, Your Lordship? I have
withdrawal come tomorrow I'll pass out.
Tomorrow, as Your Lordship directs. My lord, if your lordship can.
Item number 9.
My lord's pleasure was that my lord will hear GS6 first.
Yes.
And then GS7 if required.
Yes.
Lord,
Before Mr. Ghosh starts, Lord, before Mr. Ghosh starts, Lord, it is that matter, Lord, where pursuant to Supreme Court's direction, Lord, my client had preferred, Lord, whatever reliefs before the NGT, pursuant to Supreme Court's direction. Now, Lord, we made an application before in this, Lord, writ petition, whereby, Lord, we were for addition of party. Lord, that application was rejected, appeal pending, whatever there is, it is. Now, Lord, the difficulty is, Lord, this writ petition basically, Lord, seeks to enforce the order already passed by NGT, which is under challenge in my, Lord, application, which was granted liberty by the Honorable Supreme Court. Lord, this way, if this matter proceeds, Lord, I shall be remediless. That's the sole problem. And there, Lord, on the some reason, for some reason, on some pretext of the other, Lord, there are various parties. Lord, everybody is filing affidavits. Lord, today they will file affidavit, tomorrow they will file a correction. That's why my matter is not getting heard out. So, Lord, I am the most prejudiced person.
So your application is already rejected.
Already rejected.
So
Lord,
now
kindly considers this. Kindly considers this, Lord.
Now this court, how consider your
Lord, else the
once your
relief.
application is rejected and this court has
Yes,
filed,
Lord.
you file this division bench is also rejected.
No, division bench is pending.
It is
It's pending in the division bench.
There is an stay of that.
No,
The question of stay
no,
does not
no.
arise.
Now, Lord, the difficulty is I will become remediless despite the liberty granted by the Honorable Supreme Court.
Okay, if you got the order in the appellate court, you can file an application for recall if at all any order is passed.
But the difficulty
If at all any order is passed,
I understand, no, what
then
is
you
falling
can
from
file
your
actually, because today I cannot, this court
Yes,
cannot
Lord.
keep silent.
I understand, Lord, what is falling from your lordship. The only difficulty is, Lord, today, if pursuant to that order, Lord, my lord passes an order, Lord, for execution of, Lord, the NGT order, or the authorities to, Lord, get triggered. Now, Lord, if the building is demolished in the meantime, my entire proceeding goes. Lord, kindly keeps this in mind, Lord, while disposing of. This is my only prayer. Nothing else I cannot have a say today. So, Lord, this is the only prayer.
How you are claiming your building?
Lord, what has happened, Lord, they have said that was behind my back, those proceedings. They had said that certain amount of parcels of land, Lord, those were, Lord, constructed, the area were constructed, Lord, after, Lord, filling up the pond. Now, Lord, pursuant to that, NGT passed an order, 8-member committee report was there. Lord, the 8-member committee found, Lord, by virtue of a Google map, that portion is, Lord, filled up. Now, my lord, we had challenged, we went to Supreme Court, Lord, indicating that we were not heard. Supreme Court granted us liberty to prefer the recalling before the NGT. So, my lord, that application is pending. Lord, we have various other grounds. First of the ground is my plot is situated on 5 DAG numbers. The alleged impugned DAG number, which the Lord, authority is alleged to be filled up, constructed by filling up a pond, is only one of them. Now, there is no demarcation which plot where. So, this is the basic. I am prima facie indicating to your lordship.
How this court, what is the reason for dismissal of your application by this?
The application was rejected on the premise that I have preferred, whatever my proceedings before the NGT will take care of. Now, the difficulty is not there. Because of this affidavit problem, I am unable to get my matter heard out. Okay. Yesterday, before yesterday, the matter was there, your lordship. That's the reason why your lordship kept it today. Now, my lord, again the same thing was repeated. The next date is on 10th of March. Now, my lord, kindly keeps this in mind before my lord passing any order. That's my only request. Great.
Yes.
Lord,
how many respondents are here first?
my lord, there are 7 respondent authorities.
Yes.
And then, my lord, the Cooperative Housing Society.
Who is appearing for the one? National Wetland Authority.
My lord, National Wetland Authority. I don't think anybody is appearing. I don't think anybody is here.
Nobody is appearing. State Wetland Authority. State Wetland Authority.
My lord is appearing because he's filed opposition, I believe.
You are appearing for whom?
Oh,
So that's
Because I'm
Milord
seeing
3.
that you're not responding.
State Wetlands Authority doesn't seem to be here.
So 1 and 2 are not appearing.
No.
3 you are appearing, you file the affidavit. Huh? I am coming on 7. So 3 you are appearing. You file. And what about the 4?
4 is not Ministry of Environment, MOEF, Ministry of Environment Forest.
And what about the
Not
5?
really. 5 is West Bengal Pollution Control Board. My learned friend is
5.
there.
6, Environment, Government, Department of Environment.
Milord
Nobody.
6 and 7, Milord, my learned friend would, Milord, both appear for.
6 you are appearing.
The both state, Milord.
Department of Environment and District. 9.
Private
Secretary.
6, 7 and 8 are state. State is represented. State is represented.
He's telling the 7. You are not appearing for the 6 and 8. No, that is the problem here. No, here is the state means state only the police. In this court, I find for the last 1 month,
Police is
state means only police. The other authorities are not the state.
Also appearing of the district magistrate on behalf of the district magistrate. And Department of Environment, Government of.
So, in my 6, 7, 8, you are appearing. Good. Yes. Then you are appearing for 9.
Yes.
Yes. No.
Conglomerate of Milord MLAs. Now, Milord, today, Milord, coal was, Milord, found to be a national, Milord, resource. Today, in today's situation, water is also a national resource. A water body having regard to climate change, etc., a water body is also a national resource. We can't, Milord, ignore the fact that environment, Milord, is very high on the list of the courts, Milord. And steps are taken to protect the environment, going over and above, Milord, all procedural shackles. Now, Milord, kindly have a look at the order. Milord, please come to, Milord, page 49 first. Milord, there was I'm not going back to the report, etc.
You're referring for GA or WP?
Milord, I am referring from the. No, where are we referring? Milord, I'll just tell your lordship, Milord.
GA Can 6.
Milord, I'm sorry, Milord, I forgot to write. Can 7.
Can 7. But I think the Can 6 is taken.
Can 6 is to be taken.
Yes, Can 6
prior
is to be
to-
taken. If that is disposed of, automatically 7 will come.
Your lordship was of that view. Your lordship.
Milord, yes. Milord, very well. Milord, may I very briefly, Milord, take your lordship to, Milord, the order of the NGT at page 38. Milord, the next matter also has the same annexures. If your lord.
Page 36.
Page 38.
Yes.
Milord, please come to page 40. Milord, paragraph 5. The NGT did not feel, Milord, that it was
Then I
necessary.
think it is not matching. Page 40 of the GSC Can 6 is different.
No, Milord, this will be Can 7.
Can
Milord.
7 then?
I'll just show.
Okay. Can 7?
Yes.
Your lordship, Can 6, mine page is also page 40, something different. Your lordship.
Yes. No,
It's
yes.
about a
Okay,
order.
let us.
Document will be
Document
very
is the same.
difficult to reply. Your lordship, kindly check. whether
Milord,
Can
very
6
well.
I find it.
Can 6 now.
Can 6 there.
Refer the Can 6, it will be good.
Yes. Milord, first is, Milord, the order of the NGT, Milord. Please have a look at page 31. Milord, years of doing, Milord, not reading briefs and doing matters without reading. Milord, I will have some benefit someday. Today, Milord,
I can take advantage of the fact that I'm used to reading from Milord an unmarked brief. Milord, please have a look at paragraph 2. This is Milord paragraph 2, second line. Averments in the application in brief are that the respondent number 14 to 22 Metropolitan Cooperative Housing Society and its office bearers and members are illegally constructing boundary wall on the bank of the water body since 17th October 15. Complaint was made to police station Pragati Maidan, no action taken. Further construction was again complaint made. Applicant has a license from the Fisheries Department. Such right is violated by the construction. So applicant has referred to news article under the caption Ukiler Bhedi filled up. This is a Ukil Bhedi, it's called. And there was encroachment, etc. Matter was taken up. Now, my lord, kindly come to paragraph 5. No interim order was granted in the hope, my lord, that status quo would not be altered. Then affidavits filed. Lord, please see paragraph 10. Lord, since my lord, they are opposing, I want to show your lordship their version before the NGT. The version of the respondent number such and such, the housing society and its members, is that they have not encroached upon wetlands. They have purchased 4.45 acres in Dag number 267. Lord, please note this Dag number, which is not a part of the water body. Reference has been made, Lord, to the KMC affidavit dated 3rd November 2017 that no construction was found at the time of inspection. In further affidavit, KMC has stated that it has accorded sanction for construction on 5th October, 1st September. Rejoinder has the sale deed. Now, my lord, please see paragraph 15. This is our contention. In violation of the order of this tribunal to maintain status quo, page 37, Lord, paragraph 15.
Yes.
Learned counsel for the applicant submitted that in violation of the order of this tribunal to maintain status quo, 16 houses have been constructed. There are 2 buildings of ground plus 2 and ground plus 4. On 8 floors, 2 houses each have been constructed. Construction started in 2018. 2 persons have shifted. And Learned counsel, next paragraph 16. Learned counsel for the project proponent submit that no construction has been raised in Dag number 268, which is a water body. Construction in Dag number 267 is outside the water body and not in violation of order of status quo. This is their stand. Lord, please have a look at page 40, paragraph 23. Paragraph 22, my lord, we consider it necessary to direct an 8-member joint committee of the National Wetland Authority. This I am told is, my lord, pursuant to some order of the Supreme Court, that in these situations, these committees are constituted by NGT and are sent to investigate. My lord, 8-member joint committee of National Wetland Authority, State Authority, Pollution Control Board, MOEF, State Pollution Control Board, and the District Administration. And committee, last line of the paragraph, committee may conclude proceedings within 3 months. And in view of our prima facie finding that the area is wetland and prohibition against construction is applicable, pending further action, no further activity be undertaken in the area in question. If the committee finds the construction are in prohibited area, the committee will ensure removal thereof for restoration of the wetland in question. Now, after this, my lord, nothing happens. Committee doesn't do anything. My lord, because they are very powerful. So, my lord, there is a writ petition filed. In the writ petition, my lord, the current writ petition, in the writ petition, my lord, please see the order at page 42, 29 September 2022.
Yes.
The petitioner is aggrieved by non-compliance of the concerned respondents of an order dated 3rd January 22 passed by the NGT. NGT directed 8-member. Petitioner claims to be leaseholder of the wetlands. Then, my lord, petitioner is aggrieved by non-functioning of the committee for 7 months and inaction of the committee to carry out directions. Then, my lord, next page, my lord, page 43, third paragraph. After hearing learned counsel appearing for the parties, this court is of the view that in order to ascertain whether committee has indeed failed to carry out directions, committee shall file a report bringing on record acts of compliance. The last paragraph made clear that pendency of the writ petition shall not discourage the committee from continuing with its business in terms of the directions of the NGT.
Yes.
Now, because of, my lord, this prod, my lord, the committee now comes with a report. My lord, please see, my lord, the report of the committee. That's at page 44. The next page.
Yes.
My lord, I want your lordship to see page 52 first. Oh, my lord, I'm very sorry, my lord. This is page 2. So, my lord, page 45. I'm sorry, my lord. My lord, this, my lord, shows the inspection of the site by the joint committee. My lord, page 45.
Yes.
Third paragraph, the joint committee inspected the site on 17th February at 11:30. Following facts have come up at the time of site visit. The present condition of Ukilbheri is low and marshy land with less water filled up with aquatic vegetation. There is no sign of pisciculture. Bheri water body stretches within parts of plot number, my lord, please see, 267, 268, and my lord, several plots. And this is, my lord, recorded in land records as Bill by paragraph 3. Then, my lord, there are few complete and incomplete new construction on RS plot number 268. One G+4 building and other buildings have been constructed recently over the filled up portion of water body of RS plot number 268 as per report of ADM. Who is he? Talking on the phone.
ये क्या है? Huh?
It's impossible. Milord, as per report of ADM DLRO, classification of the area in question is recorded as Bill. Few incomplete and incomplete new construction on RS plot number 268. One G+4 building and other buildings have been constructed recently over the filled up portion of water body of 268. Now important, Milord, paragraph 6. As per the report of ADM and LRO, South 24 Parganas, RS plot number 267, 268 were not converted by the district administration. South 24 Parganas. Then, Milord, please come to next page, Milord, third paragraph. At the end of inspection, joint committee decided that KMC would submit the following documents. These documents, Milord, are called for. Milord, inquiry continues, stop work notice, my lord, meetings, my lord, are KMC is very much a part of this, integral part of this, my lord. My lord, from page 47, your lordship would see, my lord, it's only KMC who's coming and giving information, providing this, that. Then, my lord, page 7. Page 7, my lord. I'm sorry, my lord, page 50, internal page 7. Third paragraph. An interim report was submitted by the joint committee before the Honorable NGT Eastern Bench on 25th of April 2022 with certain conclusions and recommendations, and further 3 months' time was sought to submit final report. As per ADM and DL and LRO's report, construction work on DAG number 268, which is Beal, has been shown as DAG number 267 in the documents given by KMC. ADM LRO has reported that DAG number 267 and 268 are classified as Beal. Both are classified as Beal. And Lordship recalls no conversion. How are you sanctioning plans? Yes. However, KMC could not submit supporting papers regarding land conversion of 267 and 268. How can plan be sanctioned? I ask myself the question. Just because, my lord, just because Shobhan Chatterjee was mayor of Calcutta.
Yes.
Then, my lord, KMC has lodged 2 complaints at Pragati Maidan. These are lip service complaints. Nothing, FRT done. Now, my lord, the classic is, my lord, 5. KMC officials claim that as per Kolkata Municipal Corporation Act, they do not require to check any records of the applied plot from the end of the BL and LRO to ascertain the land classification records. The Metropolitan Cooperative Housing Society lies in ward number such and such. And joint committee suggested that the cooperative should come to provide supporting documents. This is the situation. Now, my lord, ultimate findings, my lord, come to, please come to page 61. I'm sorry, my lord, 55. But it's impossible. What is going on? Middle of the page, 55. Finally, the committee unanimously took the following decisions. Plot numbers such and such have been created after 2013 by filling up of water body, that is Ukil Bheri. Hence, these plots, my lord, have been created. Hence, they need to be demolished. Then, KMC shall take steps to immediately restore the water body at plot number such and such in compliance with the order of the NGT. First thing, my lord, Mr. Ghosh is absolutely correct. First, go demolish. Then, after restoration of the water body, KMC, yes, after demolition and restoration of 2 is restoration, 1 is demolition. Then KMC shall take management control of the same in accordance with the West Bengal Inland Fisheries Act. Then KMC will demarcate Ukil Bheri boundary with concrete pillars and do geotagging with the help of ADM and LRO. KMC shall submit a compliance report with NGT. Now, my lord, very interesting. My lord, please see the date, my lord, of this. This is my lord 22. Today, my lord, we are going into 26. Till today, absolutely nothing in 4 years has been done by the KMC and by the authorities. That also, my lord, in spite of 2 orders passed by your lordship's court in this writ petition. Even then, nothing done. My lord, please have a look at 2 orders, my lord. First is dated 15th November 22 at page 111. My lord, what had happened was, we said that we wanted to take exception to one part of the report, which says take over the Ukil Bheri. Our, my lord, right is by KMC. Our, my lord, contention is that we are entitled to leases in respect of these lands. Plus, we also have a license from the fisheries department to, my lord, do pisciculture and, my lord, raise fish or whatever. License is now gone. But we say that we have certain rights, and that, my lord, can't be decided here. So only that part we want to, my lord, challenge. Yes, you demolish, you restore water body, do everything. After that, whatever rights I have, I have. I'll not want to challenge that.
Who are you?
I am a lessee in respect of, my lord, the Bheri, and, my lord, I had a license from the fisheries. All have gone. Everything holding over. I have to be evicted. Now, my lord, please see, my lord, 111. I'm sorry, my lord. Yes, page 111. Learned counsel appearing for the petitioner seeks to take exception to a part of the report filed by the State Wetland Authority. Such exception within 2 weeks. Now, my lord, the learned judge was cognizant of the fact that I was only going to challenge a small part, and implementation of the rest of the report should happen. Please see, my lord, the last paragraph. The authority shall be at liberty of implementing the part of the report and not be interrupted in their work by reason of pendency of the writ petition. This is my lord, direction 1 in 22 after report is filed. Report contains a direction on KMC. This honorable court in this matter, my lord, directs, my lord, implementation. Now, my lord, see implement, my lord, kindly see the next order, which is, my lord, 5th December 22. My lord, this is in this order, my lord, is dated 5th of December 22. It is not page 119 of Can 7. But may I just read out the relevant portion? Yes. As clarified in the order passed on 15th November 22, the authorities shall implement the part of the report with regard to taking steps against the illegal constructions in the meantime. It is made clear that the concerned respondents shall be at liberty of taking police assistance. So another direction on KMC.
Order dated?
This is dated 5th of December 22.
মেইন রিটটা থাকলে অর্ডার ফাইলটা খুললে আমি মেইন রিটটা যদি থাকে অর্ডার ফাইলটা
এটা বার করে নিয়েছেন
এই দেখছেন পিটিশন বক্স মেইন রিটটা নেই
Yes.
Despite these orders, my lord, they are very, very powerful people, my lord. They continue to make construction. My lord, please, sometimes, my lord, we wonder what is the situation. There is an embargo by NGT. There is a report from the committee. There is, my lord, orders of demolition from court. KMC, of course, will do nothing, but the sheer gall, they continue to make construction. So then, my lord, we come with, my lord, can number 3. My lord, for this, may I request your lordship to look at the can number 3 itself, your lordship can see, my lord, or it's annexed to, my lord, can number 7. We clearly say in this application that you are continuing with construction. And we clearly say that that's in
The construction.
cooperative. Cooperative.
And we take satellite pictures to show how much construction has happened.
Milord, this Milord cooperative which is bristling with Milord MP members and MLA members. No, councillor members, not MLA members.
Lordship, the cooperative is not a party also in this proceedings. Cooperative is not even a party to the proceedings, Your Lordship.
No, the 9 is what?
The secretary, Your Lordship.
Total party.
Perpetual body, it's cooperative is a perpetual body. And these plots are allotted to members. Your Lordship, this is just I wanted to clarify.
Possible. Now, my lord, again, my lord, order passed dated 15th of December 2022. My lord, this is again, my lord, we have annexed it at page 140, 139 in cans. An impossible situation. So, my lord, this is, I think, order number 4, which is the impossible situation, absolutely. Now, please see page 139.
There's the 15/12/2022.
Yes, this is Milord 15 December 22.
Correct.
Milord, please see the last sentence, second last line. The applicant, who is also the writ petitioner, has enclosed photographs which show that substantial construction took place between 13th November 22 and 20th November 22. It is relevant that this court passed 2 orders on 29th September and 5th December, giving liberty to the 8-member committee to continue with its work in terms of demolition of construction on certain plot numbers as directed by NGT. By the later order, respondents were given liberty of taking police help. Learned counsel appearing for the applicant submits that construction continues even after 20th November 22 till date. Court is of the next paragraph, Lord, third, fourth line, court is of the view that immediate measures should be taken for ensuring that no further construction takes place in the plot numbers in which the applicant writ petitioner is interested.
So now what you prayed for?
Demolition. You should.
In which application?
Yes, Milord.
In which application you prayed for demolition?
Now, Milord, I'll show your lordship.
The writ application.
No, we want enforcement, Milord, of the report.
In which application? A writ application.
Milord, please see
What is your writ application? What is your writ application?
Writ, Milord, is because of no Milord inaction on the part of Milord the committee. So this is Milord for enforcement of the order of NGT.
Correct.
So that Milord really also takes within its ambit.
So what is the prayer in the writ petition?
Milord, act in terms of the NGT order. NGT order, follow-up is, Milord, the report.
Correct.
First step is report. Report comes, now implement the report. So that is acting in terms of the NGT order.
So now your main writ application is for implementation of the order of the NGT.
NGT.
Read with the report of the.
Yes, report comes in.
Correct.
So, and report says demolish.
Correct.
So that's all that I want.
So why to 6 and 7?
Now they are not demolishing that plots, but they are taking over the management.
Now, please see 6. Please see how diabolical this is. Helpless. No, court is helpless. No, court is actually helpless. So many orders passed by Justice Bhattacharya.
I'm telling, because what you have prayed for, that has been granted by this court with regard.
Yes, but
now further what you want?
But-
If it is not been implemented, what the court will do? What steps you have to take?
Lordship will not direct something drastic like demolition, like asking the police to go appointing special officer to ensure that KMC will go and demolish today.
Okay.
If technical pleas, my lord, taken by my learned friend can defeat so many orders, that will be the end of the situation. My lord, please have a look at, now my lord, please have a look at the important issue. Please take page 173 of can number 6.
Yes.
Oh, I'm sorry, my lord. 16. Oh, wait, it is 164. My lord, please take page 164. I'm sorry, my lord. Yes. My lord, now KMC, my lord, who has been asked to demolish by the committee, by the NGT therefore, and also by this honorable court thrice. Now what do they do? Please see. Allow me to read this for your lordship. It's not very clear. Second, it has been
From
found
black
that
and white, you have become color.
Yes, my lord.
From black and white, you become color.
Colorful. My lord, on inspection, it has been found that the water body, description of which has been given, has been kept in ill-maintained condition, resulting in destruction of fisheries and environmental degradation. And whereas the owner, person in occupation, water body was asked to show cause through newspapers. The Lordship has ever heard show cause in newspaper? I haven't. Lordship has few more years of experience. Now, namely, Shongbad Protidin.
When I'm so heavily litigating.
Yes.
They don't.
I'm litigating, participating, going before committee, coming to court. They can't reach me. They are parties in my writ petition, which has my address. Show cause in newspaper. What more can I? Bona fide
intelligence.
Bona fide.
Not because they are not considered only you, they have considered the total public. That's why they publish.
Everybody will see.
Yes.
Now, whereas owners, persons in occupation did not take steps, and whereas for carrying out the purpose of the act, it has been considered necessary and expedient. Let's see this to take over management and control of water area, including its embankment. So what are they now going to do? Take me out of there by this notice. Once that happens, then they'll come and tell your lordship, where is the locus standi? Lordship remembers last hearing. There is no locus standi. You don't have locus. My learned friend's submission will be that you don't have locus standi to, my lord, raise any of these issues. However, I have locus to have corporation issue this notice to frustrate order number 1, order of NGT, number 2, order of committee, number 3, 4, and 5, 3 orders of this honorable court. Now he wants to take it over. Now what does he do, my lord? I've shown.
Who has published this?
The KMC. My lord, kindly see, there is no. He is directed to demolish, to restore the water body. He will not do. Now, my lord, whatever balance is there, he wants to take it over under the Fisheries Act, so that nobody can complain. KMC has to protect its mayor. He has to protect politicians.
Okay, I will pass an order. This you can take, but subject to file a report, all the things has been demolished and you acted in terms of.
I am for respondent number
Who
9.
is appearing for the authorities? Okay, let the KMC be made a party.
KMC is here.
We are
KMC is present before your
for 5
lordship.
minutes. Let me respond. I did not interfere.
I will.
Just
This is
allow me
between. This is only the court to see whether who is the necessary party.
Your Lordship.
This court is satisfied.
Your Lordship, one. Your
Let the
Lordship,
municipal
I am
corporation
also a
come
party in
before
this
this
proceeding.
court on the next day along with the report.
Your
And I will say that yes, municipal corporation take this land, but first you file the report that all the construction is demolished.
Lordship, this notice has not been issued in terms of the 8-member committee. It is
You are
under
not
7.
challenge. Have you challenged?
Your Lordship, I am the owner of the property. If I am,
Have you challenged
Your
this
Lordship,
notice?
I need not to. I am the owner of the Ukil Bedi. Your Lordship, I am the owner of the Ukil Bedi.
You are the owner of the Ukil Bari. Have you challenged this notice? Show me the writ petition. I will take this
Your
writ
Lordship,
petition. I will hear this
I
writ
have not
petition along
agreed.
with.
I am not agreed by this notice.
So
Why
you are
shall
not
I
agreed by the
I
notice.
have not agreed by this notice.
Correct.
Your Lordship, kindly hears me once before Your Lordship, before passing any order. I am just praying before Your Lordship to hear me for once. If thereafter, if Your Lordship is
My
satisfied,
only one question is that what is the harm for implement of the municipal corporation as a party respondent in the writ application? That's all. Nothing else. Nothing on the report. I am not passing any order on fact. Only you satisfy this court. What would harm you if the municipal authority will made a respondent party here? Give the answer to that.
Your Lordship, if my learned friend,
I am on. Please
If
don't allow me to make further thing.
Your Lordship,
Only you give the answer to the question of the court. You satisfied this court. What harm you will face if the municipal corporation will made a party to the.
it is in effect, Your Lordship, enlarging the scope of the writ petition.
Okay.
Kindly sees what was the prayer. Kindly sees what was the prayer of the
Leave
writ
aside,
petition.
I am asking you, what harm you will, that the court will say whether the prayer will be allowed or not. Only the question is that at this stage, this two application for implementing the municipal corporation as a party. So this court find that the municipal corporation is the necessary party, and what harm if the municipal corporation is made a party? Can you give the answer to the? If I will satisfy, I will dismiss the application. That here you know.
Last occasion, we had taken the point of mentability,
Correct.
which was considered by Your
Mentability
Lordship
with regard
of
to
Can
what?
6. Of Can 6.
Ah.
Of Can 6.
Yes, I satisfied that it is a maintainable. Because after going through all the
without
reports.
hearing the Lordship.
Yes, I will record. I have not given an opportunity hearing. You challenge this.
Your Lordship, kindly bears with
Because the court time is very precious. If the court satisfied.
Your Lordship, I was not even given a time to.
Yes, I will record. I have not given a hearing to you because the court is satisfied that the municipal corporation is a necessary party.
Your Lordship, if the municipal authorities comes in, Your Lordship, it will be helpful for everyone, Your Lordship, and it will be great.
Correct. Why your site of municipal corporation could come before this court?
This will in effect make this writ petition maintainable. Your Lordship kindly reports that irrespective of the fact that this writ petition is maintainable, Your Lordship is allowing the KMC to be added as a party. I am not.
I will decide that after the municipal party will be party.
Your Lordship kindly sees the notice which they have relied. It is under the 17A of the Inland Fisheries Act. Your Lordship, that is the KMC authorities have been empowered to act as a competent authority under the 17A of the Inland Fisheries Act. This is not under the KMC Municipal Corporation Act that the KMC has taken over the water body. And Your Lordship had rightly pointed out, who is he? He has time and again said that he is the lessee of the property. If Your Lordship, he can show a single paper that he is the lessee of the property. I am saying that I will not open a mouth. Your Lordship adds KMC as a party now and now. Your Lordship kindly asks them to show a single paper that they are the lessee of this property. Kindly sees what fraud they play. Kindly sees one order, Your Lordship, which they have relied. Kindly sees. I may be always thrown out of the court, Your Lordship, but kindly hears me what I am just wanting to point out. They will show one after another fraudulent orders, and thereafter take orders, and thereafter in the subsequent proceedings, kindly see page 42, which was relied by them. Kindly see.
Yes.
How they maintain this writ petition?
Yes.
This is the first order passed in this writ petition. Your Lordship, kindly sees. The petitioner is aggrieved by the alleged non-compliance of the concerned respondent of an order dated so and so passed by the NGT. By the said order, the NGT directed the 8-member joint committee of so and so and others to determine the factual position about the status and extent of the wetland and whether the prohibition against the construction applies to the area. The petitioner claims to be leaseholder of the wetlands. Your Lordship, this was how they maintained this writ petition. Their locus was that they are the leaseholder of the property.
Okay.
Till now, in the
Have you challenged this order?
Your Lordship,
Have you challenged this order?
this proceedings is pending before Your Lordship.
Correct,
It
but
is
you
not-
were telling that this is the wrong submission recorded or this is wrong thing. Have you challenged this
Now,
order?
now may I say one thing, Your Lordship? At that point of time, also, it fell from the Lordship, the coordinate judge who was presiding, Your Lordship, that what is the harm if the report is called from the NGT,
Correct.
from the 8-member committee. Now, when Your Lordship is now of the opinion that what prejudice will be caused if the KMC is added as a party,
Correct.
it means that I have admitted to the maintainability of this writ petition. This will in effect do the same thing.
I will pass an order. I will pass an order. Mentality is kept up open.
Your Lordship.
I will pass an
Your
order.
Lordship,
Mentality is kept
and
open.
Your Lordship, only one thing. Your Lordship kindly sees the 17A once, and thereafter Your Lordship asks them to produce the lease deed. Because once and again, every time I am the owner of part of the 267, they are claiming themselves to be the leaseholder.
So as per
Is it not a fraud to the court?
what is the document? The 267 is not a bill land.
Your Lordship, it is not. The corporate, the
I will challenge the order of the NGT.
Your Lordship, the NGT did not say that it is a wetland. Your Lordship, the NGT is prima facie, kindly sees. That order also kindly sees once. What is the NGT's order? Kindly see.
Have you filed the exception to the report?
Yes, Your Lordship, that is.
Where is the exception?
That is pending before NGT. That is pending before NGT.
What is the report? You show me. Since beginning you are appearing. Where is the report you brought? Exception you brought here.
Demonstrated in opposition of respondent number 9.
You the
The CAN application, Your Lordship. Kindly see.
पीछे देखो, पीछे देखो.
My affidavit in opposition.
नहीं है.
Your Lordship knows that firstly it was CS, thereafter RS. RS was prepared in 1955. There was LR, thereafter LR plots came into effect. Now, if I show the LR records of 1955 and say that it was Bill, and thereafter when the LR record says it is Bastu, and it will be not considered and we will be prosecuted in this fashion, Your Lordship, then it is very difficult to save my client, Your Lordship.
That is the problem. See.
Kindly seize, Your Lordship. The NGT members were not aware of, Your Lordship, that the after RS.
That's why you cannot fight with the administration and you cannot fight the main person, the Patwari or the revenue officer of the revenue record, because I am telling, I am personally experienced. You cannot challenge the report of the Patwari or the revenue officer. Today they will give, yes, this courtroom is in the survey number, plot number 255. If tomorrow they will create, this is not 255, these are 244. I have good experience with this authority.
Nowadays, Your Lordship,
and I know how it is to be prepared. If you will give the record, within 15 minutes, I will trace out how this has been done.
Your Lordship, it is now digitally available in Bangladesh.
Digitally has come subsequently, sir. Don't come to that. Digitally, I know, digitally, the map cannot be corrected to the digitally.
Your Lordship, that is what I am saying. The map of 1955, Your Lordship, kindly sees one thing. This bill, any property, Your Lordship, changes its character. In 1955, in the RS records, it was recorded as bill. Our cooperative society is not of 2025. It is of 1970. We had purchased the plots in 1970 when there was RS operation. Thereafter, LR operation came in. The LR record says.
So how you can declare the title in the writ proceedings?
Your Lordship?
How you can declare your title in the writ proceedings?
Your Lordship, that is what, when they are not sick, they are claiming that they are the leaseholder. They have not come in a PII.
Leave aside that. You are telling that you are leaving aside that. You are telling that you are the owner of the property since 1948 or
1970s.
1970. Correct. And society was formed and you have purchased the land. So you might have been having the document. So you are the person, you have to prove your title of your own evidence.
Your Lordship, I have
Correct.
to.
So where you will prove?
Your Lordship,
which court you will prove?
NGT proceedings, Your Lordship, kindly appreciate for once. The writ proceeding was filed only to the aspect that the 8-member committee has not taken any step. When the order was passed, Your Lordship, by that time already the 8-member committee had passed this order. That was also suppressed. Kindly cease for once.
Okay, okay, leave
Now-
aside all these things. This land, who is constructing the house over the property?
Your Lordship, in 268, no construction is being done. The KMC authority, acting as a competent authority under the Inland Fisheries Act, is trying to save the water body, to preserve the water body. What they want to do is now, these persons want that water body to be dried up so that they can sell it off to the third parties. They do not have any locus. What will be the harm if the competent? Your Lordship, kindly appreciate. In districts, there are competent authorities of the Fisheries Department who act as a competent authority under the 17A of the Inland Fisheries Act. In Kolkata Corporation areas, Your Lordship, 17A, the notification says will be acted upon by the PNU of the Kolkata Municipal Corporation. So in this case, KMC has not acted under the KMC provision of the Kolkata Municipal Corporation Act. It has acted upon the provisions of the 17A of the Inland Fisheries Act. And Your Lordship, there is a coordinate-based judgment of March 2025 which says the owner can only challenge the 17A of the Cooperative of the Inland Fisheries Act. They have not been able to show any right title interest document. Your Lordship, no harm will be caused if the KMC has added as a party. But what will happen? Again, same kind of situation that the matter was taken up in 2022 when they had said that they are the leaseholders, and the court was of the view that even if they are the leaseholder or not the holder, if the report is filed, what harm will be caused?
Correct. Let the municipal authority come on record. Let they file the report. Let this say what you are telling. You are telling they are not the leaseholder. They are telling you are not the owner.
Let them
Municipal corporation is telling that this is our property. They are maintaining. Let. So let the municipal corporation come. Let the municipal corporation file the report or affidavit. All the things will be clear and all the party will be heard.
Only one thing, Your Lordship. Today also 3 times they have uttered the word that they are the leaseholder of the property. Your Lordship was also of the view, pointed out that who are you? They said that they are the leaseholder of the property. If Your Lordship today they can show that they are the leaseholder of the property, I say that Lordship not only just appoint add the KMC as an authority, also impose cost upon us. Also impose cost upon us because we have wasted Your Lordship time. A person cannot play fraud upon the court and take orders, Your Lordship. That was our point of mentality taken in our writ petition, that they are going on enlarging the scope of the writ petition. The CAN 5 application of the coordinate bench, kindly seize the order which prompted us to file written objections. Kindly seize. This is Your Lordship. Kindly seize. Order is off. Lordship, this order is off. Of the coordinate bench, Your Lordship.
Affidavit क्यों नहीं आ रहा है यहाँ में?
Your Lordship, kindly seize the order dated 8th of August 2025. Kindly seize the order
8th of August 2025
of the coordinate benches. Your Lordship. There is order of Supreme Court. The matter is now being considered by the NGT. There cannot be parallel proceedings in teeth of each other, Your Lordship.
Yes.
Kindly seize the order. Mr. Acharya so and so, certain subsequent developments has been filed to bring certain subsequent developments or events to the notice of this honorable court. According to Mr. Acharya, in order to render complete justice, the application deserves to be allowed. This was for serving the application to the KMC. He further submits that the applicant has also averred in the application that the KMC ought to be implemented as a party in the writ petition, as its presence is necessary for the effective adjudication of this list. At the outset, Mr. Sen and Mr. Sureka, learned advocate, appearing for respondent number 9, conjointly submitted that this application is not maintainable in its form. Mr. Sen submitted that by filing this present application, the petitioner seeks to enlarge the scope of the list, and the subsequent events which the petitioner wants to bring in to the notice of the court have given rise to fresh cause of action. The petitioner can maintain a fresh cause action before the appropriate forum. He further submits that the avertments made in the application suggest that the KMC adopted a policy, and in furtherance of that policy took over the subject matter of the present writ petition, namely a water body for certain purposes. Mr. Sen submits that the prayer portion amended to the application indicates that all prayers or relief sought by the petitioner are ancillary to the incident of the corporation taking control of the water body. He submits that unless the action of taking over of the water body is challenged, the petitioner cannot claim any relief, consequences relief thereto. Lastly, he prays to leave for leave to file affidavit in opposition. So, Your Lordship, we had pointed out this is a fresh cause of action. Now, why we say so? Why we say so? Your Lordship, kindly seize the prayer of the writ petition. Kindly seize the prayer of the writ petition.
One thing I should have told you. In fact, I was told KMC is building a road through the Bhedi.
Page 22. Page 22 of
This will now, by the time all this charade stops, there'll be nothing left.
New road, absolutely.
New
Yes.
road.
kindly see page 22.
Yes.
A writ in the nature of certiorari to do issue directing the respondent authorities and each one of them to forthwith certify and transmit to this honorable court all the records and documents pertaining to the action taken by them in compliance of the order dated so and so. So that justice may be done so and so. Then C is who were supposed to act as a nodal officer to forthwith constitute 8-member committee. They were of the view, despite having got the notices from the 8-member committee to appear before the 8-member committee. They were aware that 8-member committee has taken cognizance of the matter. They did not appear before the 8 members committee, and thereafter they complained that 8-member committee has not taken any steps. Your Lordship, this order was passed on 29th. The first order in this writ petition was passed on 29th of September 2022. Kindly see page 42 of the CAN application. Kindly see.
Yes.
Page 42, last 3 lines, Your Lordship.
Yes.
The petitioner is agreed by the non-functioning of the committee for 7 months from January to September 2022 and inaction, Your Lordship. It is in 27th of September 2022. Correct. Now sees the report which has been relied upon by them, the 8-member committee's report. Kindly sees the page 55, Your Lordship.
Yes.
The report, Your Lordship, the second last paragraph.
Yes.
Page 55, Your Lordship. The report of the final meeting. The report of the final meeting held on 27th of 7/2022.
Correct.
So they played fraud upon the court on 29th September 2022, indicating that no action has been taken by the committee. Whereas by 27th 7/2022, committee had already taken the steps. Thereafter, steps were again taken on 8/9/2022.
Yes.
This report was only filed before the court as the court had asked. Now, by showing this report, thereafter they didn't, at that point of time also these things were there, that who is going to take the management of water body and what will be the procedure, who is going to demolish. Since 2022, they did not take any steps to implement KMC as a party to the proceedings. Since 2022, they did not do. Now, after the KMC has taken over the water body, acting in 17A of the Inland Fisheries Act, they are claiming that they are the leaseholder of the property. And now they are wanting to get the KMC added as a party without deciding the maintainability of the application, Your Lordship. What we are saying is that, Your Lordship, they have all remedies. They can challenge the Inland Fisheries Act. Kindly sees the section 18 of the Inland Fisheries Act.
Where your maintainability is kept open.
Your Lordship, kindly sees.
In the first order, whether you have taken the stand, the maintainability. So when you have raised the point of maintainability.
Your Lordship, it is in CAN application.
No, not CAN application. We see. It is settled law only very first day when the writ petition is admitted, then you have to take the plea of the maintainability. In the mid of the, you cannot take. Okay, you are taking the maintainability of the 6th, that is different thing. Have you taken the maintainability? Because there are several orders passed, you have not challenged that order. Can now in the mid of the session, can you say that writ petition is not maintained?
May I indicate one thing, Your Lordship? At times it happens, it is very difficult to go beyond what is falling from the judge.
Once the advocate has accepted the brief, he should be conscious from the first day when he's appearing in the court.
Your Lordship, what happens is,
but you cannot say, no, sir, I was not aware. Now I aware that it is not maintained. It's not the law.
I am not at once saying, Your Lordship, that I am saying that we have not challenged this order or we have challenged the order. What happens is, Your Lordship, at the time when a suggestion is given from the bench, Your Lordship, we at times accept that. But when we see that this suggestion is being misused time and again, Your Lordship, then a time comes, then each and every point has to be hampered. Today also, Your Lordship was of the view that KMC to be added as a party. I had to interfere because if this thing happens today also, and this order will not be challenged by me, thereafter the same plea will be taken that as KMC has been added as a party, now you pass an interim order. Now Your Lordship will be bound to pass an interim order. This is the difficulty. Kindly sees, Your Lordship decides the maintainability of the CAN application. If Your Lordship sees that
I will decide this.
Fresh cause of action can be challenged, that is the taking over of the water body. Kindly sees the 164 page, that is the 17A notice. Kindly sees. And the Inland Fisheries Act for Your Lordship, the notice, though it is illegible, Your Lordship, it speaks of the 17A of the Inland Fisheries Act have been invoked. It does not say that this taken over of the water or body.
See, with regard to the notice issued by the KMC, and this court is not going to decide. This court is only to whether the CAN application filed by the petitioner with regard to the implementation, only not this. This is the notice on the basis of this. The court has filed several orders, and in part there is an allegation that the KMC is continuing with the construction work, allowing the construction work, making some orders. So that's why he is the necessary party. With regard to the mentality of this notice and all these things, you have a other cause of action. You can take recourse of that.
Appreciate one proceeding challenging. We have challenged the order of the 8-member committee before the NGT. Affidavits have been filed. The date is fixed. If your Lordship today, being a superior court, directs implementation of this order, of the 8-member committee's order, what will be the effect of
CAN 6 is not with regard to the implementation of the order. CAN 6 is only for the implead the KMC as a party. They are not asking for implementation of the what is
the entire arguments are made that they have not implemented the
that's why the KMC is required to be made a party.
Your Lordship, two parallel proceedings where the KMC is a party in the NGT proceedings, where the entire 8-member. Your Lordship.
So then again the matter come to zero. The writ petition was filed 2022. You have not challenged that all the orders passed by the now at this stage when they have filed an application, you are taking all the pleas.
No, Your Lordship, we have taken the point when CAN 6 has been filed. If Your Lordship,
that's why I will decide the CAN 6 is it maintainable, then the KMC will be added as a party. If it is not maintainable, automatically it will be dismissed.
CAN 6, Your Lordship, has been filed challenging that the taking over of the water body is illegal.
Because you are telling that you are authority, but you are not taking any steps.
So you have to,
but only by making as a party, you are making the objections for the sake of the objection, allowing the KMC to continue with the construction work.
Your Lordship, it is upon a submission made by my learned friend that he is the lessee. If Your Lordship says
again, I am telling us this court is not going to decide that court already. There is an observation. This court is not going to decide who are you. This court has to decide whether because admittedly today as on record the writ petitioner is a petitioner. They are the petitioner.
Is a petitioner.
They file the writ petition. They have a right to file an application. Who should be party? Who should not be party? They choose that yes.
With a fresh cause of action.
So that's why that is to be decided by this court.
This is what we have taken the point that this is a fresh cause of action. They can very well challenge it under Section 18 of the Inland Fisheries Act. Kindly seize the Section 18 of the Inland Fisheries Act.
Show me.
Kindly seize the Section 18 of the Inland Fisheries Act.
One way or other way, if you wanted to drag the matter, then I will pass an order to competent authority. I will appoint a special officer. No construction should be made. Complete that.
It should not be. If
then you are one, so you are not saying that no construction should be going on. One hand you are telling that the KMC not be a party. One hand you are telling that you are not the authority. What you want? What is going in your mind?
My mind is very clear that the restoration of water body should not be
to allow the illegal construction over the water body.
Water body should not be the restoration of water body should not be halted, Your Lordship.
So that's what the court is telling that the construction court is telling that if any construction, let it be demolished.
Kindly
or no construction should be made over there.
Section 18. Kindly fix Section 18.
Show me.
Kindly fix Section.
You are not coming on any of the way to.
By taking one order, Your Lordship, whatever events will come in, they will club it in this writ petition. This is also
Since
not
2022, you are sitting straight over the matter. Now you are. What steps you have taken?
Show
me what steps you have taken.
Today I am not accompanied with that steps. I did not. They are party to the proceedings. Ask them whether I am not taking steps.
He is not challenged the report.
Impose cost that I have challenged the 8-member committee.
The court is not interested to impose pause or anything. Court is only interested with regard to what is the matter before the court that is to be decided. That's all. But the court has to observe this, the attitude of the advocates who is appearing for the parties.
Your Lordship,
the court, the advocate is the officer of the party. The advocate should not be biased in any of the way. You are appearing for the. You can say anything, but you from the record. You're not ready for the KMC to be a party. You're not ready for the appointment order, issuance of the order. You're not ready for the appointment of any commissioner. So what do you want? You want that only the case may go and the KVMC continue with the construction of the property.
Your Lordship,
Nobody is entitled. Neither petitioner is entitled, nor the KMC is entitled, nor any society is entitled. You are the only owner, but you will not take any steps.
Your Lordship kindly indicates one thing. If
What steps you have taken to declare your title?
Your Lordship,
What steps you have taken for declaring your title of the property? Show me.
Your Lordship, a person who is fraudulently saying that I am a lessee.
Again, you are coming. Yes, a person is telling he is a lessee, and you are telling him he is fraudulent. What steps you have taken for declaring yourself as a title holder of the
Your
property?
Lordship observed that he is a lessee. Your Lordship was made to observe that he is a lessee without looking at the document. Kindly allow him to show a single document that he is a lessee.
Sir, that has not, again and again, the court cannot repeat. You have not challenged that order. Unless and until the order is not challenged, that order remains an order.
This is not a PIL, Your Lordship, that anyone without having a locus can come in.
You are again not in, the order is passed 2022. Have you challenged? Let the order set aside. Yes, the submission is incorrect. So the court has to go by the earlier order. The court cannot give the other observation than the order which is already on record.
Which can application I have taken this point?
May I take? At one point of time, because the fact remains as per the order of the my lord NGD, at page number 31, 32 of the my lord, the can application number 6, any order, but any my lord, any order means this order may be annexed to many page number 31 is the my lord, the order of the NGD of 3rd January 2022.
Correct.
Then my lord, the second page of the order running page 32.
Yes.
My lord, in the middle portion of paragraph 2, it has been mentioned that the applicant has a license from the fisheries department. As per their, my lord, I think averment in the petition filed there, that they were the my lord of
Licensee holder.
license. Such right is violated by the construction. So it was the case. Not the petitioner was a licensee, their such right was violated or infringed because of construction. Now, who has given the right? Fisheries department. Now, order is of my lord 2022. Then the third paragraph, kindly come. Matter has been considered by this tribunal in the last about 6 years by several orders. So it is evident that when this order was passed in 2022, the claim with regard to that they are my licensee from the fisheries department prior to 6 years prior to 2022.
Correct.
Now, fisheries department is not a party in this proceeding. If your lordship so kind enough, I think, for my lord, the proper adjudication in the matter, including my lord, the right also, corporation's right, petitioner's right, they say their right. Everybody is coming and claim that I am the owner, I am in possession. I think, lordship, apart from corporations, fisheries department should be also made a party, direct them. Let the fisheries department should also come. And then all angle, all aspects should be, my lord, I think would be clear. This is only my submission today.
You are appearing for?
But I appear for matter 6, 7, 8. Huh? 6, 7, 8. Department of Environment, Government of West Bengal, District Magistrate, and Senior Superintendent of Police.
Okay.
Your Lordship,
This is my answer.
I was
At least two.
I was showing Your Lordship section 18 of the Inland Fisheries Act. Kindly cease for once.
Yes.
Your Lordship, 17A prescribes the procedure in which notice is to be given to the owner before taking over of the water body.
17A?
17A of the Inland Fisheries Act. Your Lordship will recollect that the page 164 speaks of page 164 speaks of 17A of the Inland Fisheries Act.
Yes.
Your Lordship, this notice was issued under 17A.
Yes.
Competent authority in respect of Kolkata Municipal Corporation area is the KMC.
Correct.
Now kindly see the section 18 of the Inland Fisheries Act. 17A says that the owner to be heard before taking over of the water body.
Correct.
They are not claiming themselves to be the owner. Rather, I say I am the co-owner of the Ukil Bedi and I am not agreed by this takeover.
Correct.
Now kindly see section 18. Kindly see section 18.
Yes.
A statutory provision has been provided to appeal against any takeover.
Correct.
This order is of May 2025, Your Lordship. Prior notification,
order?
this taking over of order of 164, this notice possibly, is of May or June, Your Lordship. Kindly see
64.
page 164. The taking over, which they are agreed with.
Achha, this one.
This one.
Okay.
So it's dated back in May or June 2025. They had the scope to challenge it before the appropriate folder under appeal section 18.
Yes.
Now what they are doing is, as because a writ petition is pending, whatever is happening in the entire area, they are filing one after another application in order to frustrate our relief before the NGT.
Correct. But they have not challenged this notice in the writ petition or in the can
Your Lordship, they have challenged. Kindly seize.
Where?
Kindly seize.
Where?
Kindly seize page 28. This is what I wanted to show. Page 28 of the can application.
Can application, how the court can grant that?
Your Lordship, they have challenged.
Maybe
Let
challenge.
them not press them. Ask them to not press what they are doing. Next day they will come and tell that Your Lordship has indicated the KMC to be party. Now pass an interim order.
Where is the order? Where is
Your
the
Lordship,
prayer?
prayer B.
And on stay 164. What is the date? Yes.
So this is the way they are going to harass us. Now what will happen is, Your Lordship, the NGT proceedings are there, where 8-member committee's report is under challenge. We have taken our exception, and I am with great reliance saying that we have taken exception to the 8-member committee's report. Now if Your Lordship proceeds with the 8-member committee report, maybe we are at fault, Your Lordship. It may be. The portions which are required to be demolished will be demolished. But I cannot be prosecuted unheard. And I cannot be prosecuted in two forums at the same time. When the NGT is the order, Your Lordship, they have obtained order from the NGT. At the time of implementation, they are coming to the High Court. When again they are not getting any order, they are going back to NGT. They are contesting in NGT. They are parties in the NGT. And these NGT proceedings have been started with the orders of the Honorable Supreme Court. When the Honorable Supreme Court has said that the matter be relegated back to the NGT, then why should I come forward before the Lordship?
Again and again, the one question is coming in the mind of this court.
Your Lordship.
You are making this submission since beginning. 2022 writ proceeding initiated. Several orders has been passed. You have not raised any question of maintainability till date. Not 6 is you maintaining them. You are raising the question of maintainability. Okay, the court can understand. Now you are telling the court has passed an order. I have given up and all this.
Your
Whether
Lordship,
this court can go back to the order passed by
What was
the
the
earlier.
limited prayer in the writ petition? Kindly see, the limited prayer was that non-functioning of the 8-member committee allow them to function.
Correct.
Once the report came in, Your Lordship,
Correct.
the relief for which they had come before this honorable court by which this writ petition was accomplished. Now, Your Lordship, this can application is a fresh cause of action if any takeover has been taken under 17A. How can this fresh cause of action can be related to the earlier orders of this honorable court?
Kindly show me whether they have prayed for amendment of the prayer in the writ application by adding this prayer. Show me, then the fresh cause of action would arise.
Your Lordship,
Have they made any application in this can 6 or can 7? They wanted to amend the prayer by setting aside this order. Maybe can, but it is settled law in the can. The interlocutory order cannot be passed in the, by setting aside anything. It has to become in the writ application. Show me any order, any prayer in the can 6 or 7. They wanted to amend the prayer of the writ application challenging this note.
Your Lordship, these are the prayers they have made in can 6.
Prayer made in the can. That is up to the court whether the court will allow or not. Now only they what is their prayer now? Now only they want that the KMC should be made a party. Once the KMC should be made a party and this can is disposed of, how this you can say that this is a new cause of action. They have not prayed for any relief, that this prayer is to be added in the writ petition as amended writ petition.
If they undertake, Your Lordship, they are not pressing for any other orders. Only they want this KMC to be heard before, Your Lordship. I have no objection. Kindly ask them. Kindly ask them to make such prayer. Their intention is to stay the order, Your Lordship. Now, kindly ask them.
Yes.
Kindly, implement Your Lordship's court's orders in
Correct.
this writ petition.
No, only you say.
That's all, my lord. What else do I need? That's all. 15 November 22, 5th December
No,
22.
that,
There are
that's
two
why
orders.
Now he is now the
Milord-
only one point, the
Milord-
player B.
Milord, kindly, Milord, do not indulge him more. He has argued for 1 hour. Though, Milord, he is not appearing for the Kolkata Municipal Corporation. Kolkata Municipal Corporation, Milord, has been served. They are aware. If they want to oppose, Milord, they could have easily opposed. They have not done so. Some private party, Milord, regardless of the fact that the private party constitutes the mayor of the corporation, Milord, he is not entitled to say all this. Please do not indulge him more. Please, Milord, add KMC and protect the water body.
With regard to the fisheries department, what is your
Milord, state has been served. If they feel that they are better subserved by some other, Milord, department, they will bring that department. Milord, department wise, there is no reason, Milord, to add. And Milord, the whole issue is decided 15 November 22 and 5th of December 22. Kindly, Milord, enforce those orders so that, Milord, this people don't have so much of confidence anymore.
May I indicate one thing, Your Lordship? Only one thing. Your Lordship, this prayer A is to serve upon the KMC. Your Lordship, at
Sir, I have served them. Let's not, there's a limit. Your Lordship's patience is remarkable.
If Your Lordship feels.
Hearing concluded with respect to the can 6 and 7 for orders.
Grateful to your Lordship.
My lord, one.
My lord,
My lord, one small indulge.
I am keeping this.
Yes.
I am keeping this.
My lord, may I have my lord's leave, my lord?
Point of integrity. So grateful, so grateful.
Just, my lord, 30 seconds, my lord, I would be troubling your lordship, not more than that. My lord, there is urgency in the matter, my lord. Lordship is overburdened with matters, my lord. I am praying, my lord's leave to move it, my lord, on Friday.
But
I tell you, lordship, petitioner, my lord, got married with the private respondent number 6. He is going to retire, my lord, any day in January. In between that, he has married again. And my name has not been recorded in the service book. Despite letters, nothing had happened.
Department?
Huh?
Which department?
Railway department, my lord.
Go to the
No, my lord, it's a residuary, my lord, miscellaneous. That,
tribunal.
my lord, this will not come under within the. I will satisfy your lordship. No, this claim will not be within the four corners of the railway tribunal, my lord. I will satisfy your lordship, my lord. I will satisfy your lordship. This claim.
Segregated what claim?
No.
The tribunal, once the department has been notified with regard to good.
I tell you, lordship.
Jurisdiction, so it cannot say that this claim is the tribunal. This
Lord, I tell you, lordship, what is my prayer? My prayer is, my lord, to entry my name in the service record so that I can get the benefits, number one. And there was a court's order, my lord, court's order directing me to pay maintenance, which has not been done. Now, if he draws the salary, my lord, nothing will happen.
Hey, Mr. Day, you are the senior person on
I know, my lord.
In the civil side also. If the wife is claiming and there is a dispute, you know what steps is to be taken.
I know, my lord.
Wife, how the report can decide?
My lord, I tell you, lord, I will satisfy your lordship. Give me 5 minutes time. Let them, my lord, consider. My representation has not been considered. An admitted fact, I am the wife. I will satisfy your lordship. Not more than 5 minutes on Friday. If lordship thinks that I have to go to tribunal, I will go to tribunal, my lord. He has no money. She has no money, my lord. Kindly, my lord,
retired?
In January. I don't know the exact date. We have 5 days time, my lord.
See, when is going to return? Because Monday, Thursday, Friday.
My lord, first week of January, I am told, but I am not sure, my lord. I am not sure.
No, in the government servant, either it is only 30th.
Very well. That, my lord, I do not know. But kindly, my lord.
Not like us.
Kindly, my lord, takes it up, my lord. Kindly, my lord, takes it up on Friday, my lord. I will not trouble your lordship more than 5 minutes. If lordship feels I have to go to tribunal, I will go to tribunal.
5 minutes over.
Yes. So, my lord, kindly, my lord, grant me leave, my lord. Kindly, my lord, grant me leave, my lord, so that I can come back on Friday, my lord.
Hey,
It's an appellate side, my lord.
Tuesday.
My lord,
Tuesday, my lord, will be all. Kindly, my lord, makes it Monday, my lord. Then, my lord, Monday.
Urgent motion.
lord,
Grateful to your lordship. Grateful.
my lords, item 32 of my lords list, my lords, for extension of interim order. My lords, today is the last day, my lords. 32, my lords. My lords, it's the
32.
My lords, item 32, my lords. My lords, Amit Mines. Appellate side, my lords.
32.
Item 32, my lords.
It is still today.
It's still today,
What is
my
the order. You are having the order.
My lords, I have it on my iPad, my lords. Right here.
My court officers have left.
Apologies, my lords. I couldn't hand over a physical copy, my lords. My lords, if my lords wants the main order also, I can.
till 17.
If my lords, it could be in to be mentioned tomorrow, my lords.
Because tomorrow, today is the last.
My lords,
Then
today
it
is the
will be a
last.
difficulty, the appellate side. Original side, it can be managed.
My lords, you were waiting for it to be called. That's why we didn't bother, my lords, in the morning, my lords.
Okay. तो जो भी है ना, item number
32, my lords.
item number 32. इनको बोले ऑर्डर करना है, इंटरिम पहले का ऑर्डर देखे, इंटरिम ऑर्डर इज एक्सटेंडेड टिल 22 जनवरी or until further order whichever is given.
Grateful, my lords, grateful.
Yes, that's right.
My lord, appellate side list, my lord, item number 171, my lord.
Yes, original, call the original.
My lord, may original side matter, my lord. My lord, my interim order is expiring on the 19th of December, my lord. I'm requesting if this can be taken up under the heading extension.
18th of, to be mentioned, correct.
Lordship, may I-
Very good, my lord.
May I have your lordship's leave to mention a matter? It's listed today pursuant to your lordship's leave granted. The electricity connection was illegally disconnected. My tenant is a UCO bank. On 12th of December, disconnected by the maintenance society, and we have filed a writ petition. Lordship has granted. It is listed as item number 177 today. Lordship, 177, last item of today's original side list. Lordship can be taken up today, if not tomorrow, Lordship.
आज क्या है हम लोग का original side है ना?
Original side list.
Tomorrow it will come.
Lordship, it's already listed today. Upgrade. Last item.
May I be permitted to mention one letter for inclusion in the list of daily list?
March 2026. March 2026, you will get the birth of listing the matter. Not before that.
Not before. But my lord,
Till February.
degree for the principal amount has been passed in my favor.
So what
The
you pray?
Claim for the interest has been delegated to the suit.
Interest you take March, because March is the ending period. New financial year will come, then you will get the interest. Come in the March, yes. Call the list.
My lord, item number 1, CS 77. My lord, no correction, my lord. It's
CS 77, no
yes,
correction.
no correction. It is perfectly fine. My advocate on record was misinterpreting it. I explained to him that it's perfectly fine. 79 only.
Because the calculation.
Yes, my lord, he was unable to understand it. 79, my lord, however, my lord, there's a typographical error.
79.
If your lordship will, my lord, take the order past.
Yes.
No, my lord, kindly see, my lord, the copy that I have handed up. Please see page 8.
Yes.
Page 8, the last entry, Roman 16. Lord, per annum on rupees, it should be 10 lakhs, not 1 lakh. Your lordship will just kindly cross-check this, my lord, with, my lord, the judge's brief of documents. The bank statement was, my lord, annexed. The entry is there, my lord. Kindly see the date, 1st September 2017. It is 10 lakhs. It is written in international style. 1,000, that's why perhaps, my lord, there's a slight typographical error.
That is only.
That is all. That is all, my lord. So I then gain by 9 lakhs.
Item number 2. The matter is listed as to be mentioned for correction in the judgment passed by this court dated 12th of September 2025. Counsel for the petition draw the attention of this court to the order dated 12th September 2025 at page number 8 within bracket X16, small x16, and submit that the amount is to be read as 10 lakhs instead of rupees 1 lakh.
This is paragraph 22, subpara 16.
Consider the submission made by the counsel for the petition for use the record in the order dated 12 September 2025, page number 8, X16, last paragraph 8 within page 8, paragraph X16. The amount shall be read as 10 lakh instead of rupees 1 lakh. This order may be incorporated with the judgment dated 12 September 2025.
Yes. I'm grateful, my lord.
Call the special effects.
Well, I'm paying for short passover. Mr. Banerjee is there, just another he's on legs. Since matter is running, my lord, he just asked me. I just complete and come back, and in the meantime, matter finished. Hello, short passover, my lord, for 5 to 10 minutes.
Short password Short password. In the meantime, my matter may be taken. In the minute, short. When he will come?
5 to 10 minutes. Get
My hope is that, my lord, recalling application made by them, my lord. My lord had passed an order. Let the petitioner. Very well, my lord. Let them.
Thank you, Lordship. Your Lordship, I appear on behalf of the judgment debtor. This is my recalling application for recalling Your Lordship's order dated 27th October 2025. Your Lordship's assets of third parties have been attached here, and I have placed before you the conveyance deed and the recent tax assessment. Your Lordship,
7th October.
27th October 20.
Page.
20.
ঠিক আছে, দাঁড়ান। That matter, my lord.
Yes.
Your Lordship, if it kindly comes to page 24, my annexure C, these are the recent tax assessments. It clearly shows that the owners of the property are third parties, but not the judgment debtors over here. Naming one Sajjan Bachawat and Srimati Jatan Devi Bachawat. Subsequently, in the conveyance deed at page 26, Your Lordship, the purchaser clearly mentions Sajjan Bachawat, and these conveyance deeds are dated 19 September 2009. And and page 51, it shows the name of the other purchaser.
Yes.
So these properties have been attached. These do not belong to anyone in the cause list. So, Your Lordship.
My order is attachment. Where is the attachment order?
Your Lordship, 27th October.
Page 20, my lord.
Page 20.
Yes.
But both parties were represented. कोई submission is नहीं किया. Now executing court is different.
Prayer A to G. Where is the prayer A to G? Have you
Your Lordship kindly allows my senior to take.
My lord, kindly take the execution application once, my lord.
Correct. Where is the execution application?
It's not there on record.
My lord, I have some aspect of maintainability which should be subject to Lordship's permission pleaded first. What they have made is a recalling application. My lord, they have obtained, they had every score and avenue for making submission. They have made their submission to the square. None of the single submission Lordship will find, Lordship has recorded, my lord, that was made to that effect. My lord has recorded both party submission in my lord's usual manner, my lord. And thereafter, my lord, when my lord had been pleased to pass the order in open court, then my lord is supposed to sign. On a 27th October, Monday, the order was passed. On Wednesday, the 29th, they had come. Now everything is very convenient, my lords, everything is remaining in virtual platform. Lordship can see. 29th, they had come and said they had missed some judgment to cite. Lordship can, my lord. Then immediately thereafter on Friday, the next day after, the bench was changed. Then, my lord, Honorable Justice Aniruddha Rai presided over that bench. The order is at page 66, annex day. See, my lord, what was the submission of the judgment debtor before the executing court?
Kindly allows me to place my application. I've not been able
But
to.
I want a maintainability.
Yes, my lord.
It should be.
I'll satisfy on the maintainability as well, my lord. Yes, my lord. Yes, my lord.
Yes, my lord. Page 66. But kindly see what before Aniruddha Rai, Honorable Justice Aniruddha Rai, they made submission. Mr. Subanso, 67, my lord. Mr. Subanso, Learned Counsel.
Yes.
Mr. Subanso, the Learned Counsel appearing for the judgment debtor submits that there was no urgency in the eye of law
for obtaining leave to move the execution application without the drawing up of the decree. Their categoric submission that without drawing up of the decree, we have come. And my lord, every day the judgment debtor, their very tendency, my lord, is apparent. Every day the judgment debtor is having a different alibi to do a dilly-dallying and to escape the effect of the judgment. My lord, kindly see. Bolo. And whereas, my lord, and they said, my lord, that they do not have any asset. And before the learned honorable court, my lord, they have made a categoric submission that there was no urgency in the eye of law. We have, without, my lord, we have made the application without leave, having the leave. Whereas, in fact, we have made, we have taken the lordship's leave, and thereafter we have made the application to file the, because in view of the cropped up urgency, to file the execution application without the certified copy. My lord, is to grant the leave. On that basis, first we have applied for the certified copy in the department. Thereafter, we have plattered before your lordship the application. And my lord, the apprehension was quite correct. Why they are trying to very much insist on this application, besides being a judgment debtor? In the meantime, as I have been informed, my lord, they have perhaps, my lord, drawn up, my lord, they have channeled out some fund from their bank account. Now, the, my lord, to bypass or escape the effect of it, either by contempt or otherwise, my lord, they are very strenuously insisting on this application. My lord, my third point, my lord, as on today, my lord, are they remediless? They have already an avenue open before the appropriate court. Are they remediless?
Okay, that's all.
It was not an, my lord, only one other point, my lord. Fourth point, my lord, it is a recalling application. And it is not an ex parte order. My lord, after hearing both the sides, my lord had been pleased to pass an order. Initially, they were saying, my lord, that my lord shouldn't sign the judgment. Whereas in open court, my lord had been pleased to pass the order. And within a gap thereafter of 10 days, my lord, lordship had waited.
My lord, if a division bench is passed an order, if division bench is passed an order, and it is to go to the SLP, but you know the SLP, it is not possible within 30 days or 60 days. What you are doing? What you are doing? You're doing a review application and the club the order and to go. That is they are doing.
Here, my lord, they have the appeal bench available.
Okay, that's all.
Appeal against.
This is a recalling application. This is not a review.
Correct, yes.
Yes, my lord. My lord,
have sustained.
My lord, this is a recalling application. The scope is quite limited. I have to show that there were facts which were suppressed before, my lord, and I need to bring those facts on record. I want to show, my lord. Kindly comes to page number 28 once. That's a deed of conveyance, my lord. Page 28 and page 51. These are deeds of conveyance, my lord. Yes, my lord. These are deeds of conveyance, my lord. By virtue of these deeds of conveyance, my lord, these two properties, the properties which have been attached today, these properties were sold off to the third parties. Now, my lord, just because a decree has been passed against the defendant, does it mean that someone else's properties can be attached, my lord? That fact has been suppressed, my lord. And by suppressing that fact, my lord, the order was obtained, my lord. So I am on that point, my lord. So far as
but the problem is that on
yes, my lord.
27th of October 2025.
Yes, my lord. But yes, my lord. Yes, my lord. My lord, fraud vitiates all, my lord. This fact was suppressed, my lord, and I brought on record proper documents to show that this was suppressed, my lord. So far as that issue is concerned, so far as that statement of my lords is concerned, as to attachment, that can be withdrawn, my lord, recalled, my lord.
What order is passed?
My lord, kindly comes to the order once, my lord.
What order is passed? Can
yes,
you
my
come
lord.
to the order?
Page, my lord, 20.
Page 20.
Of my application, my lord.
Correct.
27th October 2025, my lord.
Correct.
My lord,
considering the above, this decree holder has made our family accordingly.
Yes, my lord.
Statement.
Yes, my lord.
This is an interim order.
Yes.
This is
But
interim
my lord,
sanction, not attachment.
my lord,
Can you
A
see
is
prayer ABC. What is the prayer ABC?
A, C, and G, my lord. There was attachment order, my lord, against the other.
The ABC, A, C, and G.
A, my lord, an order restraining the judgment debtor from operating any of its all bank accounts linked with the permanent account PAN number so and so, or any in the name of the judgment debtor from withdrawing any sum lying therein without keeping apart a sum of rupees, the decretal sum, my lord.
Then, my lord, B, my lord, an order of attachment of all bank accounts of the judgment debtor linked with the permanent account number so and so, or any in the name of the judgment debtor.
Correct.
C, my lord, an order directing the
No, A, C, and G.
A, C, and G. An order directing any responsible officers of the judgment debtor to make true and proper disclose of all assets and properties, including movable and immovable
That will be done in course of the
immovable
execution
assets of
application.
the judgment debtor by way of any affidavit form 16A. That has not been done. And G is there. They say, my lord, suppression. My suppression is something else. The element of suppression is
The
completely
schedule
else.
of assets, my lord, the schedule of assets.
Something if
lists
I have
two
missed.
properties. Yes, my lord.
This court, they have made so many prayers.
And G is
As
the
per-
injunction.
Correct.
Yes, my
A, B,
lord.
A to G.
Yes, my
They
lord.
have made altogether I, L,
Yes, my lord.
M.
Yes, my lord.
Together M. Correct. This court has passed an order with regard to the A, C, and G.
Yes, my
A
lord.
is with
My
regard
lord, that even covers the schedule
No.
properties as well, my lord.
Kindly read.
Yes,
A,
my lord.
an order restraining
what?
the judgment debtor. Restraining the judgment. You are not the judgment debtor. You are the judgment debtor.
I'm the judgment debtor, my lord.
Correct.
Yes, the properties do not belong to me, my lord.
Correct.
Yes, my lord.
Judgment
Yes, my lord.
debtor from operating any its bank account.
Yes, my
So
lord.
your bank account has been stopped with its permanent account number or any of the total name of the judgment debtor. So this is with regard to the you only.
Yes,
not,
my lord.
Not the third party.
Yes, my lord.
Now kindly come to the C.
Yes, my lord.
An order directing the respondent so and so to make it true and proper disclose. That is also you have
Yes,
to
my lord.
disclose.
Yes, my lord.
Correct. Now G. An order of injunction restraining award debtor or its man, agent, servants dealing with the encumbering and alienating the creating any third party interest over the respect of the mobile and immovable properties.
Yes, my lord. I'm on this.
Properties of the award debtor as more specifically particularly mentioned in Schedule A.
Yes, my lord.
Schedule A.
Kindly show. Yes, my lord.
Schedule A
Schedule A has two properties here, immovable properties. my lord. Flats 404.
There, my lord. Just
Immediately thereafter, after the
and most
after the
interesting
prayer, my
part,
lord.
page 14, my lord.
These two flats, I'm concerned with these two flats.
My lord,
These
the
do not
original,
belong to
it
the
is
judgment
not the
debtor, my lord.
case that the original owner is not before your lordship. They have their pen. It is only to, my lord, escape or jettison the
No, my
execution.
lord, not escaping.
On
Doesn't
one
mean,
hand,
doesn't
Honorable
mean, my lord,
Supreme-
that someone else's property will get attached, my lord. No, my
How
lord, it
is
doesn't
it
mean.
done? On one hand, Honorable Supreme Court says within 6 months the execution must be harbored. And on the other hand,
So
they are
through someone
jettisoning-
else's property, my
they
lord.
are jettisoning-
Very schedule of property.
schedule to that. Page 14, my lord. Joseph Pachen na bhai, dao na.
My lord, prima facie, my lord, these two properties do not belong to me.
Let
Yes.
me the court
Schedule, yes,
understand whether
yes.
G property with the which
Yes,
you have
my lord,
mentioned
yes,
with
my lord.
regard to deed
Yes,
is
my
there
lord. Yes, my
or
lord.
not.
Yes, my lord. Kindly, my lord.
Kindly see, my lord. Whatever the detail we had, that we have given. No, even if it is not,
Schedule of property A, flat
Yes,
number
my lord.
404 and 405.
Yes,
kindly see, there is no block mentioned.
So 405, 40.
Yes, my lord. Now,
404 or 405 is the outside the
yes, my lord. Now, kindly seize page number 33, my lord.
23.
33, my lord.
33.
That's the first deed of conveyance that I've annexed, my lord. The
33,
second schedule referred to there too.
33.
We are
Yes.
going on merits.
34, my lord. Second schedule, my lord. Flat 504. That was conveyed to. Who was it conveyed
In block 4, my lord, that is not.
to? Sajan Bachawat, my lord. And then, my lord, this is regarding flat 504, my lord. Then kindly comes to, my lord, page 55, my lord.
Sajjan Bachawat
55, my lord.
Judge Sahab ko
That's flat 404, my lord. So I'm concerned with these two properties. Those do not belong to the judgment debtor, my lord. And yet, that order was passed, my lord. This fact was suppressed, my lord.
55. Yes. 55.
Yes, my lord. 55. Second schedule, my lord. Flat number 404, my lord.
Correct.
Bol bota raha hu, bhai.
Now the details. in
Actual
schedule-
suppression,
the
I will
details-
portray, my lord.
The details in schedule A, my lord.
But
The
kindly
details in schedule A, my lord. It's regarding flat number 504 and 404. So the only by reason of the fact that the
So from whom you have purchased?
my lord,
From
actual
one,
suppression, I will portray. Page 28.
From one Ashok Kumar Roy, my lord, and Ganga Prasad Roy.
Ashok Kumar Roy has sold the property to the Jatan Devi Bachawat.
Yes, my lord.
Correct.
Other people,
Other people.
not the judgment debtor.
Who are you?
Yes.
For the judgment debtor.
What is your name?
Sajjan Bachawat, wife of page 28, wife of Rabindra
Amit
Bachawat.
Vanijya Private Limited is the company. Amit Vanijya Private Limited is the company.
Amit Vanijya Private Limited company.
Yes, my lord.
So how you connected with this?
Yes.
How you connected with this?
That's my concern, my lord. How am I connected with these two properties, my lord? Now the decree holders or the decree holders have gone against those two properties. Those do not belong to me. Attach those properties belonging to third parties, my lord. How could that have been done? Even if those issues.
How these two properties?
Kindly come to page 28 once.
20?
28.
But my lord,
See, my lord, where is the page? Prima facie. I am telling my lord.
There is an
Who has made the suppression?
erroneous finding, my lord.
We
of
should
this
not
court,
take
my
the
lord.
court lightly.
Yes,
Every
My lord,
time.
not taking the court lightly at all, my lord.
Sajjan Devi Bachawat, wife of Sri Rajendra
My lord.
Bachawat. My lord,
Yes,
who
my
is-
lord.
my lord, let's see.
My lord,
Who
these
is
were-
Rajendra
my lord.
Bachawat?
Yes, my lord.
Rajendra
Yes, my
Bachawat
lord. Yes,
is
my
the
lord.
director of the judgment debtor.
So
That
by
part
virtue of the
very
fact that I am
meticulously suppressed.
just that's not been suppressed, my lord.
Oh,
There is a-
exactly. I have
there
suppressed.
was-
They have not suppressed
there-
anything.
There was an expunging application, my lord, that was allowed in my
Oh,
favor, my lord.
excellent.
Yes, my lord. Though the directors are not a
Excellent.
party to this
Yes.
execution proceeding or the suit proceeding, my lord.
The
That was
Rabindra
allowed in my
Bachawat
that was allowed in
is
my
the
favor, my lord.
director of the judgment debtor,
Because of the fact,
meticulously
just
suppressed,
because of the fact that
and
I am a
boldly made submission before the court, and in the answer that we have suppressed before your lordship.
I have not never said that.
There's a
What is-
proverb in Hindi, my lord, if I'm allowed to say, ulta chor kotwal ko date.
No. So is Ravindra Bachawat.
Yes.
Yes.
Ravindra Bachawat is?
Is the erstwhile, he is the director of the judgment debtor.
My lord, kindly seize the judgment and degree once, my lord. Judgment and order once, my lord.
Now again
Yes,
another
my lord.
station.
No, not out of place at all, my lord.
It is a recalling application.
Yes, my lord.
They were present when
because
they are
because
in their
these facts,
presence.
these facts, no, my
Yes.
lord.
So how you can say this Sajjan Bachawat, Ravindra Bachawat is the director where
Man,
My lord, yes, my lord. These
man,
they were directors,
here
my
and
lord.
now I am showing. Let
Direct-
them say once that she is
My
not the
lord, kindly-
director because he is for the
No,
company. Let them say.
I'm not. My lord,
Let them say
my
once.
lord kindly comes to the order once.
When
the
the
judgment
submission
and
is
order
made,
once.
full-fledged.
Yes, my lord, kindly comes to the judgment and order once. The September 4th, 2025 order. That's at page number 13, my lord. An expunging application was so the suit initially was filed against three parties: the company, Amit Vanijya, the directors of the company. Now, the company came up with this expunging application, my lord. The defendants number 2 and 3, their names were expunged from the array of parties, my lord. Kindly comes to page number 14 once, my lord. Department is directed to delete the names of the defendant numbers 2 and 3 from the cause title of the suit
And
within a period of 1 week from date, my lord.
who are the defendant number 2 and 3?
The directors, my lord. The directors.
Who? What are the names?
नाम बताओ.
हाँ, 52 की है.
Directors का नाम बताओ.
See, my lord, page 52, the list. And this Sajjan Bachawat had 1,50,000 shares in the company. All these, if I'm allowed to say, suppressed. Page 52, my lord.
Page 52.
My lord has held that just by reason of the fact that we are directors. Yes, my lord.
I remember.
Yes, my lord.
Who are the defendant number 2 and 3 in the
My lord, the names will be
Who are
available.
the defendant number 2 and 3 in the
Yes.
plane?
Deven, Jot sahib ke to den. Madam, I'm handing over that page. Din. My lord, left-hand side, my lord.
There's no issue about the fact that they were directors, my
this-
lord. They are directors, my
Yes,
lord.
and they are
There is-
shareholders. Even that Sajjan Bachawat is shareholder.
No, defendant number 2 and 3 have been they are the partners, directors.
Yes, my lord.
And there was a submission that they filed an application for deletion of the name. So the name has been deleted. If the name has been deleted, how the directors can be able?
Yes, my lord. That was allowed, and that has not been appealed against, my lord.
My lord, was all this submission made when the order was passed? Was all this submission was based when the order was passed?
Correct. That's why.
Be that as it may, that is why my recalling application
That's why
has been
But
brought.
that is not the way the recalling application. Anyone that whenever any submission is missed, will file a recalling. And kindly see what was their ground.
My lord.
What was their ground and in what ground they are making this recalling application.
My lord,
But
my
anyone
ground
will,
of-
This recalling application, my lord, suppose is allowed, my lord, everyone will make a
My lord,
T9 for
understood my
whatever
mind,
the
my lord.
grounds they have.
Kindly,
They have made their submission squarely. The order is passed. They have other forum available, and that is very within the vicinity of this building.
my lord has passed that order. It was
But
passed
otherwise,
under a
everyone will
suppression
take
of
the
facts,
chance.
my lord. I've brought-
Everyone will take the
I've-
chance of
I've
availing
brought-
this code, my
brought
lord.
the facts before my lord decides.
They have made their entire submission on that basis. The order was passed.
How the
Yes, my lord.
total order can be recalled?
Not the total order, to that extent only, my lord.
No, can you see the prayer? See the prayer, Master Saman. Can you see the prayer that you caption proceeding so and so be recalled?
My lord, in recalling application, my lord has inherent powers, my lord. To what?
Application, it is not a power.
Yes, my lord, inherent power, my lord. I'll show the relevant judgment, my lord. Budhiya Swan squarely talks on that point, my lord. The scope of review of my lord's order is limited to when, let's say, there's a suppression of fact or fraud on the part of any of the parties and order has been obtained, my lord.
No.
You do one thing.
Yes, my lord.
You bring the plaint and the order plaint original copy of the plaint and the order wherein this court has passed an order for deletion of the that is already
Here and now,
my lord.
You
Man,
the
no order.
That is already on record, my lord.
You the plaint.
Annexure, page 13, my lord.
You the plaint.
Page 13, my lord. That application was allowed, my lord. Page 13 and 14, my lord.
Bachawat was not even made the party. Where is the question of deletion comes? I have given the copy of the plaint.
Two other directors.
Every time, my lord.
Exactly,
the
my
court
lord.
is being
My
played.
lord, my lord. No, my lord. The director's properties have been
Who is
attached, my
Rajendra
lord.
Bachawat? Not told. We have brought into light. Who is this Sajjan Devi Bachawat? Not told. A shareholder. Not brought into light.
And their properties will be attached. Their properties will be attached in a decree against the.
Let us not shout.
Yes, my lord. I'm
Yes.
just trying to place my case as well.
Then, my lord,
Seems like
the name of Rajendra Bachawat is deleted, my lord. Where is his name in the plaint? Where is the question of deletion comes? If this is an approach before the honorable
my
court,
lord,
one at least should come with clean hands.
my lord, there were
What
two
else I
directors.
should say?
My lord, there were two directors.
They are not the party. They are not
Yes,
dependent
yes,
on
kindly allows me 2 minutes, my lord. The people who were directors, they had filed an expunging application.
They have been deleted.
Done. Now, after that, no further directors of the company were added as parties to this particular suit, my lord. Now, the decree has been passed against whom? Against the judgment debtor, the company, my lord. Now, any attachment or order cannot be passed against any property that the judgment debtor is not an owner of. Right, my lord. So that's why, my lord, that's my limited submission, my lord. So far as the order, insofar as the order passes, directs an attachment order, my lord, in respect of those two properties, my lord, flats, my lord, those do not belong to the company, my lord. That order may be recalled, my lord.
My lord, where is the original? Where is the original owner as on date before this court?
That is something that will be placed during that will be placed during the execution
Every time, my lord.
proceeding, my lord.
Someone by
I am on a
filing
very
review,
limited point, my lord.
someone filing a
Yes, my lord. I'm on a
recalling
very
by
limited.
way of a clever drafting.
The
Order is already passed.
judgment debtor has filed the present application being GA Com 1 of 2025, praying for an order and praying for recalling of the order dated 27th of October 2025. Passed in ECCOM 537 of 2025. Counsel for the judgment debtor submit that this court by an order dated 27th of October 2025 has passed an order directing passed an order in terms of prayer A, small a in bracket, comma, small c and small g of the tabular statement, which affects tabular statement, but the said property does not belong to the judgment debtor. Full stop. The learned counsel appearing for the judgment debtor has drawn the attention of this court to the conveyance deed dated 19th September 2009 2009,
Date bolo, date bolo.
2009 entered between Sri Ashok Kumar Roy
Help the judge with the dates. ठीक है?
and Sri Ganga Prasad Roy
And no such
as owner
prayer made before
of
the
the first
executing court
party,
also.
and Sri Sajjan Bachawat, Srimati Sajjan Bachawat, wife of Sri Ravindra Bachawat, being the purchasers, and another conveyance deed dated
Date bolo.
19.
Bolo, bolo.
No, it was same dated.
conveyance deed dated 19 September 2009, executed between Ashok Kumar Roy and Ganga Prasad being the owner, and Jatan Devi Bachawat as purchaser. The judgment debtor submits that in deed of Sajjan Bachawat consist of flat number 504 in block number 4.
Yes.
4, which is the Schedule A property, Schedule 1 property. Schedule 1, na?
Schedule A, my lord. Schedule A, my lord.
In the order.
Order,
In the Schedule A property. Schedule A property of the execution proceeding, and survey number and the flat number 504 and flat number 404 in block number 4 are the property of Schedule 1 of the execution proceeding. Police. She submit that the petitioner decree holder has suppressed the fact and obtained an order from this court for attachment of the said property, though the property does not belong to the decree holder. And as such, the petitioner prays for recalling of the order dated
judgment data, my lord.
Petitioner বলেছেন, ঠিকই বলেছেন জজ সাহেব, is your application.
বলছে
Learned
property does
counsel
not belong to
appearing
the
for
decree
the
holder বলে।
degree holder
Petitioner
submit
is
that
not file the
the order
recalling
is passed in presence of the learned advocate appearing for the judgment debtor. At the time of passing the order, it submit that the order was passed in the open court, dictated in the open court, but learned counsel for the judgment debtor has not made any submissions that the Schedule 1 property of the execution proceeding is not of the decree judgment debtor. Now, after passing of the order, the judgment debtor has come with the present application and only to drag the execution proceeding. Yes, any further?
Yes, my lord, and these two, my lord, these persons, my lord, they have talked about, my lord, they are, my lord, they were the directors and their shareholder. As I showed.
He submit that the purchasers
And that they have suppressed.
Purchaser of flat number 504 and 404 were the directors of the company, dependent company, and having a good number of shares in the defendant number company.
Around 150,000 shares.
Good number of shares in the defendant number company, and as such,
and this was not brought to the
has made the property of Sri Sajjan
Rajendra Kumar Saroge.
Sri made the property being Schedule 1 and make flat number 504 and 404 at Schedule 1 property of the execution proceeding.
And my lord, in that, my lord, schedule given, my lord, the block 4 is not there. The detail we have
If
given.
further submit that
Yeah, they are
504
showing
and 404 is of the block number 4, but in the Schedule 1 of the execution proceeding, the decree holder is not claiming the 504 and 404 which is in the block number 4.
And even today, the original owners are not before this court.
If
What
further
they are
submit
saying.
that, if further submit that as per the conveyance date which the judgment debtor is relied upon, the Sajjan Bachawat and Jatan Devi Bachawat are the owner of the property in question, but they have not come before this court for recalling of the order. Wherein the judgment debtor has come before this court though he has no right to file any application for recalling of the order, as this order was passed in his presence and at the time of passing of the order, no submission has been made with regard to the said property. At the learned counsel for the respective parties peruse the application and the document. This could find that where is the schedule? That
Schedule A.
prayer A, C, and G of the prayer A, C, and G of the tabular statement are as follows. A, C, and G. This one A, C, and G. Page number 19. A, C, and full stop. And must say the prayer C, prayer A of the execution proceeding is upon the judgment debtor for restraining the judgment debtor for operating the bank account linked with the permanent account number AACC capital A 1197M, and the prayer C is an order directing the judgment debtor from disposing of any of the property of the judgment debtor. Thus, prayer A and C cannot be said that the cannot be said that the same will be a part of the cannot be said that the same will affect the judgment debtor. As regard prayer G is of the schedule of property is regard to the flat number 504 and 506, 504 and 404 being schedule A property of the execution proceeding. This court find that the convenience deed which the judgment debtor is relying upon, the property is in the name of Sajjan Bachawat, wife of Rabindra Bachawat. And survey number flat number 404 is recorded in the name of Jatan Devi Bachawat, wife of late Chain Roop Bachawat. Chain Roop Bachawat, CHAIN, Chain Roop Bachawat. And none of the party has come forward before this court for recalling of the order, as due to the order passed by this court, the said parties are affected. The judgment debtor has filed the present application on the ground that by an order dated page 20, by an order dated 4th September 2025, the dependent number 2 and dependent number 3, who are the directors of the dependent number 1 company, name has been deleted. But the said two persons were not the directors of the company when the court has passed an order on 4th of September 2025. They are the directors. But 2 and 3. The 2 and 3, but that's why 2 and 3. Full stop. Considering the above, this court did not find any merit in the present application. Accordingly, when there is no dispute that they are not the director, application is dismissed. Next.
My learned friend is here. Will it be my lord's pleasure to take it today or fix some other day?
How much time will it take? This is not good. Otherwise, I will close your argument. Once the court was taking the matter, you left the courtroom.
Lordship, I was here at court 33.
The court is also, this is also a court. If you say this is not a court, then I will release the matter, passing a decree in favor of the plaintiff.
I tender my apology, my lord, kindly.
You know the matter is fixed at 3 p.m.
I was here, Lordship.
And you left the court when the matter is called. This is not, it is nothing, it is only intentionally.
No, Lordship, I will then not take any time. I will file my written notes of argument. I will not take it. This is not my intention, Lordship. Kindly appreciate, Lordship. I have never done this in my life.
So you were here when the matter is called. You left the courtroom by opening the door.
No, Lordship. I was here, Lordship. I thought that other matter was going on. I thought that I can do that and come back in.
You could have been taken the leave from the court.
I mean,
matter is fixed, especially fixed. When senior person is waiting here,
I found senior advocate was saying, so I did not.
Or you
interject.
could have been informed the senior you're leaving the court.
I'm extremely sorry. My
How
lord,
much time you will take?
give me 5 minutes time, Lordship. I will complete it today itself, Lordship.
Today I have no time.
5 minutes. Any day, Lordship, and then there are by another 5-10 minutes time only.
But this side of the vacation, if it is possible, since it wants 5-10 minutes, if it is possible, I'll give it.
At good
No
time.
pressure.
I am at fault, Lordship, whatever Lordship is.
And my lord, let him come with his written notes of arguments that day, so that we close the chapter there and then.
वो तो जमा हो गया ना.
দু তারিখ কারোর কোনো কাজ থাকবে না করে নি স্যার
Because we have filed our notes. Let him
My
file
lord,
his notes on
second we all will have little less burden. 2nd of January, Lordship, can we fix it on 2nd of January?
कब है वो कब है?
Maximum कोट हल्का था
the next week, my lord, the week beginning Monday.
Come tomorrow at 4 p.m.
Yes.
Item number 3. Let the matter appear tomorrow at 3 p.m. 4 p.m.
I'm not, Lordship, it was not, Lordship, it was not intentional.
Item number 7, let both of us have agreed.
Yeah.
Kindly keep it after the
After vacation.
Item number
7th. And all of us have agreed. The defeat number 1 and 2.
We have all agreed, we'll have to pardon the
Yes, absolutely, absolutely.
For what?
Kindly keep it after vacation.
For what?
Anything will have.
7. As per the prayer made by the
Yes.
for the parties.
A specific date may be given, my lord.
Matter appear. हम लोग कब लेता? Original.
The interim order that they are enjoying is
Because the 15th is the
Yes.
that is expected.
yes
Around 15th.
on 15th. Yes,
Okay.
obliged. Thank you.